Court officer, may I please,
Hello?
court officer, please.
Sir, is it audible?
Court officer, speaking from the court, sir.
No, sir, just a minute. Court officer ma'am is coming.
So, is there any court officer, please?
Okay, sir.
Sir, is
No.
there any court officer, please? I just wanted, please.
No. Court officer, please.
check ತರಬೇಕಿತ್ತಲ್ಲ ಮಾಡಬೇಕಿತ್ತಲ್ಲ son. This is a company which gets the staff and the officers on deputation basis from different departments. Controlling officer appointing
ಸರ್ ಹತ್ರ ಒಂದು ನಿಮಿಷ ಮಾತಾಡಿ.
Court officer, can you hear me, please? Court officer? Court officer? Can anyone hear me, please?
Yes,
Yes.
sir, I can.
You're audible.
Okay.
You're audible, sir.
Okay.
You're
We are
audible.
audible, but court officer is not audible.
Yes.
He is not available.
No, he's available. I see his link is open, but it's muted.
No, the
I think
proceedings
proceeding hasn't started yet, sir.
no, the proceedings are underway. I understand. There's a separate. The YouTube live can be seen that His Lordship is already holding court.
What?
Okay. Okay, all right. Thank you so much.
If he's already holding court, the
We can't hear.
will be called.
Nobody can hear.
We have a Zoom link, whereas the Dharwad bench has a V-Consul link. I think advocates there are appearing through V-Consul.
Oh, we need to connect through
Oh,
vConsole?
no, I'm not sure. That is why even I'm a little confused because from what I understand, if somebody can also verify it again on YouTube, His Lordship is actually holding court.
How do you check it on YouTube, please?
You-
I'm calling from Delhi. That's the problem.
No, sir, I understand. I'm equally a little concerned because So you can just find it on YouTube, Court Hall 6, Dharwad Bench, Karnataka High Court.
Court Hall 6,
Dharwad
Hall,
Bench, Karnataka.
Dharwad Bench. Bench, Karnataka?
High Court.
High Court, Karnataka.
YouTube alone.
But we will get a chance on our ID or not? That's my concern. Hello? Can anybody hear me, please, ma'am?
Sir, I can hear you. I just checked. The proceeding is going on. It's live on YouTube. I'm not really sure which list they're taking because I cannot make submissions there. But yeah, it is going on. Court proceedings are going on this.
Okay. Thank you, sir.
No, when they take up this Bangalore list, we will get the access to all those.
Okay. I think
Once
that's
they finish up the
No, we are all
then
kept
they
on
will take the
standby
Bangalore list.
issue.
Announcement going on.
In this case, that is a banker check.
Here in the
After
Zoom
the
itself, sir.
Dharwad list,
3 months.
Bangalore list will be accommodated and access will be given.
3 months, they issued notice. Subsequently, they
option buying is the fastest way to lose money in the
Come there, we'll go to the chamber. Come. I have my file there. Come. There. Oh. Like start
Submission, unable to hear the code, please, Manoj.
The court is not audible, my lord.
About the 5-page note has been prepared.
ಬಂದಿರೋದೆಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
But the facts really, my lords, are not in dispute. But it is alleged, my lords, that on 19/12/2024,
Lord,
when
may I
the-
make a submission, Lord?
No, 1 minute. Let him finish, sir.
No, Lord, the respondent is served. So it appears.
I appear for respondent number 2, my lord. I have filed wakalat yesterday only.
All right. Yes. Who has filed wakalat?
Shivshankar Patil.
All right. Yes. You're ready?
I will.
We will file objection, my lord, next
You
date.
want to, you want
A
to file
short-
objections?
Yes, my
A
lord.
short date, my Lord.
No, not the point is this one. But ultimately, lordships are requested to decide on the question as to whether the CIM, the jurisdictional police, could have registered the first information report having regard to the provision of Article 194, subclause 2. It is pure question of law. But if on an interpretation, if lordships find that they could have registered, then the petition requires to be dismissed. On the other hand, if lordships comes to the conclusion that there is a bar as it contains and as held by the Honorable Supreme Court on a true interpretation, that will be the question. Yes. But these written submissions which now we have placed before your lordship, I'll briefly call out about 3 or 4 factual aspects for lordships to appreciate the questions of law. 19/12/2024 is the alleged incident. It is not there are 3
Facts I am aware.
one the other sentences only I'll say. 19/12/2024, the petitioner before your lordships is a member of the Legislative Council. The House was in session. There was some altercation within the well of the House. It is at that point of time, the allegation is that the petitioner has uttered a word which, according to the respondent number 2, constitutes outraging the modesty. That is the word which has been. But
Yes.
it is also of some relevance for lordships to kindly note that on the very same day, the respondent number 2 also made a complaint before the Honorable Chairman of the Karnataka Legislative Council in respect of the same incident. The Honorable Chairman of the Karnataka Legislative Council, my lords, is said to have given a ruling on that complaint after hearing me. It is thereafter, my lords, a complaint, first information is lodged before the jurisdictional police, and this section 77 and 78 is, my lords, registered. This petition, my lords, primarily is on the ground that registration of the first information report is barred under Article 194, subclause 2 of the Constitution. Therefore, if lordships, I'll just briefly take lordships to what are the lords heads on which this argument is built up, and then elaborate if possible.
Yes, sir.
Internal page 3, if lordships are given. Internal page 2. ಫಸ್ಟ್ ಕ್ವೆಶನ್
ಎಸ್
ಈಗ ನಮ್ಮ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಒಂದ್ಸರಿ
submission.
ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಅಂದ್ರೆ ರಿಟರ್ನ್ ನೋಟ್ ಅಂತ ಮಾಡಿದ್ವಿ.
ಆಯ್ತು.
ಪೇಜ್ 2 ಅಲ್ಲಿ
ಹ್ಮ್.
left hand side para 5 notes. These are the questions more according to us would arise for lordship's kind consideration.
All right.
Number 1,
Hmm.
whether the protection given to a member of the legislative council
Hmm.
from any proceedings in the court of law as contained in Article 194(2) of the Constitution of India is a qualified protection.
Hmm.
But the second question is what will be the true and scope of jurisdiction? I will not request lordships to kindly consider it later on, but kindly see third one. Whether the registration of the first information report by the jurisdictional police in respect of the words spoken by the petitioner inside the house would be barred having regard to the constitutional injunction as under Article 142 of the Constitution of India. But these will be the two broad questions, ultimately. The reason why we have raised these questions is at the time when the matter was presented before your lordships initially, two aspects came into force. First, number one is whether anything said when the house is really not in session, that was how the learned SPP had argued, whether a protection can be extended under Article 194(2). Secondly, lordships did observe and some discussion took place. What happens if a derogatory word or a word which constitutes an offense under the criminal procedure, IPC is committed? Will the protection also continue to 194(2)? That's the two questions. Now, lordships may kindly see Article 190.
Hmm. Yes.
Lords, 194(1) lordships may kindly permit me to read.
Hmm.
Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. But this is very interesting. The Honorable Supreme Court says the importance of this. There is already a freedom of speech as available under Article 19. There is restriction under Article 19(2), the reasonable restriction. What the Honorable Supreme Court interprets 194(1) to say is, this freedom of speech given under 194
Has no restriction.
there cannot be having any restriction except the rules and standing orders regulating the procedure of the legislature. Therefore, they make it an in-house procedure. State executive comes out of the session of 194(1). That is the importance I wanted to place. Now, 2 is what we really rely upon.
Hmm.
No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him. We are not really concerned with that. By him in the legislature or any committee thereof. And no person shall be liable in respect of the publication by or under the authority of a house of such legislature of any report, paper, votes or proceedings. But a true and correct interpretation of Article 194(2), as I have understood, is that for anything said in the legislature, you cannot be subjected to any civil or criminal court, any court for that. It is 194(3), my lords, which relates to privileges and immunities, powers of the legislatures, which, my lord, I am really not, do not think, my lord, we would be advancing any argument based on 194(3). But if lordships feel it necessary, I'll read that as well. In other respects, the powers, privileges and immunities of a house of the legislature of state and of the members and the committees of the house of such legislature shall be as such as may from time to time be defined by the legislature by law, and until so defined shall be those of the house and its members and committees immediately before the coming into force of Section 26 of the Constitution, so and so. The provisions of clause 1, 2 and 3 shall apply in relation to persons who by virtue of this Constitution have a right to speak in and otherwise take part in the proceedings of a house of the legislature of a state or any committee thereof, as they apply in relation to the members of the legislature. The 194 is really meant for Advocate General who can, though not being a member of the legislature, can still address the house as well. That is the extra precaution the Constitution has taken insofar 194(4) is concerned. But what, which therefore we have used the word, there is a constitutional injunction. not to proceed against any member of the legislature in any court of law for anything said to him. Now, these two questions, Lord, which has been raised, Lord, according to us, have been dealt by the Honorable Supreme Court. Therefore, Lord, I'll straight away take lordships to both the questions. Internal page 3. Copy. Lord, according to us, absolute immunity granted to legislatures, irrespective of whether the House is in third page. Sorry, sir, written submission. I'm sorry. Whether that session whether session is, for instance, in this case, they say he had adjourned the House and chairman had left the chair. That is one of the arguments which has been advanced, which according to me, Lords, cannot be really gone into, but that also has been considered in Sita Soren. May I read it?
Yes.
Lordship, in order to make it easy, Lord, we have extracted the relevant portions in that written submissions itself.
All right.
So that Lordships find it easy, Lord. Internal page 3, paragraph 9.
Yes, sir.
The Honorable Supreme Court, in the case of Sita Soren versus Union of India, expanded the proposition about the conscious use of the term legislature instead of the House of the legislature in the text of the provision. Distinct from the marginal note in the text of the provision, there is a conscious use of the term legislature instead of the House of legislature at appropriate places. It is evident from the drafting of the provision that the two terms have not been used interchangeably. The first limb of Article 194(2) pertains to anything said or any vote given by him in the legislature or any committee thereof. However, in the second limb, the phrase used is in respect of the publication by or under the authority of a house, such a legislature of any report, paper, votes, or proceedings. There is a clear departure from the term legislature, which is used in the first limb, to use the term house of such a legislature in the second limb of the provision. It is clear, therefore, that the provision creates a distinction between the legislature as a whole in the first limb, that is right to vote, and the house of the same legislature in the second. Second limb is more publication made. As correctly submitted by so-and-so, senior counsel for the appellant, the terms house of legislature and legislatures have different connotations. House of legislature refers to judicial body, which is summoned by the governor pursuant to Article 174. The term legislature, on the other hand, refers to wider concept under Article 168, comprising the governor and the houses of the legislature. It functions indefinitely and continues to exist even when the governor has not summoned the house. The use of the phrase in the legislature instead of house of legislature is significant. There are several parliamentary processes which do not take place on the floor of the house, that is when it is in session, having been summoned by the governor. For instance, there are ad hoc committees, standing committees, which examine various issues, including matters of policy or government administration. Many of these committees do not deliberate on laws or bills tabled in the house or cease to function when the house is not sitting. There appears to be no reason why the deliberations that take place in such committees, anything said, would not be protected by parliamentary privilege. Then, Lords, their Lordships, Lords, deal with voting aspect, which obviously is not when the session is done. Therefore, Lords, the conclusion in Sita Soren is that the word legislature has been consciously used.
Yes. Yes, sir.
Please. Orissa judgment act No, anything said straight away. We'll go to anything.
So these are the paragraphs in Sita
Yes, these are the paragraphs only for this first proposition.
Hmm.
One minute, please. I'll tell you. To state, my lord, that whether the legislature, whether the
enjoys absolute immunity.
as soon as I enter the precincts of the legislature, well, I get that protection under 194. But the reason is not far to see. There could be a number of situations where I may not be called upon to speak. I may get up and say something. I may not be part of the deliberation. The chairman may not be there. The assembly member, the speaker may not be there. Yet the protection is given. Also, kindly visualize this situation. 194(2) also uses the...
What you submit is whether the house is in session or not in session.
in session.
You are inside the
Legislature.
legislature.
Yes.
So protection springs.
Please. That is the my submission.
All right.
I just wanted to demonstrate this by of two illustrations. Number one, my lords, for instance, in Rajya Sabha, voting takes place. In fact, this P.V. Narasimha Rao and fallout of Sita Soren were cases of voting. Obviously, the legislature is not in session. Therefore, their lordship said, no, even if the legislature is not in session, that protection is not there. Second is, lords,
Yes.
194.2 also uses the word committee, if lordships have seen.
Yes.
Therefore, as a member of the committee, this under the legislative process, there are a number of subcommittees which are constituted,
Yes.
who deliberate for the purposes of, lords, for instance, recommendation of a bill, etc. In all such cases, that protection extends. On this point, only one more submission I propose to make.
Yes.
Now, it would be not open for the state, that is the executive, my lord, today, before your lordships, to say, even interpret to say whether whether the legislature was in session or not. Now, in order to find out, if I am to deny that assertion, but then lordships may have to exercise the powers which are exclusively vested with the chairman of the Legislative Council. The question as to whether it was part of the legislative session or not also, according to me, exclusively belong to the legislature itself. And therefore, I said under Article 226 or 227 of the Constitution of India, it would be not open for them to invoke lordship's jurisdiction to say, please make a distinction here that the legislature was in session, it was not in session. Because now it was not in session, 194.2 is not applicable. The question as to whether the 194.2 is applicable or not should also be decided by the legislature itself, insofar as this aspect of the matter is concerned. Insofar as only the requirement of a procedure is concerned. And as a matter of fact, in this case, the jurisdiction of the chairman has been invoked by the respondent number 2, and a ruling has been given. But I must only add a caveat. The orders, lords, or the decisions passed by the legislature really cannot be relied upon before your lordships, lords, because that forms part of the privilege. By inadvertence, lord, I must bring to lordships notice, those proceedings have been filed before your lordships as part of the writ petition. Therefore, in my written submission, I have made it very clear that we do not propose to rely upon that, and we would request lordships not to take into account those proceedings. But the fact of the matter is that the chairman of the Legislative Council has relied upon could be gathered by a letter written by the chairman, lord, to the Honorable Home Minister, which I may just refer before your lordship, just to
Now, the preposition mugspeedy. Amal will get into the
facts. This what I am now submitting before your lordships is also attended to this for this reason. The question as to whether the house was in order or not. Ultimately, the house was in order or house was not in order. That also has to be decided by the chairman of the Legislative Council. This is the second limb in this submission.
Which page?
Adu memo hakidare. If lordships are see the writ petition, in the writ petition, Lord, I'm not requesting lordships to look into it, but I refer to it. But page 53 if lordships, page 54 if lordships are to see.
In the writ petition itself.
In the writ petition, lordships may kindly see first that.
Yes.
Idu page 54 na ಮೇಲ್ಗಡೆ top lordships is ತಿದ್ದುಪಡಿಯಾದ ಪತ್ರೆ ಅನ್ಎಡಿಟೆಡ್ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಅಥವಾ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗಳಲ್ಲಿ ಉಪಯೋಗಿಸಿಕೊಡೋದು ಅನ್ಎಡಿಟ್ ನಾಟ್ ಫಾರ್ ಇವರು ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಅವರ Siddharth has done it, but I don't say that it could have been done. But this is the reason why I refer to this is this is also a matter which the chairman only has to decide. This as to whether the house was in order or not.
Now, who invoked the jurisdiction of the chairman? The complainant?
Respondent number 2.
Complainant.
The Honorable Minister, she filed a complaint. Then he heard the matter and has given some ruling. Our ruling now, this cannot be relied. But that letter which he writes to the Honorable Home Minister, there he refers to this.
Page?
Separate memo. ಒಂದು ಮೆಮೊ ಹಾಕಿದೆ. ಲೆಟರ್ ರಿಟರ್ನ್ ಬೈ ದಿ ಚೇರ್ಮನ್ ಲೆಜಿಸ್ಲೇಟಿವ್ ಹೊರಟ್ಟಿ ಟು ಮಿಸ್ಟರ್ ಹೋಮ್ ಮಿನಿಸ್ಟರ್ ಬರ್ದಿರೋ.
Given offhand, it was not with the memo. It was given offhand itself, not with the memo.
Nothing here. Communication, huh?
ಹೌದು, ಲೆಟರ್ ತೋರಿಸ್ತಾರಲ್ಲ ನಾನು. ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೋಮ್ ಮಿನಿಸ್ಟರ್.
ಯಾವ್ದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? There is no memo. ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಕೊಡಿ.
I'll just file it. I'll go to the next.
ಇದ್ರೆ ಕೊಡಿ, ಇಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. You have an extra copy of it, give it.
But lot, I'll just read.
ಕೊಡಿ.
There he writes to the Honorable Home Minister, last paragraph nodre, it will give rise to unnecessary confrontation between the executive and the legislature. I request you not to proceed with the, in his capacity as a head of the legislature, he writes it. But this is only to amplify that he had taken cognizance of this incident and he had given a ruling. This is an important aspect, notes, in the matter, according to me. Very, very important aspect.
Next.
So this, notes, would be the first submission. Second one, notes, would be as to whether if I have to speak something which is derogatory, which is defamatory in nature, which may constitute an offense, in the could it give rise to a situation where a criminal case could be registered? Lordships have referred to Ajit's case. I'll straight away come to that as well.
No, that's the only clarification. If a crime is committed.
Crime is committed. Now the law is well declared and there cannot be any doubt about it. The protection is only in respect of anything said. Yes.
Which has nexus to the business of the house.
Other ಬಗ್ಗೆ I'll just put. No, but anything said, no, I'll put it across in this. Anything said or vote given. These are the two acts which is protected. Obviously, not anything said under they said, therefore they first gave freedom of speech as a absolute right. Then they said anything said, even if you say something, now the law has been settled. I'll point out. Anything said is also absolutely protected. No, the question in Ajit's case, however, a case where there is unruly behavior, giving rise to damage to public property, etc.
There, Ajit's case was not anything said.
It was about public property.
It was an action.
Please.
Not by way of speech, but by way of action of breaking the
mics, etc. Therefore, that is the protection.
There are criminal acts which are performed.
Therefore, that
now here is a statement made.
Yes.
The alleged here is a statement made. Whether that is protected as
yes,
anything can be said in the legislation.
Yes, I could take lordship straight away to the next judgment in that written submissions.
Yes.
Tej Kiran Jain and others versus N. Sanjeeva Reddy and others.
Yes.
Judgment to if lordships are to in the compilation. But I will just read in the compilation of judgments which is given. It is the first judgment itself.
Yes.
Now, may I request lordships to kindly see paragraph 7.
Yes.
Mr. Lekhi's argument has been first referred, and kindly see how the Honorable Supreme Court interprets it. Paragraph 7, page 4.
Yes, sir.
Mr. Lekhi, in arguing this appeal, drew our attention to an observation of this court in special reference number 1 of 64, where this court, dealing with the provisions of Article 212 of the Constitution, pointed out that the immunity under that article was against an alleged irregularity of procedure, but not against an illegality, and contended that the same principle should be applied here to determine whether what was said was outside the discussion. This is what. Outside the discussion of the calling attention motion, according to him, the immunity granted by the second clause of the 105th article, that is Parliament, 105 is particle, 194 is was to what was relevant to the business of the Parliament and not something which was utterly irrelevant. This was the argument of Mr. Lekhi. Kindly see what the Honorable Supreme Court says.
Yes.
In our judgment, para 8, in our judgment, it is not possible.
Yes.
In our judgment, it is not possible to read the provision of this article in the way suggested. The article means that what it says in language which could not be plainer. The article confers immunity inter alia in respect of anything said in Parliament. The word anything is of the widest importance and is equivalent to everything. The only limitation arises from the word in Parliament, which means during the sitting of the Parliament and in the course of the business of the Parliament. No, my lord, obviously, my lord, sometimes it shocks the conscience of a common man, us or the court also. Can it be anything said? Well, according to me, the test of Article 194(2) is really the independence of a legislature or the democratic functioning of a legislature itself, not individual blemishes like this. I would put it across in this way. On facts also, I will state something for your lordships. But if lordships are to read 194(2) and say, if you are to say something which is not relevant to your business, and if that limitation is read into 194(2), my lord, that would result, according to me, in a situation where we will be surrendering our right to the hands of the executive. The executive could easily say tomorrow, or the police can easily say, this was not in your context of what you have spoken, according to us, this constitutes, therefore we'll register crime. But once you expose the legislatures to the whims, I will say, or the fancy of the executive, my lord, this whole balance between the legislature, executive will not turn topsy, lords, and has grave consequences. Therefore, my lord, therefore the lordships say there could not have been more plainer. Therefore, it starts with a negative language. No court shall take note. That lordships have seen 194(2).
Yes, that has.
It is emphatic to say anything said, no court shall take into consideration. But this honorable court, in that A.K. Subbaya's case, also has dealt. Lordships may permit me to read A.K. Subbaya case. Paragraph 14 of that compilation, that judgment. In that compilation, page number 5.
Yes.
Page 8. Huh? Page 8. It starts from page 8. The relevant portion words is para 16. Interestingly, Mr. A.K. Subbaya had moved the court for some judges honorable judges were criticized by the members of the House that he wanted some action to be taken. Kindly see paragraph 16. Though, His Lordship Justice Venkatramaya, in fact, expresses in the end in this judgment, it is really unfortunate what has happened that the honorable judges have been criticized, but we cannot do anything. Para 16, Lordship may kindly see.
Yes, sir.
It is in the above terms. It is in the above terms, the Supreme Court, while holding, that they refer to Tej Kiran, that in certain circumstances it was open to the High Court to take action in a matter which came within the latter part of Article 194(3) of the Constitution as it stood then, emphasized that Article 194(2) of the Constitution, but Lordships may kindly see, difference between 194(3) and 194, stood entirely on a different footing, and the immunity granted thereunder was inviolable. Then their Lordships refer to Tej Kiran Jain, which I have just read. Then, Lord, kindly see para 18.
Yes. Yes.
This is not a case. One second, Lordship. Correct. This is not a case of where any individual's fundamental right is involved. No prayer is based on any ordinary civil or criminal laws made in this case. This is not a case where any objectionable words has been used in the course of the speech of a member made outside the agenda of the House or a subject which has been disallowed by the Constitution. I will only bring to Lordship's notice word anything at paragraph 8. Same thing, the Tej Kiran's case has been reiterated by this honorable court. I will leave it at that. Now, my lord, therefore, the word anything or everything includes everything.
Yes.
But and on this series, my lord, so that I will not skip, the 1951 Calcutta is also referred to before your lordship, which is at page 132. Relevant portion. Paragraph 8.
Yes.
Para 8. Para 8, what's Clause 1 and 2 of Article 194 protect absolutely and completely a member in respect of any speech made by him in the Legislative Assembly or any committee of the legislature. His words spoken within the four walls of the Assembly are clearly, absolutely privileged, and no proceeding, either civil or criminal, may be taken in respect of them. It is therefore clear that Dr. Suresh Chandra Banerjee, who made the speech in the Assembly containing the alleged defamatory matter, cannot be prosecuted for uttering the words complained of in the Assembly. It is to be observed, however, that in the complaint, it is not suggested that he is liable in respect of the words spoken in the Assembly. What is suggested in the complaint is that he is liable in respect of the publication made at the instigation of the Lok Sevak of the so and so. But any other paragraph?
Yes.
Then what I wanted to, there is some mistake on my, that A.K. Subbaya, there is some other paragraphs also.
Paragraph 16.
Yes, there is
Paragraph
some,
16.
I missed out on that criminal or no criminal court. Or
Yes,
I'll just point out 2 minutes.
That's paragraph 16.
Yes. In fact, their lordships say there that you cannot subject yourself to anything criminal.
At the mark paragraph 16.
Yes. Paragraph 16. On this, neither civil or criminal court you are not.
Para 23 is what it is unfortunate and
that is last week. Though their lordship said something like this, it is unfortunate that criticism has been made to justice, civil or criminal. And paragraph 19 is what?
194.2.
Oh,
yes.
No, 19 is what I wanted to emphasize. 19, para 19.
Para 19 and the last three lines is what you want to rely on?
Yes.
No court, whether it is Supreme Court or High Court or civil or criminal court, can initiate proceedings against a member in respect of anything said on the floor of the House.
Please.
This is what you want.
Yes, yes. Therefore, tomorrow, if they are to register, they have registered an FIR, of course, file a charge sheet. Obviously, I have to go before the court. Proceedings may have to be initiated before the court. If it is a non-cognizable offense, they have to take the permission of the magistrate. So all will lead up to a situation where the court orders are required. And also, kindly visualize this situation. They have to hold a Panchanama. They have to prove this matter.
See, if criminal law is permitted to be set into motion, procedure also will be set into motion.
All of them will be. That would then has several other consequences of 194.3 privileges. Would the chairman be asked to come and depose before the court in respect of proceedings which has happened? All those aspects. That is what I wanted to emphasize before.
So
it has happened. Please,
whatever crime happens inside also.
Crime, I'm sorry. Not a
no. What is projected now?
What
is an ingredient of section 354?
No, 350. Not anything said by me. If it results in a crime, I am not subjected to criminal. Not any crime. I will say anything said by me.
No. Now what
in this case, I have said according to them.
Now taking this case itself, what you have uttered in the house is now become the ingredient of section 354.
Assuming so.
Assuming so. Now it is, what is invoked is outraging the modesty of a woman. Now that is, it is not by acts.
It is by
not by acts. It is by
word.
It is by a statement.
Yes.
Whether that also
yes, ma'am.
Has.
I will answer that question straight away.
No, are you insulated with immunity of a kind that even such words cannot be?
No, I will put it. Yes. I will put it across in this way, in giving only two straight answers.
All right.
Tej Kiran's case, A.K. Subbaya's case, therefore use the word anything said, include everything said. Number one. But therefore I said individual.
So, according to you, anything means everything.
Anything means, Honorable Supreme Court says, anything means everything. And not the object of 194.2 is this only. Object of 194.2 is, if anything said by me results in an offense under the Indian Penal Code, or for that matter, any other enactments, I will not be called into court. And instances will galore before your lordships that a statement made by a member of the legislature may be defamatory in nature. In all such cases, my lords, if we are called or registered, cases are registered, etc., the whole independence or the right of a member of the legislature will be taken away. But I would implore before your lordships for this reason. Individual cases of such nature, which which I will come to it also, cannot set an example of true interpretation of Article 194.
Well said. Yes. Next.
The word, the context in which why they said anything includes everything is for this reason itself. Whether defamation can be anything. This question was posed and answered. Anything means everything. All right. Now, my lords, for instance, can there be more blameworthy conduct, permit me to use, of a legislature when it criticizes the honorable judges? According to me, that is, my lord, can it be more blameworthy? Even that has been protected, though their lordship said it is unfortunate. But there were, if lordship permit me, there were instances where, in Kaveri dispute, two honorable judges, directed the Karnataka state to release water in the last regime of the present government. The House legislature collectively took a decision that we will go back to the court. Obviously, they were milder in their terms, but it was almost a defiance of the court. But I collectively took that. No, I'm only.
No,
I'm going.
Defiance can't be projected to this case. Defiance is
No. What I
see, defiance or the independence of the legislature to undo what the court has done. That power is there. That is all. Go to the parliament and to the state legislature.
So that was not a case of that.
Wherever we have passed judgments, it is not that they're weeding out.
I'm only in those discussions, but obviously.
Doctrine of invalidation is always there.
I gave examples. There have been instances where the honorable judges have been criticized. That cannot be a better example than what's an utterly word to another member of the legislature. Both of them are blameworthy. I'm putting it. I'm not saying one is better than the other. If that has been given protection for this reason, saying that no, we can't do anything about it, because though he says it is unfortunate, because my lord, the reason is this. But I'll once again emphasize. It is necessary, my lord, that protection, that independence is given to the members of the legislature. If the in the current parliamentary system of government, or Westminster model where the ruling party also is the head of the executive, lordships may have to see the nexus. If the executive is allowed to dictate the terms, it would lead to consequences. I cannot get up and ask a question to the Honorable Chief Minister. I cannot blame the government of undoing. That would either result in defamation or some sort of an intimidation. If that fear is crept in, then it would result in, if the executive is allowed to overtake this, then it will result in turning the whole concept of independence itself according to. Therefore, Tej Kiran's case and A.K. Subbaya's case, both of them reiterate that position of law.
Yes.
But I also wanted to bring to lordship's notice Article 212. Two and two subclause 1, the validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity of procedure. Kindly see subclause 2. No officer or a member of the legislature of a state in whom powers are vested by or under this constitution for regulating the procedure or the conduct of business or for maintaining order in the legislature shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Mr. Belliappa is arguing exactly contrary to 212 subclause 2 when he says this person was not speaking when the house was not in order. He was speaking beyond the power which is vested in him. These are all matters of procedure, conduct, controlled by the head of the house. And he cannot now, ultimately, who has to determine that? This has to be determined by the head of the house itself and not by a court under Article 226, 227. And the court under Article 226 and 227, the only exception the Honorable Supreme Court has made as to when it can actually determine this issue. But why I am emphasizing on this is these two questions which has crept in the mind of the court as to whether he can can speak something outside his duty, etc. But the Honorable Supreme Court in Raja Rampal's case lays down a very fine distinction between the jurisdiction of the court as well as proceedings of the legislature. What is said by me in the legislature that day on 19th December, I am subjected to only to the order of the House by the chairman of the Legislative Council. Whether I spoke in excess, whether I spoke as part of my duty, whether the House was in order or not, these are all matters, according to me, to be controlled and decided only by the chairman of the Legislative Council in this case. And under what circumstances 226 can be invoked to determine this, is it Raja Rampal's case? In that written submissions itself, Lordships, I'll kindly find it paragraph 16.
16.
17. Conclusions. No, not this. Conclusions. Last conclusions. But in that compilation, Lordships may kindly see.
Yes, yes. Para 656 and 657.
But I have always maintained, it is very difficult for us to catch up with Lordship's speed.
Oh, there.
It is very difficult to catch up. Page 160, 448.
448.
440. Conclusion. I'll just bring one second. But there is a conclusion is Lordship Justice Ravindran draws. But finally,
yes,
has to be how 226 and inter-alia. I'll just point. But where they emphasize that the coordinate organ of the constitution must be equally respected.
Conclusion illa.
7 conclusions their Lordships have drawn. I'll just point out. But I had all done this note. I don't know. We lost it in the book. 749. No. 1 second. I'll just.
That's in paragraph 656 and 657. Page 414 and 415.
656.
657. If what you are wanting to submit. Conclusionally, there is nothing like that.
In this kind of, yes. No, more than, no, I'll just point out there are about 7 tests they have laid down.
Yes.
Just kindly give me a minute, not more.
Yes, yes.
There was a case not where they were
Are you
expelled.
reading Justice Ravindran's view?
Ravindran or the one separate view.
That's a dissenting view.
So there he takes a slightly different view. But this
Concluding
one,
remarks,
Balakrishnan.
703, 704.
Yes.
That is the concurring view.
Yes.
This para 643.
Yes, 643. Open Rajaram Panchas. Yes, ma'am. This is what Rajaram Pal.
You can point out later.
Yes, ma'am.
We'll
I'll
be
point
hearing
out.
the SPP.
There, they lay down 7 tests. Some of them immediately, if I recall, they say fundamentally, normally the decisions of the legislatures must be respected by the court under Article
That is in 640.
640. And only in exceptional cases where there is violation of Article 21 or Article 14. For instance, in their case, but they were ousted from the expelled from the parliament by Somnath Chatterjee. In fact, that time he was a speaker, and he expelled them from the house. And they moved the Honorable Supreme Court. Honorable Supreme Court actually quashed that order of expulsion by the Honorable Speaker. And I must state in the same breath, my lord, this judgment came in for a lot of issues when the matter went back. The House rose in protest saying that we will not recognize the judgment, and that's a different story. But the fact of the matter is, there, my lord, they delineated exceptions by saying, only in respect of these matters, we will interfere under Article 226, or for that matter, Article 32.
Yes.
Not in other matters.
We'll hear the SPP.
I'll just conclude, try and conclude. The last page, my lord, is the conclusion of that we have said.
Nimma conclusion.
That the word legislature, these are the propositions.
So you're on the fourth proposition throughout.
Yes.
Anything said.
Anything said.
Not anything done.
And not anything done. Certainly.
The distinction, the subtle distinction you're wanting to make is
not
anything done, but anything said.
Anything said.
Ajit's case was something done.
Ajit's case only, they actually broke
something done.
Something done. Something done.
We'll see.
But I'll one sentence I have to send. I'll be failing in duty if I do not convey the instructions of that. But insofar as the present incident is concerned, we have the deepest regard and respect for the respondent number 2. She's a lady of some reputation, honorable minister, irrespective of whether he has said or it has hurt the feelings. There could never be a situation where any woman could be hurt. I am not for a moment justifying, assuming it is to be true. Therefore, the honorable speaker or the chairman took a very right decision. He said, these are matters which we should leave it here and proceed further in order to enhance the responsibility of the House. Therefore, my lords, I don't think, my lord, he has also been in public life. He has come from a student struggle. No, I'm not saying it's a student struggle. So has respondent number 2. So both of them are now ultimately members of that House, which ultimately we are trying to interpret and protect. Therefore, anything said, though legally I would say anything said is everything said, but not necessarily in all cases for justification. The deepest respect, my lord, I must convey, not by me, my lord, through the petitioner, deepest respect, highest regard for the respondent number 2's achievements, their modesty and their nobility is conveyed to lordships, my lord, so that things are resolved in the manner it is written.
But the contentions are to be answered.
Yes.
SPP, sir.
Yes, Lord. Lord, it's all about anything said. Lord, 7 judges have said in Sita Soren's case is what, my Lord, I will take your lordship to. Kindly take, my Lord, 194.6, the conclusion drawn by 7 judges of the Supreme Court. Kindly see, my Lord. Your lordship goes to para 7, my Lord. The conclusions drawn are at page 742 at para 194. Your lordship gets it?
Yes, yes. Para 194, yes.
Yes. Now kindly turn to 194.6. Lord, I straight away take your lordships to what the judges have said about anything, the expression anything said in respect of a speech or a word given. May I read, Lord?
Yes, sir.
194.6. The expressions anything and any must be read in the context of the accompanying expressions in Article 105 plus 2, 194 plus 2. The words in respect of means arising out of or bearing a clear relation to and cannot be interpreted to mean anything which may have even a remote connection with the speech or word given. Now, my Lord, admittedly, there was a complaint before the speaker, and the speaker has also, my Lord, the first contention was that the speaker has given a finding. Now, let me take your lordship to the speaker's finding, my Lord, that the House was not in session and it was not in good taste that these utterances were made.
SPP, sir. Judgments muguspudi. Then I'll get into the facts.
Lord, I would want some little time, Lord, even after 2 days, I would be there because while coordinating with the respondent number 2's counsel, he said he would take some time. Therefore, I was to come there. Otherwise, my lord, now I could not come. The judgments, I will not rely on any more judgments except not clarifying these judgments and Ajit's judgments, my lord. I will not have anything but to clarify. Give me 2 days time, my lord. That is all I request. My lord, on facts now. Could your lordship go to the finding of the speaker, my lord? He sums up saying that the house was not in session. Lord, may I take your lordship to...
Chairman ruling, we cannot rely. It will amount to...
No, he is not the,
No,
I'm
it is
not
our
relying on
they're
that.
not relying on that is what
I'm
is
not
said.
relying on that. The facts. And what
in our favor, I have not relied.
yes, because they have relied it.
Yes. Yes.
And
yes.
what is parliament? What is defined as parliament? My lord, now kindly turn to page 54, my lord.
Yes.
54. That's the finding given by the speaker. It starts from 53. My lord, all that he says is, the fact is that when the house was not in session, kind of filthy language is used. It is not in good taste. It is extremely disrespectful. See the tirpu, my lord, at the para 54. There is what is shown as tirpu. The lordship gets it?
Yes.
Yes, my lord. He is
No.
given a finding.
Well, SPP sir, if
Yes,
if you're wanting time, tell me, I'll take it on Monday, no problem.
Yes, my lord. Yes.
But after all this, then adjournment agalla.
Alala, because respond number 2 is seeking time. I'm not seeking time. That's why I thought, my lord, I will also sail with them and argue on.
Second respondent.
Yes,
Yes,
I have yesterday only, my lord. We will make detailed objection on this.
When?
Soon, my lord. Any short accommodation.
Monday.
Yes.
Monday?
All right. We'll take it on Monday then.
Yes,
Monday at 4 p.m.
yes, my lord.
Lordships permit me to appear on VC
Online.
on Monday.
Whenever I insist. Yes.
My lord, may I make one submission, my lord, with respect to serial number 1. I could not join the matter due to some technical glitches.
Which one, sir? Bangalore
Serial
list.
number 1, my lord, that's the animal trophy matter.
We'll see. Wait. Yes. Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner who has completed his submissions and reserves liberty to submit anything in rejoinder to the submissions of the learned SPP or the counsel representing the respondent number 2 complainant. The second respondent, counsel for the second respondent seeks short accommodation to file objections. Therefore, list this matter on Monday at 4 p.m. for further hearing, showing it as heard in part. Yes.
My lord, serial number 1, my lord.
One minute, sir. Idu muguste.
Sorry, my lord.
Interim order to be
For one name, Tejasvi.
Yes, my lord. My lord, this is a matter pertains to animal trophy that we have challenged the predicate offense itself, my lord.
Ad adjourn ಮಾಡಿದ್ನಲ್ಲ.
ಅದು ಟೆಕ್ನಿಕಲ್ ಗ್ಲಿಚಸ್ ಇಂದ ನಾನು ಜಾಯ್ನ್ ಆಗಕ್ಕಾಗ್ಲಿಲ್ಲ.
There is no technical glitch. Correct ಆಗಿ adjourn ಮಾಡಿದ್ದೀನಿ.
No, my lord, I could not join the call due to
No
some
problem.
technical glitches.
I posted it on 7th March, sir.
Yes, my lord.
Yes.
Grateful, my lord.
I appear for the petitioner in this matter, your lordships. This is the Valmiki scam case, your lordships. When petitioner is accusing...
My request for some time to file objections.
Stay ಕೊಟ್ಟಿದ್ದೇವೆ ಇದರಲ್ಲಿ.
Stay ಇಲ್ಲ ಇದರಲ್ಲಿ.
Stay ಇಲ್ಲ, your lord. There's no stay in this.
KG.
I'm on the point that petitioner is a public servant and there's no sanction, your lord.
Seventh. List the matter on March the 7th, 2020.
May I request your lordships to kindly defer the stage, your lordship. Tomorrow it is for here before charge.
Nothing will happen. Yes. List on.
I'll insist matter there, your lordship.
No, whether all these acts are covered, we'll see. Yes, list the matter on March.
It's covered by your lordship's judgment, your lordship. Timaya versus Mohan Kumar.
List the matter on March the 7th, 2020, 2025. The objections, if any, by the next date by the respondent CBI.
Please.
In the event no
ED,
objections are filed. ED. In the event no objections are filed, this court will be constrained to grant an interim order.
Please.
Yes.
The stage defer ಮಾಡಿದ್ರು ಸಾಕು ನೀವು.
ಅಲ್ಲ ಏನ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ತಾನೇ ಆಗ್ತಾರೆ
ಏನು ಒಂದು ಎಕ್ಸಾಮ್ಷನ್ ಹಾಕಿದ್ರೆ ಆಯ್ತು
ಅಷ್ಟೇ.
ಅಲ್ಲ,
It is
JC in JC
one
or
ನಿಮಿಷ. The learned.
Item number 5 is similar matter. It can be tagged on 7th.
One moment, sir.
Yes.
The learned counsel for the petitioner submits that the matter is slated before the concerned court for framing of charges. Therefore, it is for the petitioner, to avail of such remedy for in the interregnum. Yes, next.
Much obliged.
Yes, sir.
Lord, a complaint came to be filed on 13/9/2024 at page 22. In respect of incidents which took place from 2019 to 2024, page 51 is the FIR.
You are ready, sir?
Yes. Page 51, my lord.
Page?
Page 51. The FIR is registered for offence under 506, 504, 365, 420 and 323. ದಿನಾಂಕ 5/7/19 18/5/24. This FIR is given in relation to an incident mainly which takes place in September 2021. Here he says, I have given some money at page 57. At page 57 September 21 I have given some money to the gunman and an additional 10 autos will be given. On that condition, 21 will be given. Thereafter, he refers to several other incidents during several years. In respect of one allegation of abuse at page 59, a separate SC/ST atrocities case is also registered. Now, on this basis, my lord, immediately on the date of the complaint itself, though it is a delayed complaint, immediately without holding preliminary inquiry, the case came to be registered. Now, thereafter, my lord, a special SIT team came to be constituted at page 68.
Yes.
ಅದರಲ್ಲಿ ಪೇಜ್ 68 ಅಲ್ಲಿ ಬಾಟಮ್ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶಾಸಕರಾದ ಶ್ರೀ ಸೋನ್ಸೋ ಇತರರ ವಿರುದ್ಧ ಬೆಂಗಳೂರು ನಗರ ವೈಯಾಳಿ ಕಾವಲ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ವೈಯಾಳಿ ಕಾವಲ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮತ್ತು ರಾಮನಗರ ಜಿಲ್ಲೆ ಕಗಲಿಪುರ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಸೋನ್ಸೋ ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣಗಳ ಕುರಿತು ಸಮಗ್ರ ತನಿಖೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ರಾಜ್ಯದ ವಿಶೇಷ ತನಿಖಾ ಸಮಿತಿಯಾದ CIDಯ ಕೆಳಕಂಡ ಹಿರಿಯ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳನ್ನು ಒಳಗೊಂಡ ಒಂದು ವಿಶೇಷ ತನಿಖಾ ತಂಡವನ್ನು ಸರ್ಕಾರವು ರಚಿಸಿದೆ. There, my lord, this BK Singh is the only person from CID. Others are not from CID, but even then they say that it is from CID. But they don't declare. But they don't declare this as a police station. Now only CID, my lord, can be declared as a police station. Then at the bottom, ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು CID ಅವರ ಮೇಲ್ವಿಚಾರಣೆಯಲ್ಲಿ ಈ ವಿಶೇಷ ತನಿಖಾ ತಂಡ ಕಾರ್ಯನಿರ್ವಹಿಸುವುದು. ವಿಶೇಷ ತನಿಖಾ ತಂಡವು ಮೇಲ್ಕಂಡ ಪ್ರಕರಣಗಳು ಹಾಗೂ ಮೇಲ್ಕಂಡ ಶಾಸಕರ ವಿರುದ್ಧ ದಾಖಲಾಗುವ ಇತರ ಎಲ್ಲಾ ಪ್ರಕರಣಗಳ ಸಮಗ್ರ ತನಿಖೆಯನ್ನು ನಡೆಸಿ ತನಿಖಾ ವರದಿಯನ್ನು ಮಹಾನಿರ್ದೇಶಕರು ಮತ್ತು ಆರಕ್ಷಕ ಮಹಾನಿರೀಕ್ಷಕರು ಬೆಂಗಳೂರು ಅವರ ಮುಖಾಂತರ ಶೀಘ್ರವಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. Lord, it is my submission that this SIT is not declared as a police station.
That is why report is directed to be submitted to the
government. It cannot be construed as a report, my lord, which is to be given under the BNSS under 193.
No, it is not a final report under 173(2) or BNSS, whatever is there.
193, the old act IPC, the criminal procedure code 173, it cannot be construed. And even otherwise, my lord, this is not declared as a police station. CID is a police station.
The final report shall be filed before the jurisdictional police antilla.
Illa.
This is,
that
no,
is one
this an investigation or in the nature of a preliminary investigation calling for a report?
Yes.
From the hands of this committee so constituted. You can't call it a committee that is declared a police station and that committee to file a final report elsewhere.
That is one submission, my lord.
That's what can be gathered from that is, I guess.
Yes, that is the only point. Now, the other point is, my lord, they also invoke PC offences later on at page 62.
Yes, I saw that.
That PC offences, my lord, no sanction is obtained. The PC Act 713.
Yes, that I saw. Yes,
Pass
sir.
transfer, put up the file, return with the direction to produce sanction order. So long as there is no sanction order, this investigation also cannot go on. These are the. And thirdly, my lord, this entire allegation over a period of 2019 to 20, and in a period of about 3 months, they go on file about 5 different complaints. This I have taken the allegation of political vengeance. One complaint for SC/ST atrocities on the ground of this conversation, which this person says that I have recorded it. On the basis of the recorded conversation, another person says you have abused in his presence. On that basis, a complaint is filed at page 71.
Yes, that types. 122 of 24.
Yes. Then 312 blood is a 376 case. That is registered. Then at serial number 13 in the index.
Now this case concerns only 121 of 24.
121.
Yes, only 121.
Yes. The ground is delay.
The ground is delay for
And
this
improperly
period.
constituted committee
Yes, sir.
to go into the allegations.
Yes, yes.
Yes. Yes, sir.
But as far as
Judgmental help.
delay is concerned, this is not an offense, which has gone on over a period of time. It is a continuing offense. 5/7/2019 till 18/5/2024. But this person allegedly, he was under.
Mike. ನೀವು Mike. ಹತ್ರ ತಗೊಳ್ಳಿ.
I don't want to be very loud.
ಪರವಾಗಿಲ್ಲ, no problem. Yes.
But he was under the obligation of the MLA. So he being a contractor, he was operating that particular area for removal of all those waste products. For that purpose, he had to be under the MLA and under his scrutiny and for the sanctions and other aspects for whatever that is. So it is a continuous process during the contract period that, the offenses is said to have taken place. Finally, the person sums up some courage to come and lodge the complaint. As far as the question of delay and other aspects is concerned, it is well answered. And that apart, no, at this stage, initially the complaint was registered by Vayalikawal Police. Vayalikawal Police Station. Subsequently, the matter was transferred for investigation to SIT. And at that point of time, SIT realizes that there is some kind of a demand in exercise of its official duty and things like that. So they want to invoke Section 7 and Section 13 of the Act. That apart, no sanction has not yet been. They are applied for sanction, not yet granted. Sanction ಬಂದಿಲ್ಲ.
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ.
ಸ್ಯಾಂಕ್ಷನ್ ಆಗ್ಬೇಕು ಈಗ. ಅಪ್ರೂವಲ್.
Sanction is for the purpose
prior
of
approval.
Prior approval.
17A.
17A.
19 stage ಬಂದಿಲ್ಲ.
19 stage ಬಂದಿಲ್ಲ ನಾವಿನ್ನು. 19 stage but 17A. We are at the stage of 17A, where we are waiting for the prior approval of for the purpose of investigation.
Sent it for a prior approval.
We have sent for prior approval. No, it is at that stage. And here, being at that stage, the next contention that comes up is whether it's a police station or not, whether they have the power to file a charge sheet, final report. No, I'm not coming to that.
Why have you indicated in the order constituting SIT that the final report should be filed before the government?
No, it is not the final report.
What report? See, now the order is specific.
Yes.
You are constituting the SIT in crime number 124 of 2020, 121 of 2024 or whatever it is.
Yes.
To investigate and report back to the government. Why?
No, it is not a final report.
Then
Well,
what investigation are you? No. Once you permit investigation into a crime.
Yes.
It is an investigation under the CRPC or now the BNSS, whatever.
Yes.
If that is an investigation under the CRPC or BNSS,
Yes.
or as the case would be,
Yes, my lord.
then where is the question of filing the final report before the government?
Well, the notification does not say it is a final report first.
Then what report are you wanting
The
to the
status
government?
report.
What status report?
Being,
The crime
being
ಅಲ್ಲಿ
a
ಯಾವ status
prosecuting,
report?
my lord, the state, my lord, has the right, my lord, to know the investigation, the progress in the investigation.
ಅದು ಹೇಳಿದ್ರೆ
That's
ಪರವಾಗಿಲ್ಲ.
status.
ಆ
That's
ಥರ
all it is, my lord. Otherwise, that
no,
could be-
let stage of investigation and status at intermittent intervals ಅಂದ್ರೆ okay.
Yes, but that is
But
what-
where is the question of asking the government
Doesn't
to file
say
a final report
at all.
before the
It is the-
government?
It is the, my lord, it could be construed only to that extent.
No,
My
no,
lord may kindly see.
one thing, you have not, in this government order, if you had correctly, if you wanted to correctly do it, you should have declared this SIT to be a police station
Yes.
and it empowering it to file a final report under 173(2) before the consent.
My lord may.
ನಾವು ಏನು ಇಲ್ಲ
permit me-
ಇದರಲ್ಲಿ.
My lord,
SIT
may
ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್
permit me-
ಮಾಡಿದ್ದೀರಾ, ಗೌರ್ಮೆಂಟ್ ರಿಪೋರ್ಟ್ ಹಾಕಿ.
No, no, my lord may kindly permit me to produce this notification, my lord, of the government. 12/1/2024. My lord, it is declared as a police station.
Who is declared? CID is declared.
So Home Department, government of, CID is declared as a police station.
Now SIT is not CID.
SIT comes under CID.
Where do you get that?
My lord, may come to the very same notification, my lord. Page number 69. Page number 69. It starts from page number 68 to the end. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ನಂಬರ್ so and so ದಿನಾಂಕ 29/21/24 ಅಲ್ಲಿ on the next page, my lord, ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣಗಳ ಕುರಿತು ಸಮಗ್ರ ತನಿಖೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ರಾಜ್ಯ ವಿಶೇಷ ತನಿಖಾ ಸಂಸ್ಥೆಯಾದ CID ಈ ಕೆಳಕಂಡ ಹಿರಿಯ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳನ್ನು ಒಳಗೊಂಡು ಒಂದು ವಿಶೇಷ ತನಿಖಾ ತಂಡ. SIT is under CID. SIT is not
This is
separate.
declared a police station that time.
It's declared a police station.
Before, they're not from.
They are not members of the CID.
But still, my lord, the CID has the power.
Now, who heads this BK Singh is CID?
It is CID.
Yes.
BK Singh is CID, and for purpose of investigation, from their department, they bring in.
That is first thing.
Yes.
Then where is the question of filing the final report before the government?
No, final report is not
ಮತ್ತೆ
before the government.
ವಿಶೇಷ
Not by
ತನಿಖಾ
kindly see.
ತಂಡವು ಮೇಲ್ಕಂಡ ಪ್ರಕರಣಗಳು ಹಾಗೂ ಮೇಲ್ಕಂಡ ಶಾಸಕರುಗಳ ವಿರುದ್ಧ ದಾಖಲೆಗಳನ್ನು ಇತರೆ ಪ್ರಕರಣಗಳ ಸಮಗ್ರ ತನಿಖೆಯನ್ನು ನಡೆಸಿ ತನಿಖಾ ವರದಿ. What do you mean ತನಿಖಾ ವರದಿ?
Investigation report.
Two
not-
things you are contradicting in terms.
Yes.
You say CID is declared a police station.
Yes.
Then this committee becomes a police station ipso facto because it is constituted under the CID.
Yes, ma'am.
No problem at all.
Yes.
Now this is an investigation under the CRPC.
Yes.
Now ಸಮಗ್ರ ತನಿಖಾ ನಡೆಸಿ under in terms of the crime.
Yes.
ಮಹಾವೀಕ್ಷಕರ ಸೋರ್ಸ್ ಇವರ ಮುಖಾಂತರ ಏನಿದು ತನಿಖಾ ನಡೆಸಿ ತನಿಖಾ ವರದಿಯನ್ನು ಮಹಾನಿರ್ದೇಶಕರು ಮತ್ತು ಆರಕ್ಷಕ ಬೆಂಗಳೂರು ನಗರ ಮುಖಾಂತರ ಶೀಘ್ರವಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು.
Yes, ma'am. That is. Lord,
ತನಿಖಾ ನಡೆಸಿ ಕ್ರೈಮ್ ಅಲ್ಲಿ this is declared to be a police station.
Yes.
You are empowered to go and file it before the concerned court.
Yes.
Where is the question of ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು?
Lord, here what happens, Lord, by virtue of the crime being registered and the investigation happening, the final report, Lord, will be submitted before the.
Then
court.
why this order?
Yes,
says
this
for-
is not the final report,
Place it.
Lord. It is where the
Please.
government has its
ಸಮಗ್ರ
power, Lord, to-
ಸಮಗ್ರ ತನಿಖೆ ನಡೆಸಿ
Yes.
ತನಿಖಾ ವರದಿ. What do you mean ತನಿಖಾ ವರದಿ?
An investigation report, status
Correct.
report.
No, no,
That's all. May not may kindly.
not status
Yes.
report.
May not kindly come to. Page number.
ತನಿಖಾ ವರದಿ is investigation.
Coordinate bench of the lawyers. It's
ಇದೇ
page
ಒಂದು
number 115, my lord.
ಇದೇ ಒಂದನ್ BMTC.
Yes.
ಆಮೇಲೆ
Is that page number 115, my lord, may kindly.
I have seen that. I have distinguished that also.
Yes, in that, my lord, very clearly says, this should be summed up as a status report.
That's the only problem.
But even otherwise, my lord, we have not submitted any report to the government as of now. That could be.
No, SIT has not submitted. But the
not
government says, after declaring it to be a police station, submit the report to us. Doesn't work like that.
My lord, here, no, my lord, what
173(2) only before the court.
Not even
So
in this,
BMTC, this issue was whether BMT is a police station, it is a police station or not.
no, CID.
CID.
Comes to CID, my lord. 115, para number 36, my lord, Mr. MDC. Paragraph number 36, my lord. 115. 5, page number 115. As noticed, it is the contention of the learned counsel appearing for the petitioners that CID police has no jurisdiction to file charge sheet before the jurisdictional magistrate, since they were directed by the government to submit a report to the government. As such, the charge sheet filed are without jurisdiction. I find no substance in this contention. The government, in exercise of its powers under superintendence over the police force and having regard to the seriousness of the allegations made involving huge sums of public money, transferred investigation to CID police. Of course, in the notification, CID was directed to complete investigation at early
Yeah, that I see.
and
Same,
takes the
same kind of a direction.
yes, madam. Here, madam, it says on the next page, madam, on the next page, page 117. Therefore, in the light of the above, it cannot be said that CID police have no competence to file charge sheet under section 173 subclause 2.
No problem.
Having regard to the fact that the government transferred investigation so and so, CID assumed that the status of office police and madam, to the end of that paragraph,
I've
the
seen that.
direction so contained in the notification, this portion, my lord, the direction so contained in the notification will merely, my lord, kindly, merely because in the notification issued by the government, CID was directed to submit a report to the government. It cannot be interpreted that CID police had no jurisdiction to file charge sheet in the terms of section 173 subclause 2. The direction so contained in the notification will have to be construed as a direction under CID to submit a status report to the government as to the action taken by it in respect of the investigation of the case entrusted to it. In view of the matter, I find no substance in the said contention and accordingly it's rejected. But it was just not in accordance, it's a status report not where the government has the prerogative to prosecute and does not preclude it from knowing what is happening regarding the investigation. To that extent, my lord, no, it has been introduced.
All right.
Either way, my lord, nothing has been submitted in this case, neither in other cases where the crime numbers are mentioned in the said notification. Till now, no report has been submitted to the government, but final report in other cases, in 2 other cases, have been already filed before the courts.
Now we are concerned about 121 of 24.
Yes, sir. And my lord, what has happened, my lord, in this case, since my lord, an order, my lords, regarding not to precipitate the matter on these grounds, especially whether it's a police station or not, my lord, that my lord has stalled other matters of CID. The other matter, Prajwal Ravana, other case, because others,
they said that since this court has said that the seeking report amounts to.
Interim order ಅಷ್ಟೇ.
Yes. So only a little, that clarification, at least other cases can be one.
Cascading effect.
Cascading effect.
In fact, this issue, my lord, Vineet Narayan judgment also.
Yes, my lord. Vineet Narayan, same issue has come up. Vineet Narayan's judgment. Here, my lord, page number 256, my lord, kindly.
Para 20.
Para 20, from para 27 onwards. Page number 256. Vineet Narayan was a Union of India.
20?
When para 27, page 256. The only caveat entered by the Attorney General is on the basis of a note by an individual minister in the central cabinet, in which emphasis has been laid that the ultimate responsibility for the functioning of these agencies to the parliament is that the minister concerned, and this aspect may be kept in mind. It is a responsibility of the minister would remain the final disciplinary authority and would have the power to refer complaints against the agency or its officers to an appropriate authority for necessary action. There can be no quarrel of the minister's ultimate responsibility to the parliament for the functioning of these agencies, and he being a final disciplinary authority in respect of the officers and agencies with power to refer the complaints against them to the appropriate authority. Some of the other specific powers of the minister were indicated as under working as the minister has the power to review the working of the agencies which are under his department, has the power to give broad policy directions regarding investigation and prosecution of classes of or categories of cases. The minister has the power to appraise the quality of the work of the head of the agency as well as the senior officers of the agency. mayor has the power to call for information regarding progress of cases. The paragraph number 38, no, 28, I'm sorry, madam. It is sufficient to say that the minister's general power to review the work of the agency and to give broad policy directions regarding the functioning of the agencies and to apprise the quality of the work of the head of the agency and other officers as executive head is in no way to be diluted.
That's all.
Further, it goes up to saying regarding the court of Lord Denning and other aspects are also there, one which says that the government, my lord, is not persuaded of that power.
Yes, yes, sir. Anything?
Points for your reply. This order, SIT order, Lord, it constitutes a team of 4 officers.
Yes.
Now, out of them, only one officer is the person
That's
from
the-
CID. He could do it. There is no difficulty about it. But the other officers are not competent to investigate. They are not from CID. So they are not been declared as police station. In similar case, Lord, this court, one of the judgments at Justice Ramajoy at para 11. Para 11.
Yes, sir.
It may be that the office of a police officer so appointed on deputation was not declared to be a police station. Consequently, he did not become an officer in charge of a police station. It might be open to the objection that he could not exercise the powers of investigation under the code. But as pointed out earlier, state government has made a specific declaration to the effect that the office of each of the 2 officers was a police station. By the force of this declaration itself, each of the 2 officers also become the officer in charge of the police station. Therefore, there can be no doubt that each of them could exercise all the powers available to an officer in charge of a police station for investigation under the provisions of the code. Moreover, Section 36 of the code specifically empowers a police officer who is superior in rank in charge of a police station to exercise all the powers of an officer in charge of a police station throughout the local area to which he is appointed. It is not disputed that SP, only deputy SP or officer superior in rank to an officer in charge of police station. The notification, the contents of which is extracted earlier, specifically indicate that the territorial jurisdiction, the DCSP was Mysore Revenue Division, AC DYSP of Dakshin Kannada, Kurk, Chikmagalur district. Investigation in question against the petitioner was conducted by them within the said local area. The question is also covered by the pronouncement of the Supreme Court and so on. Now, in this case, my lord, both the officers were declared as police station. Now, here what they do is, in this case, one officer is from CID. Where is the question of constituting a special investigation team and treat only one person as an officer in charge of police station? This entire SIT should have been declared as a police station, and thereafter they could have proceeded in the
There is
matter.
no necessity for another declaration. CID has already declared a police station.
No, only CID is declared.
Yes,
Kindly see the order.
SIT is constituted under the CID is what he says.
No, my lord, it is not so. Page 68, our Helado, all of them are CID officers, which is not so. Page 69, ವಿಶೇಷ ತನಿಖಾ ಸಂಸ್ಥೆ.
ಕೆಲಸ ಮಾಡ್ತಾರೆ.
What?
In
My lord,
fact, page
may-
69.
69,
Last
2 lines, my lord, page 69.
ಅಲ್ಲ ಇದರಲ್ಲಿ
His last 2 lines says,
ಅದು ಮೇಲ್ವಿಚಾರಣೆಯಲ್ಲಿ ಇದೆ. ಗೊತ್ತಾಯ್ತು.
ಅಲ್ಲ
ಅದು
ಮೇಲ್ವಿಚಾರಣೆ
ಮಹಾನಿರ್ದೇಶಕರು
ಅವ್ರ ಮೇಲ್ವಿಚಾರಣೆ ರಿಪೋರ್ಟ್ ಕೊಡೋದು ಗೌರ್ಮೆಂಟ್ಗೆ.
CID.
No, at best
And
ಇವ್ರು ಏನ್
all
ಹೇಳ್ತಾರೆ
these
ಅಂದ್ರೆ
people-
all these 3 are appointed to assist the
assist the-
ಮೇಲ್ವಿಚಾರಣೆ.
No, they say ವಿಶೇಷ
They're
ತನಿಖಾ.
deputed, my lord, once deputed, they come under CID.
No, they are not
No, they are
deputed.
presently in the CID.
They are presently in the CID.
No, they are not deputed. Where does he get all this? I don't know.
Sir,
The order doesn't say. There is no deputation order.
No.
No, ಇದರಲ್ಲೇ ಇದೆ ನೋಡಿ ವಿಶೇಷ ತನಿಖಾ ಸಂಸ್ಥೆ.
Wait, 1 minute.
Then, my lord, last line in that, ವಿಶೇಷ ತನಿಖಾ ತಂಡವು ಮೇಲ್ಕಂಡ ಪ್ರಕರಣಗಳು ಮೇಲ್ಕಂಡ ಶಾಸಕರುಗಳ ವಿರುದ್ಧ ದಾಖಲಾಗಿ ಇತರ ಎಲ್ಲಾ ಪ್ರಕರಣಗಳ ಸಮಗ್ರ ತನಿಖೆಯನ್ನು ನಡೆಸಿ, ಅದು ಇವರು ಬರೀ ಇದನ್ನ ಹೇಳಿದಾಗಲ್ಲ, ತನಿಖಾ ವರದಿಯನ್ನು ಮಹಾನಿರ್ದೇಶಕರು ಆರಕ್ಷಣೆ ಬೆಂಗಳೂರವರ ಮುಖಾಂತರ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಇಟ್ ಡಸಂಟ್ ಬಿಕಮ್ ಎ ರಿಪೋರ್ಟ್ ವಿಚ್ ಕ್ಯಾನ್ ಬಿ ಸಬ್ಮಿಟೆಡ್ ಟು ದಿ court. My learned friend referred to this Vineet Narayan case, my lord. Kindly see that.
Narayan ಅದಕ್ಕೆ ಅಷ್ಟೇ. It's
What?
not that on that point. ಇದಯ ಒಂದನ್ is what is on the point.
Which one, my lord?
ಅದು ಜಸ್ಟಿಸ್ ಕೇಶವ ನಾರಾಯಣ್ ಅವ್ರದ್ದು
Keshava.
ಅಲ್ಲ ವಿನೀತ್ ನಾರಾಯಣ್, ಅದೇ ಕೇಶವ ನಾರಾಯಣ್, that is a case of a metropolitan task force.
BMTC, I know.
That is a
Whether that is
entirely
a police
different-
station or not.
Yeah, that is a different issue. There in Vineet Narayan case ಅಲ್ಲಿ The Supreme Court definitely said that he can only call for information. But this court specifically says, however, all the powers of a minister are subject to the condition that none of them would extend to permit the minister to interfere with the course of investigation and prosecution in any individual case. In that respect, the officer consent ought to be governed entirely by the mandate of the law. Now, where does the law apply? Particularly in the background of a case where political vendetta is being alleged.
Oh, that's drop. We are not going to get into that. We'll answer it legally.
In fact, Vineet Narayan, my lord, page 258. Page 258 by referring other judgment of Supreme Court.
Abhinandan Jha.
Not that. Page 258, my lord.
Yes.
Para 5 is the earlier judgment. They're talking about. According to the Code of Criminal Procedure Code, the information of the opinion as to whether or not the case is to be placed, case to
We'll
place.
answer it.
Yes.
And we'll answer
Then it
it
says
soon.
the minister's
ಬೇರೆ
power
ಎಲ್ಲ
is-
ಇದಕ್ಕೆ ಸ್ಥಗಿತವಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಲ್ಪ.
Apart from the issue of SIT, my lord, the complaint is filed in respect of incident takes place from
Delay,
19
yes.
to 20. Is only one of
We'll
the
consider
points.
that delay.
In this, my lord, in this judgment, Kutra, para 4, my lord, the court specifically says the court, the authorities are bound to go only according to the statutory provision.
Yes.
Mandate of the law. They say specifically says no minister can tell him that he must or must not keep observation of the place. He must or must not prosecute this man.
That's the only thing that is now to be decided. The manner in which you word the.
To that extent, my lord, we will.
Allah,
the manner in which you word it. The correct word ಮಾಡಕ್ಕೆ.
Yes, that's the only. That
Allah,
aspect-
And constitution correct ಮಾಡಿ.
This point was raised at the initial stage, but Leonard Friend said, now hige ಮಾಡೋದು ಎಲ್ಲ ಕೇಸಲ್ಲೂ.
ಹೌದಾ?
No, I didn't say that. My senior friend has to be here. I said
Heard the
almost
Leonard
all the
Friend.
notifications I have seen till now is
That is
ordered.
why I'm telling, take corrective steps. Jagdish ಅವ್ರಿಗೂ ಹೇಳಿದೆ ನಾನು.
Yes.
ಕೆಲವ್ದ್ರೆಲ್ಲ, see, these are the loopholes that you live where
Yes.
investigation, you can't discover the truth at all with these technicalities.
One issue with Vineet Narayan judgment also recognized, madam, in para 27 and 29. They say the funds of the state has been invested in this organization. The state has to know how the funds have been expended. Only to that extent.
To
this-
that extent, that is, otherwise there is nothing. To that extent, because they need to know what has happened. That's why we called it as a status report, my lord, instead of final report.
ಇನ್ನೊಂದಿದೆಯಾ ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ 5 ಕರೆದ್ಬಿಡಿ, ಆಮೇಲೆ 12:30 ಮಾಡ್ತೇವೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ 5 ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಮಾತ್ರ ಒಂದೇ ಇರೋದು ಬಾಕಿ.
Well, 5 has to be tagged with 3, my lord, is the co-accused.
5 and 3 will go together.
4.
Fine, yes.
Serial number 4, interim order.
Interim, I can continue. I heard reserved, heard the learned senior counsel Ashok Karnali, learned additional advocate general Pradeep and so Jagdish, ಎಲ್ಲರದು ಹಾಕ್ಬಿಟ್ಟು heard reserved, interim order subsisting will continue to the next date. 12:30 matter.
Well, item number 5.
5 is on same day, sir, of 3.
7th March, my lord.
7th March, yes.
Grateful, my lord.
Lordship, kind leave, your Lordship. Lordship, there's the Bangalore list. Serial number 32 is a fresh matter with the demand notice pro rata.
Wait.
Please.
Yes, sir.
Serial number 5.
Ah.
I'm in 5.
5 alla. 5 is, you are in 5.
Lord, your Lordship heard me on the previous date of hearing, and my Lord friend Mr. Prasanna Kumar was not immediately available to us.
7th ಗೆ ತಗೊಂಡ್ರಲ್ಲ ಮತ್ತೆ.
ಅಲ್ಲ, ನನಗೆ I have sought for stay and your Lordship heard me in.
ಅಲ್ಲ, I will post it on 7th. ಅದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದನ್ನೇ. You in the interregnum ಅಲ್ಲಿ applications ಹಾಕಿ ಅಷ್ಟೇ. Same order.
ಇಲ್ಲ, ನಂದು it stands totally on a different footing. In as much as the procedure, in fact, your Lordship has recorded it also. The procedure which came to be followed is totally different. It goes to the root of the matter itself is your Lordship's prima facie finding.
The matter of co-accused is on 7th, my lords.
One moment, sir, one moment. I don't know what order I have passed.
Let him not record any, let the trial court record any further proceedings in the case. Well, may I just invite your Lordship's kind attention to section 223, BNSS. May I make myself?
Yes.
Please. Well, for the purpose of taking cognizance of.
197 of CRPC.
Alala, I am not on.
223 is private complaint.
Oh, private complaint too. That is how the Supreme Court has said.
Latest judgment.
How that is the Justice
It should
Lucas.
be heard prior to taking of cognizance.
Well, the problem is this. For the purpose of taking cognizance, he has got to issue notice to the accused. It leaves no doubt. In fact, it is covered by Your Lordship's judgment as to what is the procedure which the court is required to follow. The only privilege a public servant gets is dispensation with the recording of the sworn statement of the complainant and the witnesses, if any, present.
No, that does not obviate the procedure.
In fact, Your Lordship has also ruled in Vinay Kulkarni's case under 195 capital A.
340 procedure.
Yes, it will not take away the procedure which is required to follow. Here, what the learned trial judge does it, he will straight away issue summons without even issuance of notice. That is impermissible. In fact, that is a law on the point.
But the same issue is there in the other matter. It can be heard on the same
No,
issue.
let it be there. That is a different issue. Let me have the benefit.
It's the same issue is
If I am able to persuade Your Lordship to my line of thinking, let there be an intermodal in my favor.
What is the next date?
Well, now to hear arguments before charge.
The argument.
In fact, tomorrow, my Lord has passed an interim order. On
Why
first
should
day-
the arguments
No,
of
no,
other
ಏನಾಯ್ತು ಅಂತ
accused
ಹೇಳ್ತೀನಿ
are
ನಾನು.
not connected with this be deferred?
No, I'm sorry, sir. Please just bear with me for a minute.
This is,
In fact, my Lord said, let him not proceed to frame the charge.
where is it?
Then, ಹೇಳ್ತಿದ್ದಾರೆ ಏನಾಯ್ತು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ. Kumar was there with us on that day.
No.
In fact, I submitted to Your Lordship.
Liberty to move the court in the event the concerned court posts the matter for hearing the framing of charge.
Yes, quite right. In fact, Your Lordship even went to the extent of saying, let him not proceed to frame the charges. Upon a submission which came to be made by me, if the trial court is precluded from proceeding to frame a charge, it is as good as me considering that the procedure which he is following is right. In that view of the matter, Your Lordship said, subsequent thereto, it involves the question of jurisdiction of the court in entertaining the complaint itself and the procedure which is required to follow. Well, now if my Lord is persuaded to accept my submissions prima facie, I am not on the merits of the matter at all. I am basically on two important and serious legal issues. What is the procedure which he has followed?
Where is the order?
Yes, my Lord. Straight away he goes. May I request Your Lordship to kindly
At best, what would happen is issuance of summons will go, or he has to redo the procedure.
Quite right.
Yes.
Now, why should he proceed to hear me?
At best, I said.
Yes,
Where
my
is
Lord.
the order?
Yes,
Where
my
is the
Lord, let
order?
him. Your
Where is the
Lordship may
order?
kindly grant me a limited stay, at least till the next
Where is
day.
the order?
Yes, ma'am. 357, volume 2. ಏನು ಹೇಳೋದೇ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಹುಡುಕ್ತಾನೆ ಇರ್ತಾರೆ. ಅಲ್ಲ ಸರ್. ತಪ್ಪು. Kindly go to page 390. Well, this complaint is on 9/9/2024, subsequent to 1/7/2024.
Complaint itself is after.
Yes, my
this.
lord. And then the cognizance is on 5/10/2024. That is my submission. And Your Lordship's ruling of a coordinate bench of this honorable court, no, you can't do it. But I will have an opportunity under section 223 itself to appear before the magistrate in the event of the magistrate choosing to issue a notice to me to tell him not to issue process.
These are ED proceedings.
Yes, my lord. But we are not on the merits of the matter.
Yes, sir.
Kindly have a look at 511. But today, my lord, no prejudice. If ultimately the matter is allowed, he will get a right to be heard.
Yes.
There is no prejudice because if it's not, ultimately, my lord, here's today nothing is going to, heavens are not going to fall. There's going to be arguments on charge. At the most, he may not argue on charge. Other accused, why should the proceedings of other accused be stayed? Number one, his arguments can be deferred to some time. But if ultimately, even if he succeeds, the ultimate, it's not that the proceedings will be quashed. He will be given an opportunity to be heard.
That is what I.
Having the advantage.
That can
And,
happen.
and ultimately,
First stage is no summons at all. I'll be losing that advantage that is given to me under the statute.
511, the requirements 5, whereas he pleaded prejudice.
There is a statutory requirement.
511, If an order has to be set aside, he must plead and prove prejudice. Where is that?
Well,
Therefore,
see, then
arguable, he
we'll
can't-
take it,
the
we'll take
matter
it on the
is plain and
27th.
Page
when
200.
I'm-
Page 200.
Well, I am supported by judgment of the Supreme Court.
No,
Your
no,
Lordship's
let
order.
us judgment.
Order of
I
Honorable
appeared in that
Justice
judgment of the Supreme
Natarajan. And even under the old code also, my lord, 1908 code and then 73 code, there are
There
a
are
number of
judgments
judgments of the
which
Supreme Court. The procedure which the court is required to follow as amended, which would come into effect from 1/7/2024. Here the complaint itself is in September 2024, subsequent to 1/7.
ECIR is dated 6/6/2024.
ನೀವು ರಿಜಿಸ್ಟರ್ ಮಾಡೋದಲ್ಲ.
And investigation is conducted.
Yes.
And section 531 of BNSS not would save
Let us.
the investigation will not also.
Now, investigation commenced prior to BNS.
Please, madam.
Yes.
Where is the complaint? The complaint haledu, it's an old complaint.
Yes, my lord, welcome.
ಅಲ್ಲ, ECIR ಅಲ್ಲಲ್ಲ, ECIR.
Predicate offense is old.
Predicate offense is old.
Now
ECIR is by us.
ECIR is by you.
6/6/24. ECIR not culminates into this complaint.
ECIR.
6/6/24. That's what I was bringing to your lordship kind notice, page 200.
Page, I'm at 200.
ಅಲ್ಲಿ 4 ಲೈನ್ ಆದ್ಮೇಲೆ ECIR number so and so dated 6/6/2024 ಅಂತ ನನಗೆ ಕೊಟ್ಟಿರೋ ಇದರಲ್ಲಿ page 200 ಇದೆ. This is internal page number 7 of
7, correct.
7 ಅದರಲ್ಲಿ ಮೇಲ್ಗಡೆ
ECR, correct.
6/6/24 on investigation.
After preliminary inquiry, the Directorate of
But
Enforcement
your
recorded
occupant
an
take it, there
ECIR
is no dispute, there is no quarrel. with-
ECIR
Yes, there is no quarrel.
dated 6/6/2024 investigation.
No quarrel.
Which complaint is September 2024?
My lord, private complaint before the court.
No, this complaint ECIR register.
But ECIR in investigation into ECIR would
Now,
culminate not into a
Now
complaint.
the hearing before charge is taking place on the ECIR or on the private?
Private complaint.
ECIR not culminates into a complaint.
Private complaint.
Private.
So this ECIR you.
FIR will culminate into not a final report.
No,
charge
1
sheet.
minute. 6/6/2024 ECIR
ECIR has
is
culminated
registered.
into not a complaint.
No, 1 minute. Investigation you began after registration of the ECIR.
Please, madam.
After the investigation commenced, you file a complaint, which
Please.
is in the nature of a charge sheet under 173(2), correct?
Please. So this is saved not under section 530.
Let us read.
Of BNSS.
Have a look at 531. Let us see. And the law on the point and what his lordship has said in the other case.
BNSS.
Therefore, all this will have to be re-argued on the 7th, my lord. That's my only.
Quite right.
All this will have to be re-argued
There
on
be
the
a
7th.
stay.
One
No, there
moment.
can't be a stay in this matter of this
One
type.
moment. One moment.
That is what you say. I say there should be a stay.
531.
Huge public monies have been siphoned out.
531, my lords, repeal and savings. If immediately before the date on which the Sanhita comes into force, there is an appeal, application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, nothing is pending. The
No.
first thing is, in September 2024, you would file it.
No, at that time inquiry
No
was pending.
inquiry, no trial, no application.
Investigation is.
Inquiry and
Let
investigation
the
both-
investigation continue. I am not on the question of investigation.
No,
That is what the Supreme Court has said.
no, inquiry, ED inquiry was pending.
Let them continue with the inquiry. Let them continue with the
No.
investigation.
Everything else will be according to the old code.
Registration of, sir, registration of ECIR has taken place prior to BNSS. Investigation commences prior to BNSS. What is filed by the Enforcement Directorate before the concerned court is a complaint which is in the nature of a report
charge sheet.
under 173(2) of the CRPC, correct? So
there
if the
probably I may-
if the investigation has commenced earlier and it is placed, a final report is placed, investigation is only in prior to BNSS and final report of filing. Now, whether an investigation that commences prior to BNSS and saved under 531 while resulting in a final report, what procedure should be followed, whether it is under the CRPC or under the BNSS?
That if it-
Now, if it is under the BNSS, while taking of cognizance, you have to be heard, it's a different thing. But those complaints in prima facie view should emerge after 1/7/2024.
This honorable court has said it is only under BNS.
Please.
BNSS.
Just-
May I invite your lordship's kind attention?
Justice Natarajan order.
Justice Natarajan's statement.
Kalburgi.
Kalburgi.
Hmm.
My lord, page 17.
1.
17. In page 17.
Hmm.
What is the procedure to be followed? My lord, may I request your lordship to kindly turn to first paragraph 19.
Hmm.
My lord gets it?
Hmm.
Paragraph 19. Really, sir, which is the page? At page 23.
Hmm.
On careful reading of section 531, subclause 2, subclause A of BNSS, which clearly defines that any appeal, application, trial, inquiry, investigation pending on the date of prior to the commencement of the BNSS, then such appeal, application, trial, inquiry, investigation shall be continued in accordance with the Code of Criminal Procedure 1973.
Para 4.
Yes, but herein, this case, there is no investigation pending prior to the commencement of BNSS in order to investigate the matter into CRPC. It is a clear case that the complainant can be filed on 1/7/2024 on the date of commencement of BNSS.
Complaint itself is filed on
1/7.
1/7/2024.
ಇದರಲ್ಲಿ
ಅದರಲ್ಲೇ
ನಮ್ಮದ್ರಲ್ಲಿ subsequent to.
No, no, no. Complaint is final report.
ಅಲ್ಲ, complaint is before
Sir,
the court.
Enforcement Directorate filing its complaint is a final report under 173(2). It is not registration of the crime.
No, my lord, here in the,
EIR is registered on 6/6/2024.
no. Complaint before the court is filed on
That is the
1/7/2024.
charge sheet. ಅದ್ರ ಮೇಲೆ cognizance ತಗೊಂಡಿರೋದು.
ಹೌದು, ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡೋದು September
That is
2024.
not the complaint that you refer under the CRP.
No, my lord, that is ECIR. What they are referring to is ECIR. ECIR is not a complaint.
One minute, sir. If
Here
I'm
is
wrong,
the
correct me.
beginning of investigation.
1 minute. ECIR is equivalent to FIR. No qualm about it. So ECIR gets registered on 6/6/24, investigation commences, final report is filed after the BNSS. That is final report is, they term it as complaint. Even in this, in NDPS and EC, both they term it as complaint. That complaint is the final report filed before the concerned court. That can, for that BNSS procedure need not be followed. Prima facie.
Paragraph number
May I
100
request your lordship
of
now?
Viswanatha
His lordship has
Vijay
further
Madalla.
clarified.
Judgment.
No, his lordship has further clarified it.
Paragraph number
May I
100 of
request
Vijay
your
Madalla.
lordship?
Para.
Sorry, sir, one ನಿಮಿಷ. Paragraph itself is not properly meant. Kindly go to page 24.
To give the judgment.
In page 24, very next page, my lord.
Hmm.
Lord, on the basis of the above analysis, this court is also summarizing the law regarding the effect of repealing of IPC and CRPC by BNS and BNSS respectively, and the same is being mentioned as below. If an FIR is registered on or after 1/7/2024,
Correct.
for the offense committed prior to 1/7/2024,
Yes.
then the FIR will be registered under the provisions of IPC, but the investigation will continue as per BNSS.
So what happens is, sometimes police, because of this transitionary teething problems, they may register an FIR in under the IPC instead of BNS. So there, what, it is on 1/7/2024. BNSS procedure ಮಾಡಬೇಕು ಅಂದ್ರೆ ಆ ಕೇಸಲ್ಲಿ because FIR is
ಇಲ್ಲ.
on that day.
No, Roman 3. Have a look at Roman 3, my lord.
Yes, sir.
Have a look at Roman 3. The cognizance on the pending investigation on or after 1/7/2024 would be taken as per the BNSS. And all the subsequent proceedings, including inquiry, trial or appeal, would be conducted as per the procedure laid down under BNSS.
Provided FIR.
Unless my lord were to dissent from this judgment, which has thereafter has got to go to the division bench and all that, whatever it may be. Whatever it may be.
FIR itself is on
That is the law.
That will see.
Not para 3, FIR itself is on 1/7/24.
That is
Clearly
invalid by the
FIR was after
Para
the
three.
coordinate bench of
came
this
into
court.
court.
In fact, I can
It's
even
not
take your
clear on
lordship
my
to what the
learning.
Supreme Court has said. No. First, my lord, may I invite your lordship can attention to the first judgment of the Supreme Court. My lord, ink page 1.
May I know the name of the case, please?
No, this is Ramesh Chandra's case.
Clause 4.
I'm sorry.
ಅಲ್ಲ ಇದರಲ್ಲೇ 3 ಆಯ್ತು. 3 ಆದ್ಮೇಲೆ 4.
Not.
531.
ಹೌದು. 531 2A of BNS saved only pending investigation.
Yes.
Pending investigation.
ಹಾ.
Yes.
Trial. ಇಲ್ಲಿ ಟ್ರಯಲ್ ಇಲ್ಲ.
ಆಯ್ತು.
ಅಪೀಲ್ ಇಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ, ಎನ್ಕ್ವೈರಿನೂ ಇಲ್ಲ, ಯಾವುದೂ ಇಲ್ಲ ಇಲ್ಲಿ. ಎಲ್ಲಿದೆ enquiry?
ಮುಂದೆ ಮುಂದೆ.
ಹೌದು. Therefore, if any trial, appeal, revision or application is commenced after 1724, the same will be proceeded as per the procedure of BNSS. ಇಲ್ಲಿ ನಮ್ದು ಅಷ್ಟೇ BNSS procedure ಪ್ರಕಾರ ಫಾಲೋ ಮಾಡಬೇಕು. That would be my respectful submission. How far your lordship would agree with me, we'll have to wait, watch and see. Anyway, for the purpose of consideration of my request for an interim order, I'm sure your lordship would certainly agree with me that I have an arguable point.
Absolutely not.
Ultimately, your lordship may accept, may not accept. Now, may I invite your lordship to the judgment of the Supreme Court? In page 1 minute.
My learned friend is referring to judgments. He is not telling me the name of the judgment. This is very unfair on his part.
No,
I
this
am
is.
in the dark.
Sir,
What
we have
judgment
already
is
given it to
going
the council and
Can
recorded
you
the
not
case.
give a citation? Can you not give the name? It's simple, basic etiquette.
I've just sent
You
him.
please tell.
Well, this is Punjab and Haryana. Then I shall take your lordship to the Supreme Court.
Punjab and Haryana, 1976.
ಹೌದೌದು.
ಹಾ.
ಯಾತಕ್ಕೆ ಅಂದ್ರೆ ಅದು 1908 ಕೋಡು 1973 ಕೋಡು ಅಲ್ಲೂ ಸೇವಿಂಗ್ಸ್. ವಾಟ್ ಇಸ್ ದ ಪ್ರೊಸೀಜರ್ ದಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು
What
ಬಿ
is the
ಫಾಲೋಡ್?
effect of repeal and saving?
Repeal and savings. Kindly go to paragraph 9.
One minute. ASD sir, this is 1976 SEC online
1976
P and
SEC
H
online P&H
139.
139.
Name of the case, please.
Name of the party is Ramesh Chandar and
Ramesh
others.
Chandar versus Chandigarh
Chandigarh
administration.
administration. Kindly go to paragraph 9 minute for a second at page 5.
Hmm.
I most respectfully agree with the aforesaid view of the full bench and hold that if a proceeding is initiated by presenting a challenge subsequent to the commencement of the new court, kindly mark this, my lord.
Chalan
Subsequent,
is the charge sheet. Yes.
yes, my lord.
Yes, yes.
Subsequent to the commencement of the new court, in respect to the act or omission committed prior to the coming into the force of the new court, it would only be governed by the provisions of the new court, because when the investigation is initiated in respect to the alleged offense before coming into force of the new court, the investigation has to be made according to the provisions of the old court, and on
Yeah,
completion
right.
of such investigation, further steps has to be taken. This is what the Punjab and Haryana High Court has said. Well, next, kindly, any number of judgments. Now kindly go to
They're all in
next
my
judgment.
favor, my lord.
Allahabad High Court.
Ah.
Allahabad High Court at page 7.
2024 SSC
That is a
online
Deepu's
Allahabad
case.
4289.
Deepu's case. In fact, a coordinated bench of this court would follow Deepu's case.
That Natarajan avardu.
ಹೌದು, ನಟರಾಜನ್ ಅವರು.
Yes,
ಹೌದು.
yes.
Now kindly go to paragraph 16. What is the procedure to be followed? 1(6).
Yes.
On the basis, my lord, at ink page 14,
Yes.
1(6). On the basis of the above analysis, this court is also summarizing the law regarding the effect of repealing the IPC and CRPC by BNS and BNSS respectively, and the same is mentioned as below. If an FIR is registered on or after 1/7/2024 for the offense committed prior to 1/7/2024, then the FIR would be registered under the provisions of IPC, but the investigation will continue as per BNSS. In the pending investigation on 1/7/2024, on the date of the commencement of the new criminal laws, investigation will continue as per the CRPC till the cognizance is taken on the police report. And if any direction is made for further investigation by the competent court, then the same will continue as per CRPC. The cognizance on the pending investigation on or after 1/7/2024 would be taken as per the BNSS, and all the subsequent proceedings, including inquiry, trial, or appeal, would be conducted as per the procedure of BNSS. Any number of judgments, my lord?
That is provided FIR is registered afterwards.
All right.
Yes.
Well, for the time being, my lord, if my lord feels that I have been able to persuade your lordship that I have an arguable point, a point which warrants consideration at your lordship's hands, because it involves a serious legal issue. The second legal issue which I have raised is 197. No, 197 is applicable, is what his lordship has said. Justice Oka, your lordship has referred to it. But here,
ಇದರಲ್ಲಿ sanction ಇಲ್ವಾ?
ಇಲ್ಲ, sanction ಇಲ್ಲ. But ಅವರು ಹೇಳ್ತಾರೆ, as a minister you have done it ಅಂತ. ತೋರಿಸ್ತೀನಿ ನಾನು ಬೇಕಾದ್ರೆ ಅದನ್ನು. ಅದಾದ್ಮೇಲೆ ನೋಡೋಣ ಅದನ್ನು.
What are the sections?
What his lordship, Justice Oka would say, may I request your lordship to kindly go to page 33 for a second. 39 for a second. Well, may I request your lordship to
197 is.
Yes, 197 is applicable.
I had appeared in the matter, I know, my lord.
In fact, my lord, the Delhi High Court, my lord, it is not a authority on the point. How the Delhi High Court is considered? May I invite your lordship's kind attention? Kindly turn to page 48, my lord, for a second. Well, I'm not quoting this as an authority on the point. Your lordship may take it from me. I'm highly conscious. It is an order which can be passed on the request made by the party concerned for an order of stay for further proceedings. It is not an authority on the point. But the approach which can be made by the other court, but may I invite your lordship's kind attention to page 48. Kindly go to paragraph 4.
Paragraph 5.
Paragraph 5. In the present case, the petitioner being a public servant and the commission of offence by him while being a public servant not being in dispute, the challenge to the legality of order of taking cognizance and continuation of proceedings for want of sanction in the light of allegations leveled in prosecution complaint would require further consideration. Now, I'm only submitting this, my lord, to bring it to your lordship's notice, the approach which came to be made by the Delhi High Court. Not that it is a precedent. I'm highly conscious of the fact that it can't be a precedent. My lord, what the Supreme Court has said in 2024, well, at page 39, in fact, the Delhi High Court, for the purpose of granting an intermodal in favor of the petitioner, would refer to this judgment of the Supreme Court. But may I request your lordship to kindly turn to page. First, we will go to 41, my lord, paragraph 5.
Paragraph 5, yes.
At least let him not proceed to hear us. That's all what I'm saying.
Pass order.
If he poster ಏನಿದೆ ನಾಳೆನೇ ಹಿಯರ್ ಮಾಡಬೇಕು ಅಂತ ಏನಿಲ್ಲ ಇವತ್ತು ಆಗೋದು ನಾಳೆ ಆಗುತ್ತೆ ನಾಳೆ ಆಗೋದು ನಾಡಿದ್ದಾಗುತ್ತೆ ಅಷ್ಟೇ ತಾನೆ. If I were to succeed,
on the reverse ಹೇಳಿದ್ರೆ ನಾಳೆ ಮಾಡೋದನ್ನ ಇವತ್ತೇ ಮಾಡಿ ಇವತ್ತೇ ಮಾಡೋದನ್ನ ಈಗ.
all right. Supposing my lord, if it is heard and he proceeds to claim it. Idರಲ್ಲಿ
lighter way.
Am I not entitled for the benefit?
No, he must be following that principle.
A statutory protection that is given to him under 223. It is a statutory protection. Am I not going? What happens ಅಂತ ನಾವು ಪ್ರಶ್ನೆ ಅಲ್ಲ. ನೀವು discharge ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನಾವು ಪ್ರಶ್ನೆ ಅಲ್ಲ. ನನಗೆ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡ್ಕೊಡುದು ಅಂತ ನನಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಇರಬೇಕಾದ್ರೆ why should I appear before the court and argue for discharge?
And may I also pass on Om Prakash Yadav's may not judgment on sanction, whether it is automatic or whether it should be determined, not based on the misuse of on Om Prakash Yadav's case. Detailed discussion has been made with the Honorable Apex Court recently. Sanction law is totally summarized, and it said merely because a public servant is involved in an offence, the sanction would not become automatic. And office should not be.
No, if you see Om Prakash Yadav, if there is nexus in the allegations leveled against a public servant, nexus to the discharge.
Relatable to the discharge of his duties.
Nexus related to the discharge of official duties, yes, is protected under 197. It's old 1955. It's not that. Yes.
All these are.
But may I invite your lordship can attention?
Discharge of duty or not.
Kindly go to page 298 for a second.
Pass order set.
Public servant at as a minister, as a public servant, you have done it.
He wants to continuously argue.
2 o'clock.
Arguments.
I'll resume early at 2 o'clock. Yes.
Your lordship
finish your lunch in 20 minutes and come.
I have nothing more to submit, my lord.
I'll pass orders.
May
I am required in the Supreme Court, my lord. May I only come a little late, my lord, in that case?
You want to appear late?
Yes, my matter is there. It will be called out.
Right. No, when what time you want me to take this? I'll take it, sir.
My lords may continue.
Wait, sir. Alva, sir. Salpa.
My lords, with permission, my lords, may I make a mention, my lord? I have joined.
One moment, sir. One moment.
3 o'clock, 3:15.
All right. 3:30.
My lords, with permission, my lords, may I?
Yes, sir.
My lords, I have joined the proceedings from Delhi, my lords. In item number 27, squarely covered by your lordship judgment, there's an office note. A similar petition has been dismissed on.
Which list?
My lords, I've been told Dharwad list, my lords, item 27, a criminal petition number 13702/2024.
Your
Oh,
lordship.
this Kumaresan.
Yes, my lords, and your lordships
Kannada,
have already dismissed.
Tamil translation.
My lords, this petition, the co-accused petition has been dismissed by your lordship's order dated 3rd of December by a 9-page order, my lords. He's a co-accused. That's the only thing. And the office note also says so.
You are for the respondent, is it?
Yes, my
Your
lords.
lordship,
I
I'm
appeared
for the-
for complainant physically when your lordship was in back.
I'll take up the matter. Wait. Yes.
Okay, my lords. Great. I'll wait.
Let's request to make a mention.
ಇದಕ್ಕೇನೆ
Lordship's kind permission, my lord.
Serial number 20, my lord. Can I seek a short accommodation, my lord? Serial number 20, Bangalore list, my lord.
You are online, sir. Wait. Yes.
Right.
Serial number 30, lordship. Morning it was taken. Senior counsel Ramdas appeared and Monday it was posted.
Entry order extend ಮಾಡಿದ್ದೀನಿ.
Tuesday ಅನ್ನೋದು ಅವ್ರ personal inconvenience.
ಆಯ್ತು ಟ್ಯೂಸ್ಡೇ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
Serial number 17, your lordship.
ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ ಬನ್ನಿ ಊಟ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Lord,
serial number 58 Dharwad.
Court officer. Madam, serial number 16, madam.
30 other. 25. Madam.
Sir, VC ಹೇಳಿ sir. ಮಯೂರ್ sir.
Madam, serial number 16 Monday ಗೆ ಅಂತ ಇದ್ದಿದ್ದು madam ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟಿದೆ.
16.
Yes, madam. 1616.
Monday date ಇತ್ತಾ?
Monday ಬರಬೇಕಾಗಿತ್ತು madam. ಇಲ್ಲಿ file was sent for the purpose of coming on Monday. ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟಿದೆ. ಮೊನ್ನೆ ರಿಸರ್ವ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್ 31069 ಅದರ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದು.
ಕನೆಕ್ಟೆಡ್ ಆಯ್ತು.
ಹಾ ಮೇಡಮ್.
ಆಮೇಲೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್. ಮಂಡೇ ತಗೊಳ್ತಾರೆ.
ಡನ್ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಮೇಡಮ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಇದೆ ಅಲ್ಲ ಮೇಡಮ್?
ಹಾ ಇದೆ ಮೇಡಮ್.
ಓಕೆ. ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಅಲ್ಲ ಲಿಸ್ಟ್?
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಮೇಡಮ್.
ಥ್ಯಾಂಕ್ ಯು.
May I mention, my lords? 101 serial number, Dharwad list, my lords. Muhammad Tahir sir is was supposed to appear. He's online, my lords.
101.
Yes, sir. And mutation entry is changed by the AC.
I'll take it up. We'll take it, sir.
Okay.
Yes.
Please, sir.
Your Lordship, if your Lordship permits, may I make one submission?
Yes.
Your Lordship, this is with regards to case serial number 15 in Bengaluru list, Your Lordship.
50.
15. For Mahesh Kiran Shetty. Your Lordship, we have filed an IA for modification of the tablet.
No, it has to be posted. It has to be posted before Justice Hemant Chandran Gaur. It is already sent. I have signed it. You move it there. Yes.
Yes, Your Lordship. Grateful.
2:30 matter ready there. Yes. The 2:30 matter you ready? ಇಲ್ಲ 2:30 ಬೇರೆ ಇದೆ
30 ಬೇರೆ ಇದೆ 12:30 ಬೇರೆ ಇದೆ
ಗೊತ್ತಾಯ್ತು 2:30 ಇರೋದ್ರಿಂದ ವಿಲ್ ಟೇಕ್ ದಟ್ 12:30 ಆಮೇಲೆ ತಗೊಳ್ಳಿ
My lords, I just was thinking of, my lords, item, I mean, I don't know the functioning, my lords. I was just watching item 27 in the Dharwad, in the Bangalore list, my lords.
27?
27, my lords, criminal petition number 13702 of your lordship's cause list. My lords, it will be taken at 2 or means I'm calling, I'm checking from Delhi.
No,
I don't know.
I'll take it up. Yes. No, I forget your name. Sorry.
Manoj Taneja, ma'am. Sorry, sir. Manoj Taneja.
No, this has to be. This is what following RS5. But that is stayed in the Supreme Court.
My lords, we haven't got any notice, my lords.
Because I got the notice from. I mean, like you get that information from the Supreme Court. What is stayed? That has come to the RS5 follow Madi. I said idalva, not his.
No, my lord, your lordship's order dated 3rd December has been stayed.
Your Lordship, I'm for the.
No, it's not stayed, is it?
No, my lords, it's disposed of.
Your Lordship, I'm for the petitioner, proxy counsel, Your Lordship. Or,
No, I'm not granting time in that. This has to go. I have dismissed the co-accused. I will not hold this on. Yes.
That's all, my lords.
Don't seek time in that. Yes.
Swami,
Wait, before the end of the day, I will call the cases. Then we'll do it.
Okay, my lords. Please, my
yes.
My lord, in this 12:30 matter. Yesterday evening, they served me an affidavit sworn by one Aishwarya Gowda. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಐಶ್ವರ್ಯ ಗೌಡ ಇಸ್ ನೋವೇರ್ ಪಾರ್ಟಿ ಇನ್ ದಿಸ್ ಕೇಸ್. ಒಂದು ಅಫಿಡೇವಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ ರಿಗಾರ್ಡಿಂಗ್ ದಟ್ ಪೆನ್ ಡ್ರೈವ್. ಲಾಸ್ಟ್ ಒಕೇಶನ್ ಪೆನ್ ಡ್ರೈವ್ ಕೊಟ್ಟರು, ಅದ್ರ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಕೊಡಿ ಅಂತ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರ ಜೊತೆಲಿ ಒಂದು ಅಫಿಡೇವಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಐ ಥಿಂಕ್ ಐ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಕೌಂಟರ್ ದಟ್. ನಿನ್ನೆ ಸಂಜೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ. ಕೋರ್ಟಿಗೆ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
No, I'll take it up. Wait. Yes. I will take it up. ಈಗ ಯಾವ್ದು ತಗೋಣ? 12:30 or 2:30? Arvind Kamath sir ಇದೆ.
We are ready.
Yes. Immediately after this 2:30 matter, I'll take up the 12:30 matter. Ram Sundar sir is in 12:30.
Yes, there is one more matter also, but
fine. Yes, all good. Thank you, sir. Thank you. Objections ಹಾಕಿದಾರಾ?
Objections ನೆನ್ನೆ ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್.
ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲಪ್ಪ, ಇಲ್ಲಿ ಕೋರ್ಟ್
ಇನ್ನೊಂದು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಇಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಸ್ಟರ್ಡೇ ವಿ ಹ್ಯಾವ್ ಫೈಲ್.
ಅಲ್ಲ ಕೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ರಿಜಿಸ್ಟರ್ ಇಲ್ಲ, ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ?
ಇದು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟು.
ಅಲ್ಲ, ಇಲ್ಲಿ ನನಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾಗಾದ್ರೆ has been handed over. ಕೊಡಿ.
ನಂದ್ರಲ್ಲಿ ಒಂದು 144 pages ಇದೆ. ಐ ಥಿಂಕ್ ಸೀನಿಯರ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇರ್ಬೇಕು ಅದಕ್ಕಿಂತ.
ಇರ್ಲಿ, ಇನ್ನೊಂದಿಲ್ಲ, ಒಂದಾಯ್ತು, ಇನ್ನೊಂದು ಎಲ್ಲ ಒಂದೇ ಕನೆಕ್ಟೆಡ್. ಎಸ್ ಸರ್. ಈಗ ಯಾವ್ದು ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಕ್ರಿಮಿನಲ್ ಪೆಟಿಷನ್ 1132 of 2025.
Yes.
My lord should recollect, my lords. I had given a synopsis.
Yeah, I've seen.
Yes, my lords. If my lord would kindly have this synopsis, my lords, I will commence from there, from where I had stopped last time. Well, it's in the synopsis.
ಕೊಡಿ ಅದೇ objections ಮಾತ್ರ ಅಲ್ಲೇ ಇರ್ಲಿ yes
Synopsis, my lords. Page 1 of that synopsis, 3 dates, my lords, which will have relevance. My lords, the entire events that have taken place insofar as this case is concerned, it spans between 1992, my lords, preliminary notification, till, my lords, 5/1/2021. That date may be relevant, my lords. 5/1/2021. That was when, my lords, MUDA allots 14 sites in favor of the petitioner.
my judgment I
Yes,
know
my lords. So that date may be of some relevance because one of the aspects which we intend pointing out is the tearing hurry in which the ECIR is registered, which I will point out. Now, my lords, in that list of dates, 6 may be noticed, serial number 6, the date of registration of the FIR.
predicate offense
Predicate offense. 27/9/2024. My lords, on the previous day was the 156(3)
that time
order. So next day, the FIR comes to be registered. My lords, 7/1/10/2024, deed of cancellation where the 14 sites have been surrendered to MUDA. From this date on, the petitioner is neither in possession nor enjoying the so-called proceeds of crime. The very same day, my lords, when the property is returned to MUDA, the ECIR is registered, same day, 1/10/2024, which is on 4 days after the FIR in the predicate offense gets registered. Now, my lords, the last part where I mentioned there, the subject matter of that investigation and the subject matter of this inquiry appears to be one and the same. The illegal allotment of 14 sites to the petitioner. Now, with this, my lords, amongst the points that I have raised, which my lords would get in the index, my lords wanted to know on point number 7, as regard the enjoyment of a proceeds of crime, would it be a prerequisite for you to proceed under the PMLA Act? My lords may have page 20, where I have elaborated the aspects of enjoying the proceeds of a crime. My lords may notice there, one of the essential requirements to proceed under the provisions of PMLA Act is the need for the accused or any other person claiming through him to be enjoying the proceeds of crime at the time of initiation of the PMLA proceedings. I have extracted clause 2, which uses the word enjoyment, my lords. Then, but in any given case, if the alleged proceeds of crime have been returned back to the appropriate authorities and the person no longer enjoys the same, then the question of initiating the proceedings under PMLA Act does not arise. The object of the act itself is to prevent laundering, as I will show from that sketch, my lords, what laundering, and after interpretation in Vijay Madan Lal, what they say is the requirement, my lords. The object is to prevent laundering, and therefore, when the alleged proceeds of crime are returned back to the appropriate authorities, then the question of laundering does not arise. It may be a different scenario where post initiation of proceedings under the Act, an accused chooses to surrender any proceeds of the crime. In such a scenario, it is arguable as to whether the said act of returning the alleged proceeds of crime post initiation of the proceedings would only be looked into as a mitigating circumstance if it happens later. Unlike a case here, my lords, on 1/10, it was returned. They registered the ECIR on the same day, but they commenced all their inquiry thereafter. However, in the present case, the records disclose that even before the initiation of any action under the Act, be it attachment, adjudication, or confiscation, issuance of any summons under 50, initiation of any search or seizure, the property in question, that is the 14 sites, had already been surrendered to MUDA, and the petitioner was no longer enjoying the alleged proceeds of crime, warranting any initiation of the PMLA proceedings. Next page, let's post the surrender. The ED would get no jurisdiction to proceed under any provisions of the PMLA Act. The essential ingredient, as spelled out under Section 3 of the Act, are totally lacking. there was no alleged proceeds of the crime post 1/10/2024 so as to initiate any action under the PMLA Act. I have quoted Vijay Madanlal, which I'm going to be dealing more extensively, my lords. In Vijay Madanlal, though my lords has seen it, but in the aspect of saying what are the ingredients constituting 3, I will point that out, my lords. E, the present initiation of the proceedings by the ED is without the existence of any jurisdictional fact, and therefore all subsequent and consequential proceedings fall through. Latin maxim which my lords uses in a number of matters. Then, my lords, please notice the next page, my lords, there are 12 aspects that have to be fulfilled for the ED to assume jurisdiction. My lords, may just once quickly glance through those 12 aspects, my lords. In which, my lords, in that page, last but one which we get, such property should be projected as untainted money. This is diluted, my lords, in Vijay Madanlal, because they say that and to be read as or. So this is diluted. The rest of it remains, my lords, till the next page. Now, my lords, kindly now notice the diagram which we had put, my lords. My lords had seen it on the last occasion. Please notice page 17 for a minute, my lords. 17. My lords may notice the first column of collection of dirty money. Now, this is nothing but proceeds of the crime, my lords. From the scheduled offense, whatever that you get would be proceeds of the crime. But in the diagrams that we see, they use the word as dirty money, my lords. Now, post this, there has to be some activity for PMLA to kick in, because you need some element of laundering of that dirty money, my lords. That second aspect which my lords would get as placement. Now, under the PMLA Act, we would see they use the word process or activity. Now, process or activity, and it's an inclusive definition, my lords, which says it may include concealment, possession, acquisition, use, or projecting the property as untainted property. So this is insofar as placement is concerned, my lords. Then it would come to the aspect of layering. Again, they say or layering. So, my lords, one of the activities in this diagram would be necessary for you to proceed further under the PMLA. Just the existence of dirty money is not enough. You have to do a process or activity beyond that for it to become an offense under the PMLA. So this layering and integration, my lords, the usage of the word is or. So, my lords, with this, my lords, the entire argument of mine would be, my lords, to attract the provisions of PMLA, unless there is going to be any process or activity in furtherance of a proceeds of crime, the ingredients do not kick in. Now, my lords, while we're talking about process and activity, incidental aspects that come is possession. Whether would you have possession of the property, is it necessary for you to proceed under PMLA? And the enjoyment of that property, is it necessary for them to initiate action under the PMLA? These are incidental aspects that come in, my lords. And also, what would be the relevant date, my lords, when we say there is an offense under the PMLA? This, along with presumption under Section 24 of PMLA Act, all came up for consideration in Vijay Madanlal's case, my lords. Now, in Vijay Madanlal's case, when the constitutional validity of the act itself was challenged, my lords, the union would defend it through the learned Solicitor General of India and the Additional Solicitor General of India. Now, my lords, my emphasis in pointing out Vijay Madanlal is to see it from the point of view of the union itself as to how they foresaw this entire act and what are the requirements for the initiation of proceedings under the act. Now, for that, my lords, the entire aspect of Vijay Madanlal, and my lords, I'm leaving off the portion where the arguments on behalf of the petitioner challenging the constitutional validity, I'm leaving that portion completely, my lords. I will not go on that. I want to go more on the aspect of saying how the central government viewed this act and what, according to them, are the essential ingredients to constitute the offense. Now, in Vijay Madanlal's case, my lords, in that big compilation, my lords, it's at number 2. But my lords, what I thought would be more easy to follow on Vijay Madanlal is I've extracted it in accordance with the topic wise under Vijay Madanlal, my lords. It would make it a little easier. My lords, this is in specific reference to Vijay Madallal and Y. Balaji, my lords. These are the two judgments that I am going to be pointing out, which mandates a process or activity in furtherance of a proceeds of crime. My lords, kindly notice the first page, my lords, the three essentials to constitute the offense. The first, that the criminal activity relating to the schedule offense has been committed. This is a mandate. There should be a schedule offense committed. Second, my lords, that the property in question has been derived as a result of criminal activity. Now, this property is proceeds of the crime. That should have been derived. Third is the most essential ingredient, my lords, in page 1, that the person concerned is directly or indirectly involved in any process or activity connected with the said property. Now, my lords, in our case, kindly notice, my lords, 1/10/2024, the property is returned back. So, I'm sorry, two aspects there, my lords. The so-called proceeds of crime is no longer with the petitioner is one aspect. So to say that she is enjoying the proceeds of the crime doesn't arise. And definitely, my lords, the third aspect of saying she has done a process or an activity post that will definitely not be there. So this third ingredient which I have pointed out, my lords, if there's not going to be a process or activity, you can't initiate an action under PMLA. Now, my lords, please notice at page 1 in the bottom, once a proceeds of crime is established from a schedule offense, then the person concerned should have involved himself into a process or activity connected with the said proceeds of crime. My lords, on the next page, Vijay Madallal, my lords, if for any reason there is no process or activity in connection with the proceeds of crime, then the provisions of the act are inapplicable. This is how the Union of India, led by so-and-so, had interpreted the act in the case of Vijay Madallal, which till date holds the field, my lords. Even now, it's of precedential value. The said argument had also been advanced by so-and-so who supplemented the argument. Incidentally, the court would also interpret words such as need for possession, whether direct or indirect, dealing with proceeds of crime, and also the date from when it is to be held that an offense under the act has been committed. The court also interprets the legal presumption under 24. My lords, has gone to the next page, my lords. So, my lords, as regard the need for process or activity, my lords, the argument of the learned Solicitor General begins from paragraph 20, my lords. The relevant portion for process or activity, 20.30. Summing up the recommendation of FATF, it is clarified by the learned Solicitor General that even in an act of mere concealment, so my lords, and process of activity of concealment, mere possession or mere use or activity connected with the proceeds of crime per se is an offense. In other words, if a person conceals the proceeds of crime, keeps it in his possession and uses it, he is guilty of money laundering irrespective of as to whether he is projecting it as an untainted or not. This is for the simple reason that if a person conceals something, proceeds of the crime, it's an act committed knowingly, and thus the question of that person projecting that very thing either as tainted or untainted does not arise. My lords may recollect section 3, the last portion of it used the word and. To answer that, this was the argument that and should be read as or. So 20.31, thus so long as any person knowingly becomes a party or is actually involved in any process or activity connected with proceeds of crime, such a person is guilty of money laundering. 20.33, the learned Solicitor General submitted that the interpretation put forth by the other side would effectively result in granting the accused a license to commit the offense of money laundering and thereafter either conceal the proceeds of crime or keep them in their possession or use them and thereby wriggle out of the legislative intent of preventing money laundering by raising a plea that same was never intended. 30.35, again, strong emphasis is laid on the use of the words any in the face, any process or activity. A careful reading of section 3 PMLA clearly provides that any process or activity of concealment, these are all the activities, my lords, concealment, possession, acquisition, use, and or projecting, claiming it as untainted property, it is submitted that all or every type or species of proceeds of activity connected with proceeds of crime shall be included while interpreting the nature of proceeds. Then again, 20.36 activity required in furtherance of proceeds of crime. Now, 20.37, my lords, it's page 4. Again, the emphasis, there should be a process or activity. My lords should get that at 20.37. Now, my lords, at this point itself, I'll point out, my lords, this process or activity which they speak about is not for the generation of proceeds of crime. The process or activity which is spoken about is post the proceeds of crime.
Laundering.
Laundering. That's why, my lords, prevention of money laundering. So you may have proceeds of crime and you have done nothing about it. It doesn't amount to laundering.
Andre, you'll have huge stacks. Don't use it for no laundering.
So here, my lords, activity for laundering. My lords, anything that happens prior to the proceeds of crime, my lords, is investigation of the predicate offense. Because you investigate. Now, for example, a drugs case, my lords, which has come from some place. The investigation takes place under NDPS Act. Ultimately, what is the outcome of that? The proceeds. It stops. Investigation stops there. Now, if that proceeds is used, any further activity, PMLA kicks in. This is how, my lords, the whole aspect of laundering takes place. And that is where PMLA comes in. But if the attempt is to say, we will investigate the generation of crime, then you're intruding into the power and jurisdiction of the investigating officer who is investigating the predicate offense, which you cannot do, my lords. No power or jurisdiction to do that. Now, kindly notice the submissions of the Additional Solicitor General, my lords, how Additional Solicitor General at page 4 itself, Roman 4. Paragraph 53 onwards are the submissions of the learned Additional Solicitor General. Relevant is his interpretation of the presumption under section 24 of the PMLA Act. His contention is that even to have the presumption under the Act, foundational facts have to be established. He says, which are the two foundational facts, my lords? First is that the person should be charged with the offense of money laundering. Kindly notice that, my lords. And secondly, there should be proceeds of crime. Probably it should have been the other way around, my lords. You should first have proceeds of the crime and then laundering. But these two are foundational facts even for presumption under 24 to kick in. That in paragraph 53.31. My lords have noticed 53.31. And then the Additional Solicitor General would contain concept of possession is central to an offense of money laundering. Lords gets that as Roman number 2 at page, Roman 4, my lords, page 2. Because they say possession is not there. 53.42, my lords. It is then submitted that the concept of possession is central to the offense of money laundering in as much as all the 6 activities recognized under section 3 PMLA involve an element of possession of proceeds of crime. He further goes on to state that such possession need not necessarily be actual possession, physical possession, but may also be legal or constructive possession. It is submitted possession of proceeds of crime being key to the offense of money. All activities have an element of possession after 1/7/2005 shall fall within the ambit of the Act. Now, finding of the court on this, my lords, as I pointed out, my lords, the contention of the petitioner, I'm not touching at all. I'm only touching how the union has interpreted this Act. Now, finding of the court is between paragraphs 85 to 391, my lords, in which my lords may kindly notice the object of the Act, which we get at paragraph 97. Even the preamble to the Act reinforces the background in which the Act has been enacted by Parliament, being commitment of the country to the international community. It is crystal clear from the preamble that the Act has been enacted to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and for matters connected therewith or incidental thereto. It's neither a pure regulatory legislation nor a pure penal legislation. is an amalgam of several facets essential to address the scope of money laundering as such. In one sense, it's too generic legislation.
I'm sorry.
So, my lords, it's a one-of-a-kind legislation. That's how they hold it. Then, my lords, paragraph 99 onwards, they use the definitions. 2(1)(u), which is proceeds of the crime. That is what you get from the schedule offenses, my lords. My lords may have Roman number 6, page 6, my lords. 106 may kindly be noticed. Roman number 6, 106, dealing with proceeds of crime by way of any process or activity constitutes offense of money laundering under section 3 of the PMLA Act. So, my lords, kindly notice in our present case, my lords, their entire cases, proceeds of the crime are this 14 illegally allotted sites. That's the proceeds of the crime. Now, it's an admitted case that this so-called proceeds of crime has been given back to the concerned authority, that is to MUDA. There is no process or activity which is done to this proceeds of the crime. Now, if there's no process or activity done, how is it that the ED would get a jurisdiction, my lords, to register an ECIR? The fundamental ingredient to constitute an offense, when it is lacking, how could you have registered it? And that too, in the haste in which it is done, 4 days after the FIR is registered. My lords, 2021 was the allotment. 27th was the FIR registered. 110 they registered ECIR. Would you not wait for an investigation to take place on the predicate offense to establish that there's proceeds of crime? Where was the laundering at that point of time for you to initiate an ECIR? And they very well knew the so-called 14 sites have been returned back. Please notice, my lords, after that, paragraph 109, that the property recovered by them, this is all recovery of property, my lords, need to recover of property to proceed under the provisions of the Act. My lords, 109 deals with recovery, how recovery should be there. That's why, my lords, this Act, when we look at prevention of money laundering, my lords, the Act is designed in such a manner, as soon as you know there's a proceeds of crime from a schedule offense, what would you do first? You want to prevent it from being laundered. Section 5 enables provisional attachment. You do the provisional attachment. You issue summons under 50, call upon them to explain on it. They will come up with an explanation. If you are not satisfied, you feel there's an offense under 3, you proceed with the inquiry, end it up with a complaint. This is how the entire Act runs, my lords. Now, in our case, without there being proceeds of the crime on the day you register it, without there being an attachment, how is it that you have proceeded further in that inquiry? Especially at the time when the investigation is going on the predicate offense. So, my lords, then, interpretation of section 3. This would be the most important aspect, my lords. Lords has already seen it. My emphasis...
No, I have closed it and kept...
I saw it, my lords. My emphasis is on the usage of the words...
Why Balaji also I saw.
My lords has seen through why Balaji. 3 Ps.
Yes.
There should be a person.
Yes.
Then there has to be a process and there has to be a product. Now, in our case, person is there. Process is not there. Product is not there. So, why Balaji clearly lends support?
So, you're saying person without product and proceeds.
You can't.
Yes.
You need all the 3 Ps put together to have the ingredient of PMLA. That's how why Balaji has gone about it. And in why Balaji, my lords, on the last occasion I had pointed out, in why Balaji, there were 4 FIRs, my lords. 3 FIRs, charge sheets filed. 4th FIR, 1 day before the charge sheet is filed, ECIR. They pointed out how the laundering has taken place. So this ECIR was registered 6 years after the FIRs. Then Supreme Court, when analyzing it, they found that it's a case of laundering. The ECIR is justified in being registered. That is how why Balaji got decided, where they say, my lords, 3 Ps are essential. The 3 Ps are available in that case. There's a person, there's a process, and there's a product. So, my lords, I'm sorry, my lords has quickly glanced through the whole thing. My lords, all these paragraphs which I have quoted, the emphasis is process or activity in furtherance of a proceeds of crime. Now, in my respectful submission, my lords, even if they consider that these 14 allotted sites are the proceeds of crime, what has happened thereafter? Now, this proceeds of crime is back to the authorities concerned. Where is the laundering that has taken place? Now, my lords,
No, the crime is with you, proceeds are with them.
crime of the predicate offense.
Predicate, not that.
That I will face. my
Crime
lord.
is with
Predicate
you,
offense,
proceeds are there.
proceeds are with them, with the authority concerned.
All right.
No laundering that has taken place. You don't come under any of the aspects of laundering. So how can this ECIR be registered? Now, my lords, subsequently, I'm sorry, my lords, presumption, all that is there in that. The entire emphasis is only this interpretation of Vijay Madanlal in the view of how union has interpreted it, my lords. Not how we are. We had more points to say, but how union has interpreted, which was accepted, is how this is there. My lords, after this Y. Balaji, one other decision, my lords, of the Madras High Court, Srinivasan versus Enforcement Directorate,
Umbilical cord decision.
Adralli, they say the mandate is of possession and enjoyment.
Correct.
Possession and enjoyment. But if there's no possession or enjoyment, then, my lords, the offense is not made up. So, my lords, that is at book 1, page 584 is that judgment, my lords. The emphasis is only, emphasis is only on possession and enjoyment. Then one other decision, my lords, quite recently on 3/1/2025 of Jammu and Kashmir, my lords. Now, what happened in that case is the court would hold that they have not been able to establish this proceeds of crime coming into the account, and they have not been able to establish any process or activity thereafter. On that score, my lords, they quashed the proceedings of ECIR. My lords would have the relevant portion there at page 17, paragraph 10. My lords would then notice paragraph 19. The fourth line, my lords. The most important thing is that there must be an activity connected with the proceeds of crime. My lords, gets that portion, my lords. Page 19. Then, my lords, the ingredients, further down, ingredient of the offense of money laundering is not made out when read so. Please notice the three aspects, my lords, which I pointed out. All the three should be there for initiation of proceedings under the PMLA Act. The third is most important, indulging in an activity connected with such proceeds of crime. It needs to be mentioned here that the activity connected with proceeds of crime attributed to an accused must be a voluntary act of the accused. Then, my lords, they would go on to quash the entire proceedings, finding that, my lords, at page 24, that he neither had proceeds nor was he engaging in any activity. So they quashed the complaint because, my lords, at that point of time, in that case, it had ended up with a complaint. They quashed that proceedings. Now, other than this, my lords, on the aspect of whether this entire action is bona fide. My lords, I'm sorry, just one page if I could request my lords to have in the book that I have given today. Please notice to age Roman page number 21, my lords. My lords, the action between 1992 and 5/1/2021, illegal allotment. Then, when the FIR in the predicate offense was registered only on 27/9, is the ED justified in registering the ECIR within 4 days, thereafter on 1/10, especially when the allotment was done on 5/1/2021? So 2.5 years have lapsed. And then comes the predicate offense FIR. 4 days thereafter, in a tearing hurry, my lords, the PMLA proceedings initiated. Second, when the subject matter of investigation in the predicate offense is whether the allotment of the 14 sites is legal or illegal, ED cannot have. Let's have seen the 6 points.
Para 26 for Pankaj Bansal.
Yes, my lords. Because there they say, and there in Pankaj Bansal, my lords, the grounds of arrest had not been given at the time of arrest. They pointed out.
That is the first judgment on that.
Yes, and they point out the events speak volume and reflect rather poorly, if not negatively on ED style of functioning.
Para 26.
Para 26. So I'm relying on that, my lords. My lords, one other aspect.
Grounds
which-
of arrest are there.
How-
Pankaj Bansal, Prabir, Arvind Kejriwal, Vimal Kumar now. Yes.
Vihan
Kumar.
Vihan.
Yes.
That now holds the field, my lords. It's applicable to all offences, including IPC.
Now that was a case of 420 and 465.
Please. My lords, one other aspect which I had pointed out is, after BNSS has come into play, section 107, which was not there under the CRPC.
Yes.
Now, under section 107, my lords, the investigating officer who is investigating the predicate offence, if it comes to his knowledge of any proceeds of crime, he can attach it. Once he attaches it, he informs the magistrate and it is also liable for forfeiture.
Allah, he attaches it and then he need not attach it.
Need not.
But there is a provision to attach.
Provision to attach, provision for forfeiture, distribution also. Now, my lords, that portion of it, my lords, to show the difference between 107 and what we get in the PMLA, if my lords in that same book, we notice 24, Roman number 24, please notice comparison of these two. Whether the proceeds of crime is defined, it's defined in both manners. Both have it, so there's no difference. Need need for laundering under the PMLA Act, it is required. But under the BNS 107, my lords, you don't need laundering. Third, my lords, derived or obtained from criminal activity, both it comes from criminal activity. Fourth, direct or indirect proceeds included. Yes, it's included in both direct or indirect. Fifth, my lords, need for process or activity in furtherance of proceed of crime. This is the most important distinction. Under the PMLA, it is required. You need a process or activity. Whereas under 107, it is not required, my lords. Merely the proceeds of crime can be attached. Then, my lords, 6, need for possession of the proceeds of crime in both is required. They must have some kind of possession, directly or indirectly. 7, the written reasons for believing recorded, it is required under PMLA, not required under 107. They don't have to have written reasons, my lord. 8, crime must be related to specific offense, schedule offenses. Under PMLA, it is yes. Under 107, no. It extends to everything. Then, my lords, property held outside India included. In PMLA, it's included, but it is not included under 107.
That's right.
Yes. So, my lords, these are the distinctions that we get of the two. So, here in a case, my lords, when the very allegation of saying whether this 14 sites that have been given are legal or illegal is being investigated, and when that investigating officer has the power to recognize whether there's a proceeds of crime, has the power to cause an attachment of it, then in this tearing hurry, can you have PMLA come within a span of 4 days and virtually doing the very same investigation which is sought to be done in the predicate offense? Investigation in both is one and the same, my lords. That can't be done because this kicks in only after you have identified a proceeds of crime and
No,
a
the
laundering.
parameters of investigation are different.
Different. For laundering.
They are not this, yeah.
Yes, my lords, for laundering. Now, without even having an act of laundering, how do you register ECIR?
No, that to investigate into that laundering only they have
They can't. For the generation of proceeds of crime, my lords, they can't investigate. Their role comes, their power and jurisdiction.
laundering.
After there's a proceeds of crime, the laundering of the proceeds of crime. This is a distinction. Now, if they're trying to go one step behind and say, we will look at the generation of proceeds of crime, then you're encroaching into the powers of the investigating officer of predicate offense. This would be the subtle distinction, my lords, between the
See,
two.
there was one case which I have written. You argued somebody else in Bangalore. He was a milkman. He takes supari and kills 2 people. That's the allegation. Kills 2 people. Receives a lot of money. That money he launders it, buys apartments, buys cars, everything. Finally, he gets acquitted.
Yes.
of that offense in the predicate offense. Now it is laundered, this is registered. Then I said, since that predicate offense is gone, notwithstanding the laundering that is found, goes.
Madanlal.
Vijay Madanlal followed. Supreme Court has stayed it.
They've stayed it, but otherwise, as of now,
Supreme Court has stayed it, saying
as of now,
there was already laundering there.
but as of now, the ratio that is laid down is if there's going to be a discharge, if there's going to be an acquittal,
That
if
is
there's
there.
going to be a
Discharge,
quashment,
acquittal, quashment.
then PMLA goes.
That's what I followed. But
Absolutely.
Supreme Court says
Maybe
there
when
was-
they consider it, they'll have to reconsider Vijay Madanlal. In fact, my lords, in Y Balaji.
No, why I told you that was, there was serious laundering of money that he receives from that crime. Those were the proceeds of crime. Proceeds were held by him. If it were held by him, it's all right. But he goes on,
Laundered it.
goes on laundering it to many purposes.
Yes, ma'am.
Supreme Court, by detailed order, stated the laundering had happened already on the proceeds of crime.
Then-
He's acquitted of a technical, so I should not have quashed it, is what is said.
And then the ratio has to
That's-
be.
that's what-
My
that's
lords,
what Supreme Court has
probably
said.
then the ratio, my lords, of Vijay Madanlal, the request made in Y Balaji is to refer it to a larger bench. Y Balaji's
No,
case.
that we don't know.
They did-
What
they
I
did.
had held and what Supreme Court has done is what I
May I
said.
just point out what happened in Y Balaji? The request that was made was Vijay Madanlal's case. There were about 8 review petitions where notices were ordered.
That was rejected, I guess now.
No, it is still pending.
Pending.
So, my lords, in Y Balaji, the first request that was done is there are certain aspects of Vijay Madanlal which needs a relook, send it to a larger bench. But the 2-judge bench said, no, we're not sending it. Then the second request that was done is, since there are so many reviews which are pending, let us await the outcome of that. The court said no. They still said Vijay Madanlal has precedential value. We will follow that. And that's how Y Balaji was decided. But as it stands now, the ratio, my lords, is that if there is going to be either an acquittal, discharge, or quashment of the predicate.
That remains.
That remains. The
That
ratio
remains, even if it is referred to a larger bench, it still remains unless the larger bench would set it aside.
Absolutely.
Mere reference will not make it lose its precedential value.
Well, it's the last aspect that I just pointed before winding up, my lords, is the statement of objection which has been filed. Kindly have a look at the statement of objections.
This is in Parvati's case.
Yes, my lords, in my case, in
So you're arguing the
1132,
1132, yes.
1132. My lords, the respondent ED, they admit, my lords, that the alleged illegal allotment of 14 sites is the proceeds of crime, according to them.
Hmm.
My lords may notice paragraph 3, Roman number 3 and 4.
Hmm.
So this foundational facts, even according to them, 3 and 4, Roman number 3 and 4.
Yes.
And thereafter again at paragraph 4,
Hmm.
what has been given to the petitioner is the proceeds of crime. And paragraph 5,
Hmm.
my lords, paragraph 21 at page 16. Page 16, paragraph 21, my lords.
Hmm.
Again, there they say, this is the proceeds of crime. Paragraph 24 at page 19.
Hmm.
Paragraph 26 at page 20.
Hmm.
And paragraph 34 at page 25.
No, that is you're referring to these paragraphs for the reason that there are copious references to 14 sites.
14 sites being the proceeds of crime. Because after those paragraphs, my lords, now they try to give it a different aspect altogether thereafter. Now, when you're saying
Different aspect.
what they're trying to say is what we're trying to investigate now is not just these 14 sites, but all the allotments that have been done by MUDA. It is about 1,708 sites. We are looking into it, virtually investigating into it. And of those sites, we have done provisional attachments of about 160 sites. And therefore, this is much larger than what is there in the predicate offense. This, my lords, if you're trying to investigate to see how the proceeds of crime have come, then you're going way beyond power and jurisdiction. That is exactly what they have produced as annexure R1 and R2. That's why it's become much more bulkier Annexure R1 may be noticed, my lords, an internal communication between two authorities on the ED. Please notice, my lords, R1, the page 31. This is addressed to the Additional Director General of Police, Police Wing, State of Karnataka, and it is addressed by the Joint Director of Enforcement. Now, I fail to understand, my lords, what is this information that is being passed on without you even having power or jurisdiction to have an inquiry?
No, section 60.
66 subsection
66,
2.
66.
66 subsection 2 is, my lords.
Information to other agencies.
Other agency. My lords, here investigation of predicate offense is happening. Are you also investigating into that same predicate offense for you to pass that information?
No, they are conducting investigation to pass it on to other agents. That's what.
They're conducting an inquiry on the proceeds of crime, the laundering of proceeds of crime,
laundering
which can
of-
be done. This is not that information that is being given. This is virtually investigation into the predicate offense. And you're passing information of that. How are you parallelly
No,
investigating?
that is to other agencies.
Parallel investigation, my lords, of a predicate offense. That is not permissible. They're trying to investigate the very same aspect which is investigated by the SIT.
Kindly see the questionnaire.
Questionnaire also is to that effect.
What questionnaire?
27.
Which questionnaire?
27, along with that petition, Maros, that questionnaire was
Along with the
issued along with the
objections.
summons. Kindly see the nature of questions asked. It's nothing but a repetition of what the predicate offense
No,
investigation.
ಯಾವುದ್ರಲ್ಲಿ?
Petitionally.
Petitionally, page 27, along with the summons, the questionnaire which is sent last time, Leonard Senior.
In Parvati's case.
Yes.
ಅವ್ರ ಕೇಸಲ್ಲಿ
Our
ತೋರಿಸು.
case ಅಲ್ಲಿ ಕಳ್ಸಿದ್ರೆ ನಮ್ಮ case ಅಲ್ಲೂ ಕಳ್ಸಿದ್ರು.
Grandfather, granddaughter, all in this.
This is a pro forma.
No,
So,
can
to every-
the nature of questions asked. No, can page
No,
27.
nature of questions I
Details of
understand,
movable,
but this
immovable.
is this a pro forma questionnaire that you ask? ಎಲ್ಲದ್ರಲ್ಲೂ ಇದೆ ಅಲ್ವಾ?
No,
It's
no,
a pro
very
forma
specific.
questionnaire.
No, it's very specific.
We have devised it.
Kindly see page 27. It can't be pro forma. It's very specific. Very specific. It refers to site numbers. It refers to survey numbers.
PMLA ಕೂಡ.
ಇಲ್ಲ, ಮಾಡಿ, ಮಾಡಿ. Let me continue.
Rule 11 of the rules. Yes, sir. Seven yaವ್ದು? Well, there are many rules. Form of records. No, but sir, you mean to say that the form cannot be of a different circumstance change. It should be in this manner only?
And they would refer to it. His the extra the power flow of officer rule 11. We have issued summons as mandated in the form of the file.
All right.
In continuation of what I was saying, my lords, that the ED,
Well.
my lords, that the ED is doing the investigation into the predicate offense in continuation of
That cannot be done, is
My lords, kindly notice annexure R1. What is it that they're sharing information? R1.
objections.
Objectionally R1. This they say under section.
Sharing of
66
information
sharing of
in
info.
respect of Shri Siddaramaya and others.
Please come below last, second paragraph, illegal allotment of sites. Now, this is part of investigation of the predicate offense. Please notice next one, illegal denotification of land. This is being investigated in the predicate offense.
No, that's the preamble they have drawn to what they are saying.
They say this is what they're doing and passing information. Please notice each and every one, my lords.
During
Please,
the course of investigation, 2 searches were undertaken, directorate. During the course of search,
and then they give a summary for everything.
the following was revealed.
And then what? Illegal denotification of land, which is what is being investigated, whether it's illegal or not. On the next page, my lords, please notice illegal conversion of the land for residential purpose. On page 33, they give a summary to it. Gifting of land to Parvati, page 35. Then illegal allotment of sites against the land. Is this not part of investigation what the SIT is doing? Which is the proceeds of crime and the process or activity that you are looking into?
SIT ಯಾವುದು?
Which one?
SIT ಯಾವುದು?
Crime number 11 ಅಲ್ಲಿ SIT.
SIT?
Especially Lokayukta SIT.
Lokayukta.
SIT. I think they have an SIT there, my lords, for that.
That's all right. Which is this SIT?
No, it's from the Lokayukta. They constituted.
Lokayukta, yes.
My lords, please notice even at page 35. What is it that you are investigating? How can you investigate what is to be investigated in the predicate offense? Same thing. And this you share information again after doing this so-called investigation. Then, my lords, after all that, my lords, they would say, we have attached certain properties. Page 41 is a provisional attachments done by them to about 160 sites that had been allotted. Please notice even in this particular attachment, the investigation they say from page 49 onwards. They register the ECIR and how the investigation, it's investigation into generation of proceeds of crime, not permissible at all. Your role comes after there's a definite proceeds of crime and a laundering of that.
You have so many names are there.
How do all people who have been allotted, my lords, allottees, attachment
Unrelated to.
And it is unrelated to this 14 sites. 14 sites are given back. There's no attachment of the 14 sites. Then how is it that I'm receiving summons under 50?
We'll see. Yes.
On this basis, my lords, the entire proceedings of ECR which I have questioned, my lords was pleased to ask, have you challenged the whole process? I have challenged the whole process, my lords, for all these reasons. Deeply obliged.
What happened to this Justice Hemant Chandan order?
It is
we are challenging it, Lord.
It's not a challenge.
It's in the process.
It's like that. And there, my lords, the 3 paragraphs we have pointed out, 25, 26.
No, that you last time you said.
They hold there is.
Vikram sir yaರಿಗೆ?
No, nothing. I have nothing more to add.
Just one
only to
other
point out,
aspect,
this is the danger, my lords, in assuming the jurisdictional fact. Now, then it essentially balloons into a roving inquiry and it can go anywhere. This is a classic case of assuming that there is proceeds of crime and then starting from there, which is why, my lord, that safeguard is there that the act would be triggered provided there are proceeds of crime. Otherwise, what happens is you assume that and then you can go in, then the world is open, my lords, which is what happens. One more aspect.
Well, it's one last aspect which we want to point out, my lords, through media that we have come to know that in the predicate offense itself, now a B report is being submitted. In the predicate
The
offense.
court?
No.
Lokayukta police.
Lokayukta. So, my lords, an additional
How is
factor.
that relevant to this?
Just an additional
Because
factor.
that procedure will go on there.
Yes, procedure will go on there. That's why, my lords, I didn't use it as a point to say this has to be quashed on that score. No. It's only an additional ground, my lords, where they find nothing.
Whatever is done there, procedure there will have to be followed.
Yes.
This has nothing to do with that.
Deeply obliged.
Sir, ತಾವು ಮುಗಿಸಿದಿರಲ್ಲ last time. Yes.
Lord.
ನಿಮ್ದು ಬಿಡಿ. ನಿಮ್ದು is a different. So, you assumed office in 2023.
My lord,
2023.
June 2023. ಅವ್ರು ಏನಾದ್ರು ಒಂದು ತೋರಿಸ್ಲಿ ನೋಡೋಣ ಜೂನ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಜೂನ್ 2023
ಇಲ್ಲ ಸರ್ 21 ಗೆ ಎಲ್ಲ ಆಗೋಯ್ತು.
ಅಷ್ಟೇ
ಜೂನ್ 23 ಆದ್ಮೇಲೆ ಆಗಿರೋದು ಒಂದೇ what is that, cancellation.
ಅಲ್ಲ ಅದು ನಾನಲ್ಲ, ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಮೂಡಾ ಕಮಿಷನರ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ, ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರೆಂಡರ್ನ. ದಟ್ ಮೂಡಾ ಕಮಿಷನರ್ ವಾಸ್ ಬಿಫೋರ್ ದಿಸ್.
Surrender and cancellation on the act has happened after you assumed.
ಅಷ್ಟೇ. That Muda commissioner who passed the order accepting the surrender and cancelling the allotment that was made earlier, my lord, he is the petitioner before a coordinate bench of dishonorable court.
That same.
Yes, that Satish. I'm sorry, Satish. Natesha. And dishonorable court would say, no, you could not have issued the notice under section 15.
All right. Yes, sir.
Lord, I will cover both the petitions together. My initial submission would cover both the petitions, then, my lord, I will segregate. Lord, at the outset, my lord, I recall para 103 of Y. Balaji judgment, where Lordship Justice Ramasubramaniam very eloquently says that when there is when the predicate offense is of corruption, then proceeds of crime is a Siamese twin. My lord, we are dealing with a case of corruption, and my lord, by applying that logic rendered by the Honorable Supreme Court, the generation of proceeds of crime is a Siamese twin.
No, corruption in the sense?
It is a case of corruption. My lord, the provisions of the PC Act, yes. Section 13 has been pressed into service. So we are dealing with the predicate offense is one of corruption, and the generation of proceeds of crime as per Supreme Court, my lord, is like a Siamese twin. The moment the predicate offense is committed, along with that is generating with itself the proceeds of crime. My lord, would your lordship first take up the writ petition filed by accused number 2 in the predicate offense? In that, my lord, she has produced
Parvati.
Yes, Parvati. She has produced a copy of the complaint. My lord, the complaint predominantly, my lord, begins at page number 41. As your lordships are aware, it predominantly deals with the allotment of 14 sites as to how the accused number 1 bent every single rule and accommodated allotment of those 14 sites. But where I would like to draw your lordship's attention is page number 51, para 52. Page 51, para 52. Similar illegal allotments are being done by MUDA officials and other political and influential persons, thereby causing loss to the tune of more than 5,000 crore to the state exchequer due to embezzlement and illegal gratification. The above mentioned accused persons, by illegally allotting thousands of sites, have received huge kickbacks. These illegal acts and corruption has gone into the roots of MUDA since the year 1990.
No, this is the private complaint.
Private complaint is. This is in fact, the private complaint is made part of the FIR. The FIR description of the offense says the entire complaint. And then, my lord, please have a look at para 56 on page number 52. Page 52, para 56. Furthermore, the corruption and irregularities committed by the accused number 1 is just a tip of the iceberg. In fact, many government officials and others at the relevant point in time were actively involved in larger scam, which needs deeper investigation, inquiry, and trial in due course. The complainant reserves the right to bring so-and-so. So why I am reading this is, I heard my learned friend, Mr. Chauta, trying to confine the investigation only to 14 sites. I'm sorry, it is not confined to only 14 sites. Because there was a chief minister of the state which was involved, probably it has drawn attention to the first 50 paragraphs. But the complaint is that MUDA has been systematically granting and allotting sites by violating every rule in the book.
One clarification. Now, this is a complaint. Complaints of this nature galore, whether it is correct, wrong, frivolous, whatever. This is a private complaint that triggers predicate offense.
Yes.
Now, if this very complaint is triggering ECIR,
yes,
then it means that you're investigating into the predicate offense, you're conforming to the process.
I'm not.
Complaints
At the outset,
will come.
I would like to make it
Complaints
clear.
will come
Lord,
and go.
neither do I have the power to investigate in the predicate offense, nor we are interested.
So that is
But then, my lord, in these kinds of cases, the moment the predicate offense is committed, there is generation of proceeds of crime. Now, proceeds of crime are broadly in nature.
The statement. In these kind of offenses, when the predicate offense is registered, there is proceeds of crime,
Yes.
is what you say.
Yes,
All right.
yes.
Now,
no.
you confine it to the accused in the predicate offense. Are you gone, inquiring into everybody?
No, my lord, I am not concerned with the accused in the predicate offense.
That's all.
I am
Yes.
concerned with the generation of proceeds of crime.
Yes.
My lord, after the FIR was registered, my lord, we within 4 days we registered the ECIR. I heard my learned friend Mr. Chauta say that what was the great hurry. But I would say our officers have demonstrated great alacrity, sharpness, and efficiency. Why should there be delay? I would say, what is the difficulty in registering the ECR the very next day? There is no law which prevents me from registering.
There is no
So
bar.
there
Even
is no
Vijay
problem. The
Madalla
moment I
doesn't-
come to know that there is an offense, the next day I can do it. So therefore, I would say that we have shown efficiency in initiating the proceedings under the PMLA within 4 days from the date of registration of the predicate offense. No, my lord, what happened after we commenced the investigation is some material that we have unearthed, my lord, I would like to place before your lordship in a sealed envelope. Lord, and I would like to now take your lordship through some of them because that pertains to the other writ petition. Because the my learned friend Mr. Nagesh's client has been claiming that I'm in no way responsible to these 14 sites. But then the investigation has revealed not just these 14 sites, there is quite a lot of muck which is involved. Lord, some details that we have discovered during the course of investigation. Lordship may kindly have a look at it. Open ಮಾಡ್ಕೊಳ್ಳಿ. But we are in the midst of the investigation now. We
given what?
ಇಲ್ಲ ಆಗದು these are we are at the time of investigation now. We cannot compromise until the investigation is complete.
How do I answer it without knowing?
No, that's not for the purpose of the court.
ಅಲ್ಲ ಕೋರ್ಟ್ ಸೀಲ್ ಕವರ್ ಕೊಡ್ಕೊಡ್ದು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has time and again said it. Yes,
Lord, would you
bench headed by Justice Bopanna has ruled that
Yes.
the sealed cover
Why touchy about sealed cover?
Yes, needs to be deprecated.
That's the judgment.
Lord, one has to see the context and the nature of investigation. Lord, would your lordship kindly take page number 1?
It should become possible for us to meet the challenge.
Lord, page number 1 at the bottom, Lord, last para.
They have referred to it in the statement of objections, fine.
We have some elements of this, some elements of this we have. Now,
yes.
My lord, then my lord, would your lordship kindly in page number 2, please have a look at the heading and then the specific instances. Lord, under the specific instances, para B. Then, my lord, on the page 3, my lord, there was some submissions made on why we ask for a detailed detailed questionnaire. And why do we seek details of the relatives and friends? For that, my lord, I don't mind reading this page 3 at the bottom. The need for detailed questionnaire. The investigation reveals that the proceeds of crime generated in the form of illegally allotted sites are being transferred, that is routed, layered in the name of relatives, associates of real estate businessmen, mood officers, influential persons. The details of such instance revealed during the investigations are appended below. Shri so-and-so, he obtained one site in the name of his son of his brother, without paying money from so-and-so businessman. The examination of issue revealed that the contradictory...
How does that concern the present person?
No. What I want to demonstrate is...
He may be at the helm of affairs there.
The part that I am now reading is to show how influential people are acquiring the proceeds of crime in the name of their relatives.
That is a generic term. I'm asking what is specific again.
On that, that is on the left side. That is on the left side. That is para A and B. You know that I have
because 50-50 scheme.
I have stated in my
was there earlier.
I have stated
earlier to him, and in fact, the 50-50 scheme is scrapped.
In fact,
now.
I have stated in my statement of objection that during the course of investigation, one of the persons investigated has stated that he was subjected to pressure from the office of the petitioner in the other case to do certain allotment.
Where? How the?
In the statement of objections, I have stated it.
Page?
No, may I come to that a
page?
little later.
Where
my
have
lord?
you said that, sir?
I will give the para number right away. ಅಲ್ಲ, ಇದು before the traversal ಇದೆ. It is before the traversal. Suresh case.
In 113 itself?
Yes.
Objection,
in the
idralena,
case of-
Parvati or Kesalena?
Yes, I have stated it. My lord, just Lordship will give me a moment.
All right, yes.
My lord, while Madhukar, my lord, I'll come to the specific instance later. But please have a look at page 3 as well as 4, 5. This is to show how we have found dozens of people purchasing property in the name of their relatives, which are all proceeds of crime. For example, please have a look at
Proceeds
the.
of crime, whose proceeds?
No, these are all proceeds of, these are properties.
Proceeds of whose proceeds of crime? Which accused is proceeds of crime?
No, this is not relating to the 14. These that I have referred to in page
So
3.
it is, this investigation that you have conducted now has nothing to do with the 14 sites.
No, my lord,
No, that's, you should be
our investigation is in relation to the ECIR that you have registered, which is pursuant to the FIR in crime number
Correct.
11.
correct.
During our investigation, we are not segregating these 14 sites or anything else. We are conducting investigation. There are.
But whatever you have said here has nothing to do with the 14 sites.
On the right hand side,
Right, left, yellow 14 sites ಬಗ್ಗೆ ಇಲ್ಲ.
it may be, some of them may be generating out of that. My lord, please have a look at the name.
AJ sir. Now, proceeds of crime.
Yes.
Of this Parvati.
Yes.
Has resulted in purchase of all this? Is that
No,
not your
it need
submission
not
at
be.
all?
It need not be.
That-
My lord,
that is not it.
that is, my lord, which is why we are calling her. We want to investigate.
No, these 14 sites now,
Yes.
whatever had been purchased or had been allotted, it's not purchased actually,
Yes.
it is allotted by Moda.
Yes.
If ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ತಗೊಂಡಿದ್ರೆ, then that's a
Yes.
different thing.
Yes.
It is allotted by Moda, allotment is pursuant to that allotment, these factors that now you have
No,
gathered.
these, my lord,
Is
these
it
are.
proceeds of crime of Parvati?
No.
That's what, and then there's.
It is with them.
My lord, I think the other side should show patience. Allah. So, sir, please come back with your rejoinder. Please come back with your rejoinder.
I'm aware of.
I made notes when you made submissions. So when I make submissions, please make notes.
Yes.
My lord, what we discovered during the course of investigation is.
No,
That
I'm just
apart-
clarifying myself.
My lord, as the complainant has pointed out in the PCR, the allotment of 14 sites is only a tip of the iceberg. What the MUDA officials would do is, I will give one modus operandi. Somebody sat down and pulled out a list of acquisition of land in and around Mysore since 1966. The CITB allotment. They would pull out the details and then make create a narrative that somebody's land acquired in 1966, he has not been compensated, and then they would give him a prime MUDA site in Vijayanagar or one of those prime areas.
So there's.
No, in relation to that, there is money transfer, there is purchase of sites. So that is exactly what I have pointed out.
Those are specific names you have.
Yes.
All right.
Yes.
That is the information you're going to share with others with regard to those persons. Now, where is the proceeds of crime here?
I come to that. There is a specific purpose why I'm reading this. The part that I'm reading at page number 345 is only to satisfy your lordship as to why in my general questionnaire, I asked people about the details of their relatives.
So, ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದೆ?
Please look at page 4. Please look at page 4. Somebody was a former commissioner of MUDA. Please look at the properties in the name of his relatives. Grandfather, sister.
So many.
Yes. Grandfather of wife, sister of grandfather of wife, son of sister of grandmother, wife of son of sister, father-in-law, servant.
ಅವ್ರು ತಗೊಂಡ್ರಕ್ಕಾಗಲ್ವಾ?
It is all, my lord, we have discovered.
ಇದು MUDA allotments.
Yes. These are all MUDA allotments.
So you share this information.
No, yes, we will do that. But for now, my lord, this part of my submission is to satisfy your lordship that I should be permitted to ask this information about their relatives. Now, my lord, my learned friend, Mr. Nagesh's client had a grievance that why are they asking details about my relatives? Now, we want to know that he, as the minister for the urban development department, was involved in a whole lot of allotment of sites. We have questioned his private secretary. A couple of people whom we have examined in MUDA have dropped names. So we want to know whether there is any transfer of proceeds of crime to his relatives, because the former MUDA commissioner, please look at the
Whose relatives?
yes, of the petitioner in the other petition.
Other petition.
Yes. So we want to know whether there is any similar. Please have a look at the previous MUDA commissioner. He has purchased a whole lot of sites.
Proceed against him.
Yes. No, we will. So therefore, to gather information, we are well within our rights to ask, please furnish the property details of you and your relatives. Because there is a history.
Questionnaire.
Yes, questionnaire. Now questionnaire, the other question about the questionnaire is that we have attached it to the format of the summons. Now, let us say I had not attached this to the summons. So I would have asked the same question when the noticee came to the for the inquiry. Can the petitioner then say that he could not have asked me so-and-so question during the course of investigation? It is only an advance information that if you have any of these properties, please bring the record. So therefore, these cannot be subjected to judicial review. I am within my right to ask these questions.
So
because
you
there
only
is a history.
You only say that your investigation and inquiry,
yes,
or questioning him will be on these parameters.
Yes, also on these. First, my lord, I want to understand what are the properties. If it is lawful, my lord, I have nothing to do. If they have any properties to which they do not have any explanation, or if I am able to some link to the proceeds of crime, then I can proceed. That is what exactly para 431, which, my lord, I will read next in Vijay Madan Lal Chaudhary. So therefore, my lord, this investigation has revealed that there is a whole lot of allotment of sites illegally purchased, and allotment of sites. And please have a look at certain the bank transactions. If your lordships will see, my lord, please have a look at page number 8. Page number 8, my lord, in the sealed cover document.
No, whose bank? Whose account?
This is one of this person was also involved. And these are all, please look at the people who are maintaining the account there. Lord, for instance, item number 2, used to route the loan account money for property purchase.
Oh, against this Dinesh Kumar.
Yes. Anyway, Lord.
You're sharing this information with other authorities about Dinesh Kumar.
Yes, my lord, I have to the authorities we have already shared, Lord, under 66(2). Lord, as far as there are certain dates which are relevant. Lord, pursuant to your lordship's order on 4/9/2024, the FIR was registered on 27/9/2024.
24/9/2024.
I'm sorry, 24/9. 24/9/2024. 27/9, the FIR was registered. 1/1, the ECIR was registered. After this, now someone's issue first. On 9/1, date anything?
Yes, sir. Third, sir. Third.
Notes
Third, which is
Lord, after the ECR was registered,
3/10/2024. Okay, sir. Same, sir. 3/10 deed of cancellation.
Okay. Lord, 1/1/2024, we registered the ECIR, and 1/10 expressing intention to surrender. Okay.
Yes, sir.
And then your lordship will notice that on 1/10/2024, the petitioner, that is Parvati, issues a letter expressing her intention to surrender the sites, a copy of which, my lord, has been produced by her. Please have a look at that letter.
Page?
Lord, that your lordship will find at page number
69.
61, no, sorry,
69.
69. Annexure L. Lord, the second part. ಮುಂದುವರೆದು ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನನ್ನ ಪರವಾಗಿ ಕಾರ್ಯಗೊಳಿಸಿದ 14 ನಿವೇಶನಗಳ ಕ್ರಯಪತ್ರಗಳನ್ನು ರದ್ದುಗೊಳಿಸುವ ಮೂಲಕ ನಾನು ಪರಿಹಾರ ನಿವೇಶಗಳನ್ನು ಒಪ್ಪಿಸಲು ಮತ್ತು ಹಿಂತಿರುಗಿಸಲು ಬಯಸುತ್ತೀನಿ. ನಿವೇಶನಗಳು ಸ್ವಾಧೀನವನ್ನು ಸಹ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮರಳಿ ಹಸ್ತಾಂತರಿಸುತ್ತಿದ್ದೇನೆ. ದಯವಿಟ್ಟು ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಆದಷ್ಟು ಬೇಗ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಿ. So she issues this letter on 1/10. And at jet speed, the officials of MUDA accept it on the very same day, and a deed of a resolution is passed.
Next page.
A resolution is passed on the very same day. Lord, I heard my learned friend say, "What was the great hurry?" Lord,
That's what
it is time for me to borrow that expression. But in this case, my Lord, we have seen, my Lord, common experience has shown.
Tearing
that-
hurry versus tearing.
Yes, common experience has shown that how when a common man goes, makes a request, it takes weeks, months, years for the government to act. But here, the chief minister's wife issues a letter on 110. On the same day, a detailed resolution is passed and an order is passed, which your lordship will find at page 70, Annexure M. So this resolution is passed, and the
It is subject to.
please have a look at page 72 of that order. That is the concluding para. From the bottom, the last penultimate paragraph, last about 3 lines.
I'm there.
ಎಲ್ಲ ಮೊಬೈಲ್ಗಳನ್ನು ಸಂದಾಯ ಮಾಡಲು ಅವಕಾಶ ಕಲ್ಪಿಸುವುದರಿಂದ ಸದರಿ ನಿಯಮಗಳಂತೆ ಹಾಗೂ ಏನದು ಏಕಸದಸ್ಯ ಸಮಿತಿಯ ವರದಿ, ಲೋಕಾಯುಕ್ತ ತನಿಖೆ ಹಾಗೂ ಇನ್ನಿತರ ಯಾವುದೇ ತನಿಖಾ ಸಂಸ್ಥೆಯ ವರದಿ ಆದೇಶಗಳ ಷರತ್ತುಗೊಳಪಟ್ಟು ಭೂಮಾಲೀಕರ ಸ್ವಇಚ್ಛೆಯಿಂದ ಬಿಟ್ಟುಕೊಟ್ಟ 14 ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರಾತು ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಿದೆ.
Subject to everything pending.
So therefore, my lord, the acceptance by MUDA is subject to other authorities, including the ED. Because our investigation is connected to those 14 sites. Those 14 sites, my lord, clearly satisfy the definition of section 2(1)(u) proceeds of crime, because they are property derived or obtained by a criminal activity. So the criminal activity is under investigation before the court, my lord. So the prima facie, it is proceeds of crime and it is subject to that. Nevertheless, then, my lord, after this order was passed, then a deed of cancellation was made, Lord, which your lordships will find at the next page.
Same day?
It is same day. These are all happening at the speed of light. But it is said to be executed on 110, but the registration takes place 2 days later on 310. The registration. So therefore, the registration date is available there.
That's all.
Now, my lord, my respectful submission would be, my learned friend, Mr. Chauta, propounded the theory of enjoyment of a property. My lord, if my respectful submission would be, if the proposition that a person can be proceeded against, even under section 50, for the purpose of investigation, that only if that person is continuing to enjoy the property, then, my lord, it will amount to turning the entire PMLA jurisprudence and the law on its head. Because at any point of time, the person, someone can say, "Hey, please take over my proceeds of crime. Like, I want to wash off my hands," and then say, "Proceeds of crime is not with me." So that possibility is there. Nevertheless, in this case, when did the proceeds of crime get generated? It is the day it was allotted.
2021.
The allotment took place because of a criminal activity. The proceeds of crime were generated. My ECR registration is only an administrative document. When I register an ECR, my ECR is not a FIR. It is only a document for administrative convenience.
One factor is the sites did not go to the accused by way of sale, purchase. It is by way of allotment.
Yes.
In lieu of usage of the lands of the accused.
Fine.
So here it is not that money is laundered for that proceeds of crime have emerged because of that. It is an allotment. Allotment is legal, illegal. It's an allotment.
Laundering has a huge import. It's got a very wide import.
No, what I'm trying to tell is, ನಾವು ಇಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟು ತಗೊಂಡಿದ್ರೆ ಪ್ರಾಸಿಟ್ಸ್ ಕ್ರೈಮ್
ದುಡ್ಡು ಕೊಟ್ಟು ಪ್ರಶ್ನೆ ಬರ್ತಿರ್ಲಿಲ್ಲ
ಅಲ್ಲ ಅದಕ್ಕೆ ನೋ ದೆನ್ ಯು ಕುಡ್ ಬೇರೆ ವೆದರ್ ದಟ್ ಮನಿ ಇಸ್ ಟೇಂಟೆಡ್ ಮನಿ ಆ ಮನಿ ಇಸ್ ಅ ಡಿಫರೆಂಟ್. ನಾವು ಮೂಡ ಅಲಾಟ್ಸ್ ಇಟ್. ಮೂಡ ಅಲಾಟ್ ಮಾಡಿದ್ಮೇಲೆ ಇಫ್ ದಟ್ ಈಸ್ ನೌ ಲಾಂಡರ್ಡ್.
Lord, what we have to see is, if we have to go by the definition of 2(1)(u) of proceeds of crime, there is no dispute that 14 sites are property.
That is no dispute.
It's a property. Now, how did the property get generated? It is because of a criminal activity.
Allotment.
It is no, that what precedes the allotment is a criminal activity.
Acquisition of the land of the.
No, yes, that is where the criminal activity has taken place.
That is where.
Not how her.
That is where.
Not if we go back.
Land that had already been.
Yes.
It is allotted.
Not, I would say.
It is allotment.
I would say, my lord, in these proceedings, my lord, we should keep away from that. What took place, whether the criminal activity is for some other court to decide. As far as these proceedings are concerned, these proceedings are
predicate offense. We are not going back.
Yes. So there is a predicate offense. In the predicate offense, it will be decided whether there is a criminal activity or not, whether it is proved or not. But the FIR says there was a criminal activity. And because of that criminal activity, these 14 sites are generated, which is proceeds of crime. Now, these proceeds of crime, my lord, which the husband of the petitioner, in his affidavit filed, the election affidavit, he has shown it as property of his family. So I would say that is one attempt to claim that it is untainted property. The affidavit filed by the husband of the petitioner, showing that my family today owns 14 sites, was the first attempt to show that it is untainted. The second attempt is by the petitioner herself, by trying to return it back. By returning back, she is trying to project it as untainted. So therefore, I would say, my lord, that is a fresh count of an offense under section 3. And the contention of the other side, that by the time the FIR, the ECIR was registered, the property has been surrendered, is not true. Now, if we look at the surrendering of the property, although, my lord, I would say that it needs to be investigated whether these are backdated. Because why I say this is, please have a look at the letter written by the petitioner pursuant to my summons. We issued a summons to appear on 9/1. That summons was issued.
9/1/2025.
Yes, 2025. Lord, it was issued on 3/1/2025. She was directed to appear on 9/1/2025. She issued a letter which she has produced at page number 37, annexure C. This is on 7/1. By 7/1, she already knew that she had issued a letter surrendering the property on 1/10. She knew that there was a resolution passed. She knew that there was a deed of registration which was made.
Deed of?
The deed of cancellation. But she does not mention it.
Oh, ನಿಮಗೆ reply ಕೊಡಬೇಕು. Summons
reply ಕೊಡಬೇಕಾದ್ರೆ nothing. No, please look at the content. I am in receipt.
Show cause notice, charge sheet ಇದ್ರೆ ಅದಕ್ಕೆ ಕೊಡಬೇಕಾದ್ರೆ ಎಲ್ಲ.
No, please look at the content. Please look at the content. I am in receipt of your notice dated 3/1, seeking my attendance on 9/1/2025, along with certain information as stipulated in the said notice. I am in the process of collecting necessary details. If she can say, I'm in the process of collecting the necessary details, the details which were already available with her, she could have disclosed. She does not disclose that. So therefore, my lord, a doubt arises as to whether, if we look back now, whether this was all, that is subject matter of investigation, I'm saying. This requires to be investigated. Whether there has been a backdating of certain documents, there has already been enough muck, but whether this piles on to that is something which we have to examine.
No. What notice did you issue?
Just to come and appear.
Alva.
Yes.
ಅದಕ್ಕೆ ಆ ನೋಟಿಸಿಗೆ ತಕ್ಕ ರಿಪ್ಲೈ. ನೀವು ನೋಟಿಸ್ ಅಲ್ಲೇ ಕ್ವಶನ್ ಕೇಳಿದ್ರೆ ಕ್ವಶನ್
ಅದಲ್ಲ ಆಗಿದ್ರೆ ಮಿಲಾರ್ಡ್ ಇಫ್ ಕ್ವಶನರ್ ಅಲ್ಲಿ ಇದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮ್ಮ ಕ್ವಶನರ್ ಅಲ್ಲಿ ನಿಮ್ದು ಏನೇನ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು. ಸ್ವಾಮಿ, ಈ ನೀವು ನನಗೆ ಕರೀತಾ ಇರೋದು 14 ಪ್ರಾಪರ್ಟಿ ನನಗೆ ಗೊತ್ತು, ನಾನು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೆ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು.
ಅಂತ ಯಾಕೆ ಹೇಳ್ಬೇಕು?
Anyway, Milord, at this point in time, Milord, I will not answer those questions. The purpose of reading all this is to demonstrate before your lordship that everything is not what meets the eye.
It's your investigation.
If your lordship sees this in the perspective of how
your investigation is right, that it has met more than what meets the eye.
Particularly considering that a letter issued by a citizen is received by a statutory authority, that is MUDA, a detailed resolution and order is passed, a deed of cancellation is executed. All this happening in a span of about 10 to 12, business hours is about 8 to 10 hours. all this happening is something which needs to be answered. So therefore, my lord, my respectful submission would be that this petitioner cannot say that as on the date of registration of the ECIR, I was not in enjoyment of the property.
As on the date of registration,
The contention was
110/24.
The contention was
110/24.
yes, on the date of registration of the ECIR. So which is and then the other issue is then, my lord, I have a few formulations to place before your lordship. The first one of them is that there cannot be a challenge of a ECIR. Lord, please have a look at the relief sort.
The Supreme Court judgment is
Lord, the relief sort is, please have a quick look at the relief. Lord, the writ petition itself is not maintainable, would be my submission.
All right.
Page 23. My lord, before this, my lord, since to complete my submissions as far as the enjoyment of the property is concerned, the writ petitioner claims that I have now surrendered it to Muda. My respectful submission is that once it is a proceeds of crime, if you hand over to A hands over to B, the custody will be with B, but it will not cease to be a proceeds of crime. It may be currently the Muda is in custody of those 14 sites, but I would say that Muda is in custody of the proceeds of crime. It will not lose its character as proceeds of crime merely because the petitioner has made a surreptitious attempt to hand it over back to the Muda.
No, an illustration. A's property is stolen by B.
I was about to give that.
A's property is stolen by B. B gives it off to C.
Yes.
Then proceeds of crime is laundered. If A's property is stolen by B and B returns it to A, crime may not go. Proceeds of crime will not.
No, my lord, here, my lord, this is my lord, even if we go by the IPC logic, if you return the stolen goods, you cannot claim that you are not committed the offense.
The stolen goods will not absolve him of the crime.
No,
I'm not on that.
Once, my lord, once it attains the characteristic of a proceeds of crime, by returning you cannot cleanse it. Lord, that is laundering. Your attempt to launder it to show that it is white property or clean property itself is the offense of money laundering.
Where is it laundered? Where is it laundered?
No, you claim
allotment. Where is it laundered? I'm asking.
No, she owned the property. The day
owning the property is laundering.
No, sale deed was executed in her favor.
Correct.
Yes. So she became the property owner.
How?
She became the property owner.
How?
By execution of a sale deed by Muda.
For what purpose?
As a compensation as a compensation, but for a property which was never acquired. My lord, which is why, my lord, we once again go back to the predicate offense, which I do not want, my lord, take your lordship to
Not
that.
necessary. Yes.
That is for another court to decide.
It's all right. Yes.
As on today, there is an allegation that there was a criminal activity. And due to that criminal activity, these 14 sites have arisen.
All right. Yes.
So therefore, as on today, those 14 sites have the characteristics of a proceeds of crime. Merely returning it back to Muda does not wipe off that characteristic, is my submission. My lord, among the 4 formulations that I want to place before your lordship, the first one is that a challenge to ECIR under 482 is not sustainable. My lord, I have prepared a compilation of some judgments. My lord, would your lordship kindly have a look at it?
ಎರಡು ಕಾಮನ್
petition.
Is not permissible. Vijay Madanlal Chaudhary.
Vijay Madanlal Chaudhary. My lord, why is, my lord, please have a look at that 431. My lord, page 6. Page 6. This is the most critical part as far as section 50 is concerned. In the context of 2002 Act, it must be remembered that summon is issued by the authority under section 50 in connection with the inquiry regarding proceeds of crime which may have been attached and pending adjudication before the adjudicating authority. In respect of such action, the designated officials have been empowered to summon, my lord, I will emphasize, any person for collection of information and evidence to be presented before the adjudicating authority. It is not necessary for initiating a prosecution against the noticee as such. The power entrusted to the designated official under this Act though couched as investigation in real sense, is to undertake inquiry, to ascertain the relevant facts, to facilitate initiation of or pursuing with an action regarding proceeds of crime, if situation so warrants, and for being presented before the adjudicating authority. It's a different matter that the information and evidence so collated during the inquiry made may disclose commission of offense of money laundering and the involvement of the person who has been summoned for making disclosure pursuant to the summons issued by the authority. At this stage, there will be no formal document indicative of likelihood of involvement of such person as an accused of offense of money laundering. If the statement made by him reveals the offense of money laundering or the existence of proceeds of crime, that becomes actionable under the act itself. To put it differently, at the stage of recording of statement for the purpose of inquiring into the relevant facts in connection with the property being proceeds of crime is, in that sense, not an investigation for prosecution as such. And in any case, there would be no formal accusation against the noticee. Such summons can be issued even to witnesses in the inquiry so conducted by the authorized officials. However, after further inquiry on the basis of other material and evidence, the involvement of such person noticee is revealed, the authorized officials can certainly proceed against him for his acts of omission or commission. Therefore, my lord, I would say that I truly appreciate the whole lot of research work that my learned friends team has done. But I would say, my lord, as far as this case is concerned, I would call it as a reinventing of a wheel, because we need not go into that at all. At this point in time, we have merely issued a summons. We may treat the petitioner as a witness, someone who knows about this particular deal. We have not made any accusations at all. I'm not sure why my learned friend had to make elaborate submissions on his client is not guilty of certain offense. She is not. This is not proceeds of crime. We have only there is a proceeding which under section 50. All that I have to establish is that there is an investigation going on in respect of an ECIR, which is in respect of a FIR. Now we have to reassemble that. Is there a FIR? Yes, there is an FIR. Is there a predicate offense? Yes, there are a couple of them. There is 420, there is 471, there is section 13 of the PC Act. Pursuant to that, is there a ECIR which is registered? Yes, we have registered ECIR. Is your investigation in relation to this? Yes, it is in relation to that. Have you summoned both of these petitioners in relation to this? Yes, I have. This is all that I have to establish when I have summoned a person. My learned friend's client need not feel that they are accused and that they have committed an offense punishable under section 3. We want to know from them. We have to gather information from them. We may record, and if we do not find anything, we may not proceed at all. And Honorable Supreme Court says, if you find something, then you can proceed further. So therefore, what we have conducted, in the words of the Honorable Supreme Court, is like a civil inquiry. So in respect of a civil inquiry, initiation of section 482 does not arise at all. Because my ECIR is not a document which is recognized under the code. It is only for administrative convenience I have given it a number. Lord, one more judgment directly on the point is, Lord, please have a look at the Madras High Court judgment at page 19. Lord, para 9, page 20, para 9. It is to be borne in mind that ECIR is not registered under the Code of Criminal Procedure, and it is not akin to an FIR which is registered under section 154 and sent to jurisdictional magistrate. The scope of an ECIR has been discussed with the division bench of this court in so-and-so, so-and-so. Then brought para 10. Thus, registration of an ECIR is an administrative act that is done by the officers of the Enforcement Directorate for initiation of an investigation under PML Act, which is a special statute, and therefore the same cannot be quashed in excess of the powers under section 482 because registration of ECIR is not under the code. Then we one more judgment of the Honorable Punjab and Haryana High Court on similar lines. I will just read one para which your lordship will find at page 26. Para 7 at page 26. This court unhesitatingly concurs with the contentions made by the learned counsel for the respondent ED that ECIR is an internal administrative document of the ED. Consequently, in the considered opinion of this court, since the ECIR precedes the stage of criminal prosecution and proceeding, it thus falls outside the purview of the inherent jurisdiction conferred upon this court by section 482 of the code. Therefore, the prayer of the petitioner for quashing of the ECIR under section 482 of the code cannot be entertained. So these are the judgments, my lord, as far as the challenge to the ECIR is concerned. The second proposition, my lord, is that the summons to appear does not give rise to a cause of action, nor does it violate any legal right. That is my second proposition. For that, my lord, I have produced a few judgments. I will read one line from each one of them. Please take up the Supreme Court's judgment in Kirit Srimankar case, beginning at page 146, where, my lord, their lordships refused to interfere in respect of a summons. Page 146, right in the beginning, their lordships say, in the course of hearing of the writ petition, we find that the writ petition was premature. And then, my lord, next page, about 6 or 7 lines. The provocation, they say, in fact, when we peruse the averments contained in the writ petition, provocation for the petitioner to file the writ petition was the so-called search conducted on so-and-so date. It was further averred therein that the officer threatened the petitioner would be arrested, incarcerated in jail, and would face dire consequences. So on that basis, writ petition came to file this court under 32. We therefore expressed it was highly premature for the petitioner to seek for extraordinary constitutional remedy under 32. Then, my lord, about 5 lines below. Inasmuch as it will be for the petitioner to work out his remedy as and when any appropriate positive action is taken. So, my lord, if I issue a warrant, then alone, my lord, it would constitute a positive action. Then, my lord, if your lordship would have a look at the Kerala High Court judgment, my lord, para 7 and 8 would be relevant at page 157. Para 7, to drive home the limited scope of interference at the investigation stage, learned ASG cited the decision in Commissioner of Customs wherein Apex Court had cautioned that as far as possible, High Court should not interfere at the stage when the department had issued summons. In so-and-so, interference by the High Court into the interrogation of a person summoned under section 40 of the FERA by fixing the time, my lord, that we can skip. Para 8, I find substantial force in the preliminary objection regarding maintainability raised by the learned ASG. Exhibit P11 summons is issued under section 52 of the Act. A person issued the summons is bound to attend in person or through authorized agent as the officer issuing the summons directs, and is bound to state the truth upon any subject respecting which he is examined or makes statement, and to produce such documents as may be required. As held by the Apex Court in Kirit Srimankar, which I just read, no cause of action arises merely for reason of a person being summoned to state the truth or to make statements or to produce documents. And then, my lord, in Kuni Shetty judgment, the Honorable Supreme Court, my lord, para 14 is an interesting observation. In Kuni Shetty at page 162, their lordship said, my lord, a show cause notice.
Service law.
Paragilla. The principle, I am borrowing the principle. Allah, my lord, when I am borrowing a principle of a superior court, the law applied
later ways.
We as counsel sometimes we tend to take seriously. Yeah, but the difference here is their lordship.
Yeah, 2006 page 9.
Allah, adralli, in a show cause notice, my lord, at least I make an allegation. When I issue a show cause notice, you have violated this law. You have done this. You are liable to be punished, prosecuted. And then I say, please give reasons. For that, the Honorable Supreme Court says there is no cause of action. Please look at this summons. I said, please come to my office and I want to record your statement. When I have not even made any allegation. So, therefore, my lord, there is no cause of action. In the page 165, Commissioner of Customs, first 2 lines, my lord, their lordships refuse. Interesting judgment is of Raghav Bail. Only 1 line in Raghav Bail, page 167. My lord, the Honorable Delhi High Court said,
Samankar is followed.
Yes, and there, page 172, on the line, page 172, para 14. There is no violation of any fundamental right or any legal right of a petitioner warranting interference at the stage of summons. So, stage of summons, there is no violation.
That is the companion petition. The senior counsel C.V. Nageshwar appeared. Our summons matra.
Elrugo apply. Both to both, my lord, even for Parvati, my lord, although she is accused number 2 in the predicate offense, as of now, we have not lodged a prosecution complaint at all. We have only issued a summons. And when we issue a summons, my lord, we need not disclose for what purpose we are in requesting the noticee to come. Only after investigation, we'll decide. If there is some material, we'll proceed. If there is no material, we proceed further with others. Please have a look at page 175, my lord, very recent judgment, December 2024. My lord,
Justice Arvind Kumar.
Justice Arvind Kumar. But here also their lordships refuse to interfere in a summons. My lord,
discharge agogit.
Discharge agogit. Discharge agogit.
What the court of
yes. And then, my lord, the next proposition that I wanted to lay before lordship is that my learned friend Mr. Chauta made strenuous efforts to indicate that, and Mr. Nagesh as well, that their clients are not accused in the predicate offense. It is not necessary. Please have a look at Pauna Debur.
That's all.
Pauna Debur, my lord, one line in Pauna Debur, the last line in Pauna Debur.
I dismissed it. Supreme Court has reversed it. My dismissal is
Yes,
reversed.
yes.
It is
Allah,
allowed
Pauna
there.
Debur, 211, page 211. Page 211, para 31.1.
I had myself written,
Yeah.
one need not be an accused.
Yes.
In
I
the-
will read
in
just
the predicate offense for summoning and conducting investigation.
to
Supreme Court reversed it,
Yes,
saying
yes.
that if there is an allegation of conspiracy, only then it would survive. Otherwise, it's not.
But the
penalized.
principle that I want to read is
Yes.
31.1. It is not necessary that a person against whom the offense under section 3 is alleged must have been shown as an accused in the schedule of
That's
offense.
what I had written.
Yes.
Pauna Debur she was
Yes.
not accused in the predicate offense at all.
Yes.
You will appear again.
And then, my lord, the next proposition that I want to lay is that I have already, my lord, covered it, which is that proceedings under section 50 is, though called as an investigation, in the stricto sensu,
Civil inquiry.
stricto sensu is not a investigation for prosecution, it is a civil inquiry. So therefore, there is no difficulty for the notices to come and appear. In the end, my lord, I have furnished two judgments, which as a passing remark, my learned friend referred to the communication sent by the investigating agency to the complainant, saying that they have not found any material. But nevertheless, that does not have any bearing. But I anticipated that the other side would raise that issue, which is why I've already brought in two judgments. In a very recent judgment, the Division Bench of Honorable Madras High Court has held that if the investigating agency files a B report and if the magistrate accepts it, then ED can question it before a lordship under 482.
You just questioned it in one case.
Yes. And their lordships have referred to para 290, 190, to para 290 of Vijay Madan Lal Chaudhary.
One, I think, he has filed review hakidire adರಲ್ಲಿ, where B report admele I have.
So, my lord, I am as investigating agency, I mean, as an authority under the PMLA, I am interested in the outcome of these proceedings. I am interested in the issues. So therefore, my lord, in this case, merely because the investigating agency has said that there is no material, unless the court accepts it, my lord, I have got a legal basis to continue. So therefore, my lord, my continuation. Okay. Lord, would your lordship please have a look at page 238 in my compilation? Page 238.
I am there all.
Lord,
66(2) ಬಗ್ಗೆ ಅದರಲ್ಲೇ ಇರೋದು.
ಹೌದು, ಅಲ್ಲ,
Yes.
the 62. Which is why, my lord, may I read, my lord, because quite assertive submissions were made in respect of a letter that I have produced at annexure R1. Please have a look at 66(2).
No, it is here.
No,
Purport
Allah,
of that
66(2) ಓದ್ಬಿಡ್ತೀನಿ, but I am
contemporaneously sending
I do not
information.
understand how, my lord, my learned friend has a grievance if I issue a letter. My lord, please have a look at the scope of 66(2). 66(2) says, if the director or other authority specified under subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being, my lord, it can be a tax law as well.
This is no problem.
No, but my learned friend had a certain grievance against it, that how I can write. I can write. In the course of investigation, if something has come to my notice, why should I not bring it to the notice of the local enforcement authority?
Submitted.
I thought that was his.
What they're trying to write is about the investigation to the predicate offense, that they can't do.
No, that is.
No, I am giving
66(2)
information that
only.
is posted. No,
You are informing other authorities that these are
No,
the
let me read
findings of
annexure R1.
investigation.
No, let me read annexure R1. I don't find anything contrary to law.
No, that's all right.
And anyway, my lord, 66(2), it is for that local enforcement authority either to accept it or not.
That's good. It is not that
No, let me explain. My learned friend, no, let me explain. My lord, I have referred to, my lord, my learned friend had a problem with illegal allotment, illegal denotification. All these have led to generation of proceeds of crime. Somebody would denotify and get it allotted to somebody, gets money. We have materials for that.
For others,
Why should I not bring it to the notice?
Others, you bring it to the notice.
Yes.
You are bringing
No,
it
what
to
is
the
what is the
notice.
difficulty of these two petitioners if I bring it to the
No,
notice?
predicate offense. These whoever is here, our the proceeds of crime Allah though.
No, for each one of them, there is a different proceeds of crime. As far as Mr. Chauta's clients are concerned, the proceeds of crime quite clearly is 14.
14 allotments.
Yes. As far as Mr. Suresh is concerned, we have, during the course of the investigation, we have discovered that several approvals and directions were given from his office to the office of the MODA.
After he assumed office.
Yes, after he assumed office, and it continues. He continues in office. So we want to get some information from him. There shouldn't be no difficulty. It is only for the purpose of gathering information. It is to find out whether there is any, as someone.
Then what do you say about the coordinate bench? That also was for that purpose only.
The coordinate bench, my respectful submission is, that the certain observations in that judgment are per incurium, it is under challenge. His
per incurium to what?
Per incurium to the law declared by the Honorable Supreme Court. It's a per incurium, I mean, to opposed to para 290, para 431. Vide Madala. That para 54, 55, 6 of that judgment requires me to record a prima facie case, even to summon, which is not the law.
Which coordinate bench is?
Yes. It says you should have a prima facie case to even to summon. And I furnish judgments to point out, the main ground on which his lordship was inclined to accept is that upon going through the reasons to believe, which we gave in a sealed envelope, his lordship felt that it is not sufficient in that case. In that case, against that petitioner, as against that petitioner, his lordship felt it is not sufficient. That is not an argument which is raised in this case. That is not an argument. So therefore, that is the main issue. The main issue was whether the reasons recorded in the reasons to believe is sufficient. And the answer to that, it is not sufficient. It says it does not meet. So therefore, my lord, that judgment would not be of much help. Therefore, my lord, to summarize my submissions, my lord, there is a predicate offense, and pursuant to that, proceeds of crime have been generated, and we have registered a ECR. In connection to the ECR, we have merely summoned both the petitioners, and our inquiry is of civil in nature. We want them to produce certain documents. We want them to disclose their property and account details, as also their relatives, because our past experience has shown that proceeds of crime is generally purchased in the names of relatives. So therefore, we want to investigate that. And this investigation is permissible in law. I have followed all the safeguards which are predicated under 17 as well as 50. And the challenge.
Now, if it does not cooperate, what do you do?
Well, they will
civil inquiry in the law.
There is a law, we'll follow it. I do not want to make a submission. There is one issue, which my learned friend, my learned friend mentioned about he referred to the submissions made by the learned Solicitor General and the additional Solicitor General. The Supreme Court has repeatedly said, do not read judgment like a statute. But my learned friend went beyond that. He is reading the submissions made by the law officers as a statute. One cannot read portions of the submissions to interpret as a law. We have to understand for what purpose those submissions were made. So therefore, when judgments cannot be understood as statute, the submissions made by law officers cannot be treated as statute. We have Section 3 that has been interpreted by the Honorable Supreme Court. That should be.
No. His submission was, what is the intention of the, what is the mind of the union also is what is.
No, one cannot take out piecemeal submissions to it. One has to understand the entire judgment and then to it. So, piecemeal reading does not give the entire intention of what the Union of India is. So therefore, my respectful submission is that it is not permissible to read a portion of it and say, this is what the government intended. Our submissions have been considered by the Honorable Supreme Court and interpreted. It is the interpretation of the Supreme Court which matters. I am grateful.
Yes. Fantastic. Yes.
2-3 aspects of it.
Rarely some great submissions. Yes. Yes.
I'm sorry. 65. Well, Section 65 makes the provisions of CRPC applicable. No doubt about that. When my learned friend is saying that you are not an accused, I have never labeled you as an accused, instead of issuing me a notice under Section 50, as my lord has pointed out, non-compliance would entail my arrest and all that. You ought to have issued me a notice under Section 161 CRPC.
Statement recording.
I'm not a police. Supreme Court says I'm not police.
Sorry, but section 65 says the provisions of CRPC are made applicable. Issue me a notice. Why a notice under section 50? ಇನ್ನೊಂದು ಹೇಳಿದ್ರು ಅವರು 482 ಇನ್ವೋಕ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ? To secure the ends of justice, to prevent the abuse of process of law.
Miscarriage of justice.
Miscarriage of justice. We can suddenly invoke the jurisdiction of the court under section 482 or even under the article 226 and 227 of the Constitution.
So long as it's seen that the basic ingredients to constitute an offense is missing, then to say, no, allow us to have a roving inquiry, we will fish and we will see what we can get out of it. That is totally impermissible, my lords.
Yes,
If
sir, they will fish to find something fishy.
Fishy and then go. That can't be done. Now, if at all, my lords, they're not in a position to show that there was an activity or a process in furtherance of this proceeds of crime, where lies a power or jurisdiction to register an ECIR and have an inquiry? Very basic. And then, my lords, no, my lords, then
power
Alla, basic ingredient illidre. My lords, now when we say basic ingredient, right from Bhajanlal to whichever case that we see, my lords, if the basic ingredient to constitute an offense is lacking, you don't proceed further there.
No, that is the reason for quashment.
Quashment.
Our power, like to register an ECIR, it's not correct.
So, my lords, now to say we will issue summons and will test the waters and see what we get out of it. My lords, issuing summons under section 50, will there not be some basis for the issuance of summons? Because, my lords, this particular act goes on the aspect of reasons to believe, not reasons to suspect. That is exactly what Vijay Madan Lal says. You can't go on the aspect of, I am suspecting something, I will do an inquiry. No, you should have concrete reasons to believe. And that reasons to believe, my lords, in my respectful submission, in 8 provisions of the PMLA Act, it is there. Section 5, 8, 16 to 21. Reasons to believe. Now, without having any reasons to believe, let me find out what exactly I can get out of this inquiry. That can't be permitted. And that affects my own right for a fair investigation or an inquiry. My lords, I again go back to Article 21 there. This is one aspect. Finding fault with me, returning this properties, my lords, as though it's an admission of guilt. My lords, I am the wife of the Chief Minister of the state. And if someone is going to be pointing fingers at the Chief Minister, my lords, my respectful submission is I would have a moral responsibility to ensure that such kind of allegations or such kind of belief that the public has, it should be drowsed at the earliest. I return the property to the rightful authorities. That can't be treated as saying he's admitting to his guilt. No, this may definitely not be so, my lords.
But predicate offense will not vanish.
No.
Because you have
no, my lords,
this
we are
will consider.
Absolutely, my lords. Then, my lords, for them to say with belief, no, my lords, then to say, my lords, this allotment of sites itself is an offense. On what basis are we saying this? On what basis is it being said? They have concluded that it is as though it's an offense. So, my lords, when they're saying all that we're trying to do is we're just trying to find out some information, that is not what they're doing. Please notice page 63, R1. They specifically say it's an offense of money laundering. Please notice what they say.
I've seen, yes.
Yes, my lords. So, if there's specific case that it is a case of money laundering, then can we put it across in an innocent manner in saying, look, all that I'm asking is for some statements? No. Please notice 63, my lords. In the statement of objections, page 63.
Yes, the beginning.
Categorically, they say, offense of money laundering. By whom? They name the Chief Minister, my lords.
Summary.
And making it appear nothing. After all, we have just issued some summons for some inquiry. May not be so, my lords. It has serious consequences. And if your foundation is not there and you do things in such tearing hurry, it is a case where the court will definitely interfere, my lords, either to meet the ends of justice or to prevent an abuse of process. This is where it stands, my lords. So
ನಿಮ್ದು ಇದೆಯಾ ವಿಕ್ರಮ್ ಇನ್ನು ಇಲ್ಲ Sir, ನಿಮ್ದಾಯ್ತಾ? ಆಯ್ತಲ್ಲ?
Great.
Oh. ಬರಕ್ ಹೇಳಿ. ನಾನು ಬರ್ಕೊಂತ ಎಲ್ಲರದು ಬರ್ಕೊಡಿ. ಸಾನ್ಯಾ.
File ಕೊಡಿ sir, file ಕೊಟ್ಬಿಡಿ sir. ನಾನು
Make a means. ಎಲ್ಲರದು ಹೆಸರು ಬರ್ದು just give it.
There was one more item 42. I don't know. Item 42 on the ID matter, where my learned friend Mr. Siddharth or
Oh, this is not special court.
if it can be taken in Bangalore.
I'll take it in Bangalore. ಆಯ್ತು, ಬೆಳಗ್ಗೆ ಸಾಯಂಕಾಲದವ್ರು ಕೂರಿಸ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದೆ.
ಅಲ್ಲ, 26th ಗೆ he has undertaken to bring some documents on 26th. Let him do it.
In fact, Manoj,
No.
the same argument what you've done, Manoj.
Cooperate. I have asked you to
You
cooperate.
not, he has to cooperate. He has to cooperate.
I've gone 3 times after my lodge.
ಇಲ್ಲ, ಇವತ್ತು ಸಾಕು. We're exhausted.
Still then, Manoj, because still my lodge.
No, Lord, on 26th, he has undertaken to produce some documents. Let him.
Whatever he is, see, if you have undertaken their good,
Manoj, they presume that I've undertaken.
all right, you, whatever cooperation you have to give, you give.
No.
Not necessary, that is not necessary. The note, we'll deal with it, yes.
Still my lodge decides that at least, Manoj. Still my lodge decides at least. At least because, Manoj, I have
No,
already.
there is already some protection given. Let that continue.
Protection.
Yes, let that
They will
continue.
not take any coercive steps, I've
Yes.
already said.
Yes.
Decide, Manoj, at least whether or not they have a base to even register, because 2018.
No, my lord, this is a clear case, my lord. This is not a elimination of the crime itself. My lord,
2023 is registered the ECI.
Your father was the accused,
Mother was the accused.
mother was the accused.
I was not.
And
only.
and mother transferred the property.
No property, Manoj. She's not.
Travel.
Anything. Ilve illa, Manoj. because
Trail,
2018
property trail.
ನಲ್ಲಿ, Manoj, it was closed.
No, my lord.
2023 they
My lord,
registered
the
ECI.
interim order in the same fashion. my
I
lord,
take it on 7th, whatever interim
very
order
well.
is there, that.
We'll continue. Great.
Still then, Manoj, because
No,
I
no,
have
no.
to cooperate. I have to
Siddharth,
cooperate.
I have heard you and granted that. I will hear you only and modify it, both of you. If it has to be modified or whatever order is.
Very well, my lord. 7th.
Yeah, again. the
Hello,
issue-
Seventh
will my lord
Thursday.
take up?
They call me from 6. They call me from 11.
No, my lord, my lord, I have personally had a call, a chat with the officers. This is not true. I deny it, my lord.
I-
A
no, no,
responsible
no,
statement.
I will not.
Same thing saying that from 11.
No problem, no problem. We'll take it on 7th, ಅದು ಬರ್ಕೊಳ್ಳಿ.
At least still then.
My lord, may I mention the part heard matter if it can be taken?
One moment, sir, one moment.
11 they make me sit there, Manoj. Every single time. And I'm a. Not, I'm a.
I deny, my lord. I
He says,
deny.
no, I have already
I
said,
deny.
I have already observed, despite
These
that
are
they're
not-
doing that, no, that's not.
One cannot earn sympathy in this manner.
ಅಲ್ಲ, ಇದಕ್ಕೆ 26 ಇದೇ ಮಾಡ್ತಾರೆ.
ಏನಿಲ್ಲ.
And Manoj,
ಹೋಗ್
somebody
ಬನ್ನಿ.
who has a history
He has to
of
cooperate.
rape before, Manoj.
My lord, he has to cooperate, my lord. These are all
I have
serious
asked you to
allegations.
cooperate with the proceedings, you have to. That's-
Like, cooperating, yes, Manoj, but then to what extent, Manoj? Not from 11 to 6 in the night, Manoj. In the evening, rather.
I did not say nature of, I did not qualify the nature of cooperation.
Then what do I do from 11 to 6, Manoj? Every single day they make me sit there.
No problem. You don't carry your phone, is it?
No, I don't know what he means by every single day. My lord, when we called last 7th February, we called, he undertook to come, he didn't appear. And then my lord, net friend has he's saying that every single day.
Liberty what, for what?
Liberty to seek for an adjournment. There.
Seek for an adjournment.
No, he didn't even seek that.
Adjournment. That's
No, if I see that you have not cooperated, I'll vacate that.
Please, my lord, I'll file an affidavit of the officer.
Yes, you file an affidavit if he's not
Yes, my lord, I
cooperating.
will do that.
List on 7th, yes, yes.
I'm grateful.
List on 7th.
Not call me again, Manoj.
Because
they
I've,
produce something
it's,
at least.
I've heard it, Allah. List on 7th for further hearing, yes.
Let them show for what I'm required them, Manoj, because there's nothing here. Because
You ಹೋಗ್ ಬನ್ನಿ first, yes.
so ಹೋಗಿದ್ದೀನಿ Manoj. ಪ್ರತಿ ಸತಿ ಅಲ್ಲೇ
List on 7th, yes. We'll continue the list and finish it off.
Hello.
Monica, madam. Where is she? She was here. Still, continue the list.
My lord, in that matter which your lordship has reserved for orders, interim order.
No, I have to make my submission.
I'll pass a note. Just one, I'll just run through the list, sir, 1 minute.
Earlier case.
I have to make submissions before my lord
Extended.
passes the orders. my lord.
That will extend. Yes. 6, Monica, madam. Stay ಇದೆಯಲ್ಲ, criminal appeal ಅಲ್ವಾ? It will come on 7th.
30 days bail has been granted by the trial court. Conviction order is passed. Senior counsel is briefed in the matter, my lord.
ಎಲ್ಲಿದ್ದಾರೆ?
My lord, it's on his legs in court hall 2.
ಆಯ್ತು, pass over. Yes. 7 and 8. Interim order ಇದೆಯಲ್ಲ ಎರಡರಲ್ಲೂ? Yes. List on 14th March, interim order subsisting will continue to the next date of hearing. Yes. 17?
7 and 8 both stay, sir. 7 ಮತ್ತೆ 2 ಇದೆ. 7 ಮತ್ತೆ 8.
Interim order ಇದೆಯಲ್ಲ.
ಇದೆ.
7, list on 14th, interim order subsisting will continue to the next date of hearing. 8 ಅಷ್ಟೇ. 8 post immediately after service of notice upon the respondent, interim order subsisting will continue to the next date of hearing. Post immediately after service of notice upon the second respondent, interim order continue ಮಾಡಿ.
Interim order ಇಲ್ಲ.
ಇಲ್ವಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಇಲ್ಲ. interim order ಇಲ್ಲ ಅದರಲ್ಲಿ. ಎಸ್. ಅಲ್ಲಿ ಒಂದು ಕೆಲಸ ಮಾಡಿ, heard the counsel for the petitioner and additional SPP BN ಜಗದೀಶ್ ಅಂತ ಬರೆದ್ಬಿಟ್ಟು interim order action ಮಾಡ್ಬೇಕು ಇರೋ ಕಡೆ. ನೆಕ್ಸ್ಟ್ 12. 12 ಏನು? 12 ಏನು?
11 ಅಲ್ಲಿ stay ಇದೆ.
My lords,
ಅಲ್ಲ ಗೊತ್ತು.
11, my lords, I appear for the
2 weeks to do the needful. Interim order subsisting will continue till the next date of hearing.
date may be fixed, my lords.
21st March, yes.
Much obliged.
Next.
Lordship, serial number 32, your
Wait,
lordship.
madam. Am I not calling the list cases?
Please, your.
Yes. 12 ಅಲ್ಲಿ 2 weeks to do the needful. List on 21st March. Interim order subsisting will continue to the next date of hearing. 13. Post immediately after service of notice upon the second respondent, interim order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಅದು heard so and so ಅಂತ ಆದ್ಮೇಲೆ ಇಬ್ಬರದು ಎಲ್ಲದರಲ್ಲೂ ಅಡಿಷನಲ್ SPP BN ಜಗದೀಶ್. 14.
For petitioners, my lord. My lord, your lordship had stayed the investigation in crime
list
number
on-
155/2024.
List on 24th.
My lord.
First interim order ಇಲ್ವಾ?
ಇದರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕ್ರೈಮ್ ನಂಬರ್ 155/2024 ಕೊಟ್ಟಿದ್ರಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಆದ್ರಿಂದ ಈ ಹೊಸ ಪಿಟಿಷನ್ ಹಾಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ. ಈಗಾಗಲೇ ಕೊಟ್ಟಿದ್ರಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 21276/2024 ಅಲ್ಲಿ ಇತ್ತು, ಸ್ಟೇ ಇತ್ತು.
ಈಗ ಇದು ಹೊಸ ಪಿಟಿಷನ್ ಇದು
ಹೊಸ ಪಿಟಿಷನ್ ಹಾಕಿದ್ವಿ, ಯಾಕಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು.
2 and 3.
Yes, list the matter on 7th March. There shall be an interim order of stay of additional SPP is directed to accept notice for the first respondent. Emergent notice to the complainant returnable by 14th March. For returnable by 14th March. There shall be an interim order of stay for the proceedings till the next date of hearing. Yes.
This is number 24254, sir.
Next.
Much of.
Mayurti Bhanu.
Not appearing for the petitioner in this one. Not these are the other 57 petitioners in connection to the.
Bitra.
Yes, my lords. My lords, the connected matter which is reserved is WP number 31069/24, my lords. These are all consumers itself, my lords. There is nobody else.
We'll post this on 21st. By then we'll do that. List the matter on 21st. Yes.
My lord, 21st of March.
Learned additional SPP is directed to accept notice for the respondent.
Lord, I have a humble
respondent and Vivekanand Bandrala. Santosh
we
Hospital
have not made a party. I have not made them a party in this petition, my lords.
Madidirala. R2.
Yes, my lord. I'll serve a copy on that, my lords. My lords, one humble request, my lords. My lords, the case is posted on 27th of this month.
List the matter on 21st. The concerned court shall defer its proceedings till the next date. Yes.
Grateful, my lords. Grateful, my lords.
Next. Appeals list on 14th March.
Interim order is the actually.
Interim order continue. Interim order appeal admit to stay ಆಗಿರೋದು.
ಫೈನ್ 25% ಅಂತ ಮಾಡಿದ್ರು. ಅದರ
ಫೈನ್ ವಿಷಯವಾಗ ಅದು.
ಫೈನ್ ವಿಷಯ.
ಅದು ಯಾವತ್ತಿಗೂ ಹಾಕಿದೀನಿ ಅದು.
ಇಲ್ಲ ಅವೆಲ್ಲ ಆರ್ಗ್ಯೂ ಆಗಿ ಮಾಡಿಫಿಕೇಶನ್ ಕೇಳಿದ್ವಿ, ಅದನ್ನ ಹಿಯರ್ ಮಾಡೋಣ ಅಂತ 7th ಗೆ ಹಾಕಿದ್ದೀನಿ.
7, 8
ಹಾಕಿದ್ದೀನಿ ನಾನು. I posted all those matters on
7, 8, 7, 3 my lord.
List these matters on 7/3. All, both 17, 18.
Obliged.
Yes.
Swami Goda.
I appear for the petition, my lord. Withdraw this petition, my lord.
Withdraw Allah?
Yes, my lord.
Thank you, sir. Yes. Learned counsel for the petitioner seeks leave of the court to withdraw the petition. Petition is disposed as withdrawn. Yes, next.
20.
For the petition, my lord, offense under 306, my lord. The
Stay ilva?
Stay illa. Stay first time ಬರ್ತಾ ಇರೋದು.
List the matter on 7th March. Yes, next.
Lord, stay of the proceedings, my lord.
Avat, yes. 21st.
21, my lord. I appear for the respondent in 21 and for the petitioner in 21.1, my lord.
21st ಅಲ್ಲ. Sir. Previous matter. 7th March. Yes. Serial number 21. Yes. List the matter on 7th March. Yes.
Interim order may extend, my lord.
Interim order, yeah, 14th March. Interim order subsisting will continue to the
there.
next day.
No, I'm for petitioner, my lords. My lords, the mother-in-law petition, my lords, crime na challenge ಮಾಡಿದ್ವಿ. By that time, the charge sheet was filed, then it is withdrawn, and the new petition has been filed.
List the matter on 14th March. Interim order subsisting. There
No,
shall be an interim order of stay. Yaar, the husband alla tha?
ಅಲ್ಲ, ತಾಯಿ.
Sorry. There shall be an interim order of Yen Jagdish?
A2.
There shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Next.
23, Ravi Shankar.
Special court, 7th
My lords,
March.
appearing for the respondent number 2.
7th March, interim order will continue. Next.
My lords, there's no interim order, but the
That-
petition has, sir, my lords, the petition has become infructuous because
Thank you,
the
sir.
witnesses have been
The
discharged.
Learned counsel for the petitioner submits that the petition is rendered infructuous.
My lords, I'm for the respondent.
My lord, serial number 23.
You are respondent or petitioner?
Respondent, I am for the respondent, my lords. Respondent number
How
2 to
can you say it has become infructuous? Yes, madam.
My lords, I need a week time, my lords. I was hospitalized, so I couldn't seek the instruction.
All right, sorry. We'll take it on 7th.
Bless
My
you.
lords, the witnesses have been discharged.
That's all right. List the matter on 7th. Interim order, yeah, madam?
There's
No,
no
madam.
Yes, list the matter on 7th. Yes, next.
24,
Appearing in favor of petitioner, my lord. My lord, appearing in favor of petitioner.
Defreezing of accounts, you can. Asking for defreezement of account, challenging those defreezing.
7th, list the matter on 7th. Yes.
25, Lakshmikant K.
Appear for petitioner, my lord.
Same order.
353, 506, man. 504, my lord.
Interim
Sir.
order, yes, next.
ಇಲ್ಲ my lord.
Ilva?
ಇಲ್ಲ my lord.
ಯಾಕೆ interim order? Oh, this ರಾತ್ರಿ ಹೊಡೆದಿರೋದು. Yes.
ಅಲ್ಲ my lord, ಸರ್ವೆ ಮಾಡಕ್ ಹೋದಾಗ ಗಲಾಟೆ ಮಾಡಿದಾರಂತ.
List the matter on 7th. Yes,
ಅಲ್ಲ my
next.
lord, stay ಮಾಡಿ ಅದು 15
No, no,
RSA pending ಇದೆ.
The 7th, yes. Next.
26, Milord, 26, Milord, for the petitioner.
ಆಮೇಲೆ
Milord, this is 120 grams of ganja, Milord. There is an interim order of stay may be extended.
Deputy to Supreme Court said that now.
list on 7th. Interim order subsisting will continue to the next date of hearing.
Grateful, ma'am. Vishwas is ready.
27th list on ಕೆಲಸ
My lords, my lords, 27, my lords.
My lord, I'm a proxy counsel, my lord.
No proxy, I would dismiss the other case. This is also going to go the same way. Dismiss.
The advocate of record has his marriage on March 1st, my lord.
Next,
So kindly
yes.
excuse.
No, sir, co-accused have dismissed. What else remains? Next.
28, Virupaksha.
So, my lord, the petition is dismissed, my lords. I take it.
Yes, dismissed.
Grateful, my lords.
My lord.
Yes,
my lord,
next.
I put
My
in
lord,
my appearance
please.
in the chat box.
Next,
Since
yes.
I'm from Delhi. Thank you, much. Grateful, my lords.
28.
27, they've come on discharge application.
27. Discharge reject ಆಗಿದೆಯಾ? Dismissed ಮತ್ತೆ. Yes. Co-accused have dismissed on its merit.
That was
My lords, criminal petition number 7578/2024. Your lordship's order is dated 3rd December.
Production of documents. Production of documents was challenged. That was the thing.
Oh, that was production of documents. No, but I have said it can be produced.
Yes, but this is on the command discharge.
Then let it wait, sir.
No, my lords, your lordships have dismissed the petitioner's challenge to magistrate order permitting the prosecution to place on record additional documents.
That's what that does. This is discharge order, I guess. I'm told Monday 24th. Yes. Monday in the fresh matters list. Yes, next.
28, Virupaksha.
Interim order continue. List on 14th March. Interim order subsisting will continue to the next date of hearing. There is no interim order, sir. Additional SPP is directed to accept notice for the respondent.
My lords, pardon my my asking. Has the petition been dismissed? Item 27 or will be taken on
24th in the fresh matters list. Monday.
My lords, can it be 25th? I have a very important matter in Delhi High Court.
All right, 25th, no problem.
Much obliged. Much obliged.
Eyewitnesses are in. 2 to 5 are eyewitnesses.
One additional SPP, 2 emergent notice, returnable by 21st. Next.
29, Nanjundappa.
354. 6 to 12 are eyewitness.
Quash ಆಗಿದೆಯಾ?
Eyewitnesses are there. 354 offense.
Additional SPP is directed to accept notice for the first respondent. Emergent notice to the second respondent, list on 7th March.
Bill number 30, Krishna.
Axis Bank covered, same order. On the Axis Bank order there. Yes.
Bill number 31.
I appear for the petitioner in this matter, my lords.
Yes, Jayasham.
My lords, offense under section 500, my bona fide complaint to the governor of Karnataka regarding a security breach, my lords, is termed as a defamation and cognizance is taken against.
Emergent notice to the respondent, returnable by the 21st, there shall be an interim order of stay of further proceedings. Further proceedings in CC 39430 of 2024 till the next date of hearing. Next.
Grateful, my lords.
Vinita PC.
Your
Covered,
Lordship,
Madam Madhu?
annexure demand notice.
Is it covered or not?
Yes, covered. Your Lordship, judgment at page number
Disposed, yes.
338. reported.
Disposed, madam. Yes, next.
Please. Grateful, Your Lordship.
Yes.
For the petitioner, my lords, your lordship had already quashed the proceedings as against accused number 1. The petitioner is accused number 2, my lords. The offences are section 3, 4, 5, 6 of ITP Act and section 370 of IPC. My lords, the matter is listed before.
NDPS, sir.
ITPA.
ITP.
She manages this thing, and the witness statement says that she collected money and then given to the other people. A1, the lordship
For
quashed it
A1,
because
A1 neither.
A3.
This is A2, my lords. The instant petitioner is A2.
A1 next time madidira.
I squashed, my lords.
Washed.
Because he was not
Please,
the...
my lords. The annexure is produced at annexure E, my lords. The accused number 1 was orthopedic doctor.
Additional SPP is directed to accept notice for the respondents. List the matter on 14th March.
My lords, the matter is.
1 minute, madam. There shall be an interim order of stay of further proceedings where the petitioner on the score that the petition on the submission that way accused number 1 is this court and writ petition 22273 of 2024 has quashed the proceedings. Yes. Next. Further orders, Pada. GMDRT.
Number 38.
38.
38.
ಏನು
36 ಸ್ವಲ್ಪ
ಕರೆದ್ಬಿಡಿ ಅಲ್ಲ
34 ಇತ್ತು.
For respondent.
My lord, 34, my lord, these are matters with regard to the delay in surfacing proceedings, whether it can be condoned. My lord, the division bench has held that condonation of delay under section 17 is not permissible. So maybe all this will have to go together.
ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬೇಕಾಗಾರೆ.
Yes, my lord.
By lots 34.4. I'm
all we'll see. I'll have it in Bangalore.
38.
List on 7th. Interim order subsisting will continue till the next date of hearing. Yes.
Serial number 35, your lordship.
35.
BB Patil name may be deleted, your lordship, kindly.
Who is there?
Latif is there.
Registry to delete the name of BB Patil as appearing for the respondent. List on 14th. Interim order subsisting will continue to the next date of hearing.
I appear for respondent number 2, my lords.
36, my lord. I appear for the petitioner.
Sir.
Your lordship may have it on 7th when you are in
I'll have
Bangalore.
it. Bangalore, yes.
I have the pleasure of appearing
List
before
on-
you personally.
List on heard the learned senior counsel Anant Mandagi appearing for the petitioner and so and so. List the matter on 7th. Interim order subsisting will continue to the next date of hearing. Yes.
It is still for the orders already granted, my lord.
It's absolute, is it?
Yes, yeah, absolute, my lord.
List on 7th. Next.
Highly open.
Much obliged, my lords.
37 IS Pramod.
My lords, appear for petitioners, please, my lords.
Intellectual property.
Please, my lords, there is a termination notice they have issued, please, my lords. Both the termination notices being challenged in the civil court, please, my lords, in Mumbai. Now, after they do not get any interim relief,
think
please,
my
my lords.
learned friend should be
Bangalore.
After they do not get any interim relief, please, my lords, they go and file a criminal case against
Sure,
me.
ಯಾರಿಗೆ?
Lords for the petition.
Matter which is purely civil in nature, my lords, a cloak of
My lords may
criminality.
kindly hear this
Yes.
matter on 7th, my lord. I'll satisfy your lords.
There's two-
I think they are enjoying an
You will
interim.
what?
I'll satisfy your lordships, my lord, about the maintainability of the complaint. I think, my lord, there is an interim order to their benefit.
The interim order, my lords, what is happening is we're looking for some funds for the company, my lords, which we're not able to do because of this criminal case. So next week. if
That's
it is
exactly
possible-
what he wants.
7th, my lord.
Seventh. will take it on.
Is that matter pertaining to hits music, my lords? There are 2 orders passed by my lords, 27-8 and 19-9. 2 orders that were passed. Despite the first order of not to take any coercive steps, they came to the office, they were sitting there, and then we had to bring it to the notice of the court, my
So
lords.
it's a hit.
19-9.
All right, yes.
They are unable to play any hits because of this is what their case.
ಇದು criminal case ಆದ್ಮೇಲೆ flop ಅಲ್ಲ. Next.
My lords, one more submission. Previous council's name is being reflected, please. Not my name may be reflected.
IS Pramod Chandra. Delete ಮಾಡಿ.
Delete ಮಾಡಿ
Chinmay Mirji ಅಂತ print ಮಾಡಿ. Yes.
So on 7th, my lord.
Heard the learned senior counsel Sandesh Shota appearing for so and so. MS Sham Sundar appearing for the respondent. Yes, next.
Please.
39. Tilmani Varsha Dilip.
39th.
My lords, I appear for the petitioner.
37 ಆಗಿದ್ದು.
38.
Please.
ಏನ್ ಮಾಡಿದ್ರಿ refreeze ಮಾಡಿದ್ರಾ?
They have defreezed all the accounts, my lord.
Yes, Dinesh Kumar has done the job.
Yes, my lord.
ಆಯ್ತು. ಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ತೊಂದರೆ ಮಾಡಬಾರದು.
I do not know that he could.
I will not observe anything.
Please, my lord. No.
And complainant has already said that maybe cost will take
Yes,
it as
sir.
disposed cost.
Yes.
Yes,
ಅದು ಡಿಫ್ರೀಸ್ ಮಾಡ್ತಾರ ಅಂತ ಕೇಳಿದಕ್ಕೆ ಮಾತ್ರ ಹಾಕಿದ್ದೆ ಇವತ್ತು. Let him not appear there. ಸಾಕು. Yes. Next.
My lords,
Disposed.
serial by number 39.
14th March.
Appearing for the-
Interim order will continue
My
to the
lords,
next week.
My lords, it's a covered decision. My lords, 3 times it has already come up. In fact,
ಏನ್
my lords,
covered?
lordship's decision. This is a FOC registered against the director of the company without arraying the company as an accused. My lord's decision in Madhusudan versus
I-
state.
I think further hearing ಅಲ್ವಾ ಇರೋದು madam. We'll close it, don't worry. Yes.
ಇಲ್ಲ, my lords, yeah.
List
My
on
lords,
7th
instructions.
March. 7th March.
Grateful, my lords. Interim orders,
Interim order subsisting will continue till the next date of hearing.
Mostly
Yes.
7,000 cross.
grateful, my lords.
7,000 cross ಆಗ್ಬೋದು.
ಇರೋದೆಲ್ಲ
Grateful,
7th
my
ಗೆ
lord.
ಹಾಕ್ಸ್ತಿದೆ. ಯಾವುದು ಎಲ್ಲ 7th. Friday.
ಅದಕ್ಕೂ ಮುಂಚಿನ ಡೇಟ್ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ. Grateful, my lords.
Yes, yes. Next.
Number 40.
My lords,
Ramesh
interim
Bhai.
order in all 3 of matters.
Party appear for the respondent, my lord.
ಎಲ್ಲಿ ಇವ್ರು ರಮೇಶ್ ಇಲ್ಲ?
Ramesh, he has filed a memo for retirement.
Who has come on record?
Now on MN Madhusudan.
Come on record, my lord.
List on, 1 minute. List on 3rd March.
My lord, may I seek
3rd March ಅಷ್ಟೇ. Wait till then.
Please.
3rd March, interim order subsisting will continue to the next date of hearing. It's made clear no further adjournment will be granted on the said date. Yes, next.
Much obliged.
51. Sampreet P.
For the respondent, your lordship.
Yes.
It's proportionate assets case.
ಓ ಇದ್ಯಾಕೆ ಬಂದಿದೆ ಇವತ್ತು? ಯಾವತ್ತು ಹಾಕಿದೀವಲ್ಲ? ನೀವು ಇದ್ದೀರಾ? 7th. ಅಲ್ಲ, I think March 13th ಹಾಕಿದೆ. List on 13th.
Interim order to be extended.
Lordship, the investigation may continue, lordship.
Interim order ಏನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes, next.
Great favors.
42. Siddharth Suman.
ಆಯ್ತಲ್ಲ ಈಗ. Yes. 42ನೇ ಆಗಿದ್ದು. List on, yes, list on 7th ಆಗಿದೆ ಅದು.
43, my lords. We may not argue on merits, my lord, that it's covered by that, what Leonard SPP says about that, not hearing the police officer, my lord.
175.
Yeah, the lordships may dispose it off on those.
The Supreme Court order. Yes.
Oh, that's there.
ನೀವಿದ್ದೀರಾ Vanti?
Otherly, I seek some accommodation, lordship, on behalf of Ravi Binay.
On merits, my lord,
Let his judgment covers
it can go on.
Om Prakash.
ಯಾವ paragraph, Jagdish? Covered.
Next week.
Supreme Court covered.
Para
Here
5.
order ಮಾಡ್ಲಿ.
On merits, my lord, let him hear the police officer and then, please.
Before referring the matter,
Yes.
175(3).
ಅಷ್ಟೇ ಇರೋದು. We will not go into the other, please.
156(3) ಪ್ರಕಾರ 175(3) ಅಲ್ಲಿ he has to be heard. That's what Supreme Court says.
Please, please.
Justice Pardiwal ಅವ್ರ ತಾನೆ?
Yeah, Justice Pardiwal.
Yes.
Please.
Disposed.
Please.
But copy only next week.
Sorry.
Copy only next week.
Please.
Don't be in a hurry for that. Yes.
44. Dalwai
For petitioner, CBI had to file a status
Status report.
ಕೊಡಿ.
There is
status
also
report of the.
Give.
We have also made a request, not in the status report, not for a direction.
Let me see. ಇದು 3ನೇ ತಾರೀಕು ಹಾಕ್ತೀನಿ ನೋಡ್ಬಿಟ್ಟು.
ಅದ್ರ ಒಂದು
ಈಗ ಡೈರೆಕ್ಷನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಅದ್ರ ಒಂದು ಸ್ವಲ್ಪ ಅದ್ರಲ್ಲಿ we just require not small direction, which is not holding up the investigation because of this reason.
ಯಾಕೆ ಹೋಲ್ಡಿಂಗ್ ಆಫ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್?
So ಕೆಲವೆಲ್ಲ there are certain documents which are in the custody of the other agencies, not which
I have already permitted you to
ಅದು
summon.
ಕೊಡ್ತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ we have made a specific request, not
Request to whom?
not CID, ED, CFSL and SFSL, and also not the court.
ಇದರದು ನಿಮ್ಮ ಯಾವುದು?
ವಾಲ್ಮೀಕಿ.
ಹಾ, ವಾಲ್ಮೀಕಿ.
From page 5.
ಹಾಗಾದ್ರೆ you appear on Monday.
Please.
We'll pass. I'll look into this and pass out.
Please.
List on Monday. Yes.
Monday 2:30 minute, Mary.
Monday 2:30.
Please.
Yes, Angad.
For the petitioner, Lord, I'm handing over set of.
Where is Praveen Gowda?
Praveen Gowda has come, Lord. My learned
My lord,
friend.
respondent number 2.
Idaralla.
I'm.
Irin Swami.
Yes.
I'm sorry, and my learned friend is
No
kind
problem,
enough to.
In full power.
ಈಗ with full power ಅದು.
Lord, your lordship's adjournments have really helped him in some way win the election.
That's
Last
what-
3
Oh.
adjournments that your lordships have granted him.
Your lordship's words have come true, my lord.
ಮತ್ತೆ yes.
Lord, on my learned friend's behalf, I'm
My
submitting some.
learned friend is kind enough to help me out by supplying, furnishing the copy of the sanction which has been obtained, my lord. I'm sorry about as my physical appearance is not before your lordship, my lord.
No problem, sir.
Lord, your lordships have heard me at great length.
No, this is sanction ಕೊಟ್ಟಿರೋದಾ?
Just to,
ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
your lordships have heard me at great length. Your lordship's record of proceedings reflects that the entire dispute has been narrowed down to one single fact as to whether there was a 17A. I've gone through each and every document that's appended to that booklet, my lord. There is no 17A. Even if we assume, Lord, that there is a 17A, if your lordship were to see the table, my lord, in that table, the 17A is granted on 1/10/2024. And not the charge sheet is filed on 21/8/2024. Even on an admitted case, let me take it, my lord, that there is a 17A. By their own case, the 17A has been granted on 1/10. Charge sheet is filed on 21/8. That itself, my lord, should result in the quashing of the entire proceedings. Lord, I'm submitting a written submission. I've already served my learned friend, Lord.
ಪ್ರವೀಣ್ ಗೌಡ್ರೆ,
ಸ್ವಾಮಿ
ರೆಡಿ ಇದ್ದೀರಾ?
ರೆಡಿ ಇದೀನಿ ಸ್ವಾಮಿ.
Lord, I have to only read one document. If your lordship were to take the booklet that's submitted on behalf of my learned friend, Lord.
May make one submission, my lord.
Lordship were to come to page 3. No, it's not paginated, Lord, but
May
11024 document.
yes, ma'am. That 1/10/2024, Lord. That document only says that the chief minister has in fact granted 17 approval, but they have not produced the original 17A order itself. So even if we take it that there is a 17A, that 17A order comes after the filing of the charge sheet. And Lord, they have not yet produced the original 17A. This is just some internal documentation which says there is an approval.
Has to happen whether it is application of mind or not and things like that. In 17A, they have not produced what is the order. If they produce the order, further questions of whether it bears application of mind or not will step in.
But the 17A approval was sought for after the filing.
After that, suppose.
Yes.
Makes no difference, makes no significance.
No difference, no difference.
Yes, Praveen Gowda.
In fact, my lord, my arguments would be on 3 folds, my lord. One is my learned friend on, I'm looking into this written submissions, my lord. So one is with, yes, contended with the IPC versus PC Act. And the next is 409 and 405 versus 3D of PC Act, my lord. May I bring it to notice of this honorable court is that as the table I have furnished, my lord, and in the last occasion, your lordship has expressed that whether the 17A permission was taken or not. In the in the last previous occasion order, it has been clearly mentioned that there was a subsequent to obtaining the order without obtaining the sanction. The sanction for prosecution was obtained by the agency. So now the table is before your lordship that where it clearly says that on 19/6/2024, a request with respect to this petition was sent to the government, and subsequently on 1/10/2024, the sanction was granted.
He admits, my lord, 110 is when it was granted.
Yes, that whatever the table and the order is before your lordship, and I cannot go against my own
No,
order.
no, how will he go against the records? He can't submit beyond the records. Yes.
Charge sheet is not still accepted because the prosecutor, the sanction with respect to 19 has been not obtained on the date of filing the charge sheet, my lord.
Yes.
No cognizance has been taken till date.
Yes.
So now, this on the date of charge sheet, even till today, the charge sheet, it has not mentioned about the PC Act with respect to Viraya, my lord. This page number 35 could be looked into. My petition copy, my lord. The lordship could. So there, ನೋಡ್ತು ಅಂದ್ರೆ ಕಾಯ್ದೆಗಳು ಮತ್ತು ಕಾಲಂಗಳು ಅಂತಿದೆ. ಅದರಲ್ಲಿ 120B, 409, 464, 465, 468, 471 ಮಾತ್ರ ಅವ್ರ ಮೇಲೆ ಹೇಳಿರ್ತಕ್ಕಂಥದ್ದು.
ಹೌದು. ಅದಕ್ಕೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇರೋದು.
ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ. Then permission, sanction in the sense, the permission for investigation in the instance stage to file an FIR ಬೇಕಾಗಿರಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನೀವು ಹೇಳ್ತಿರೋದೇನು ಅಂದ್ರೆ offense ಅಲ್ಲಿ ಯಾವುದು PC Act ಇಲ್ಲ, ಅದಕ್ಕೆ prior approval ಬೇಕಾಗಿಲ್ಲ, sanction ಬೇಕಾಗಿಲ್ಲ. That is your submission.
Yes, and I would my lord. I will read the last paragraph of the same page, my lord. ನಿವೇದನೆ ಆರೋಪಿ 2ರ ವಿರುದ್ಧ 13(2) ಭ್ರಷ್ಟಾಚಾರ ಆಗ್ರಹ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ತನಿಖೆ ಮಾಡಲು ಅದೇ ಕಾಯ್ದೆಯ ಕಾಲಂ 17A ಅಡಿ ಈಗಾಗಲೇ ಸರ್ಕಾರದಲ್ಲಿ ಕೋರಿಕೆ ಸಲ್ಲಿಸಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಕಾಲಂ 197 ದಶಾಂಶ ಪ್ರಕಾರ ಮತ್ತು ಕಾಲಂ 19ರ ಭ್ರಷ್ಟಾಚಾರ ನಿಗ್ರಹ ಕಾಯ್ದೆ ಅಡಿ ಅಭಿಯೋಜನ ಮಂಜೂರಾತಿಗಾಗಿ ಕೋರಿಕೆ ಸಲ್ಲಿಸಿರುತ್ತದೆ. ಅದರಂತೆ ತನಿಖೆ ಮುಂದುವರಿಸಿ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಅಭಿಯೋಜನೆ ಮಂಜೂರಾತಿ ಪಡೆದು ಕಾಲಂ 173/8 ದಶಾಂಶ ಪ್ರಕಾರ ಹೆಚ್ಚುವರಿ ದೋಷಾರೋಪಣ ಸಲ್ಲಿಸಲಾಗುತ್ತದೆ ಎಂದು ಪ್ರಾರ್ಥನೆ. So on the date of filing the charge sheet also, there was no PC Act was mentioned with respect to this petitioner, my lord.
ಅಷ್ಟೇ, that's your submission. PC Act ಬೇಕೇ ಆಗಿಲ್ಲ
ಅಲ್ಲ, PC Act ಇರ್ಲಿಲ್ಲ ಅಂತಾನೆ ಅವ್ರ ಮೇಲೆ ಇನ್ವೋಕೆ ಮಾಡಿಲ್ಲ ನಾವು. ಚಾರ್ಜ್ ಶೀಟ್
ಇನ್ವೋಕೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾಗಲ್ಲ, ಅಪ್ರೂವಲ್ ಬೇಕಾಗಲ್ಲ.
ಒಂದು make a submission, my lord, on the date of filing an FIR, my lord, complaint. Here is a case where there the umpteen number of directors have come and gone during the course of the offense. So ಅದರಲ್ಲಿ 2-3 ಜನ ಡೈರೆಕ್ಟರ್ಸ್ ಗಳು ಸಹ ಬಂದು ಹೋಗಿದ್ದಾರೆ. ನಮ್ಗೆ ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಮತ್ತೆ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಸುಮಾರು ಜನ ಅಲ್ಲಿ ಈ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲೂ ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಬಂದು ಇಲ್ಲಿ ಡೆಪ್ಯೂಟ್ ಆಗಿ ಮತ್ತೆ ದೇ ಹ್ಯಾವ್ ಬೀನ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್. Nobody knows. 40. Nobody knows that.
ಆಯ್ತು. ಎಸ್, ನೀವ್ ಯಾರು?
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2.
ಆಲ್ ರೈಟ್. ಎಸ್. ಮುನಿರೆಡ್ಡಿ. ಎಸ್. ಎಸ್, ಪ್ರವೀಣ್ ಗೌಡ್ರು ಹೇಳಿ.
My lord, in fact, on the date of filing the complaint, my lord, to initiate PC Act or to file an FIR, to obtain a sanction, to register a case or to investigate, my lord, there should be a specific names has to be mentioned and their role from the competent authority.
Now unknown persons ಮೇಲೆ ಹಾಕಿದ್ದು.
Unknown persons ಮೇಲೆ ಹಾಕಿದ ಕಾರಣ ಇಷ್ಟೇ ಸ್ವಾಮಿ.
ಸೊ ಯಾರ ಬಗ್ಗೆ ಅಪ್ರೂವಲ್ ತಗೊಳ್ಳೋದು ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ?
ಹೌದು. On that date, my lord, my specific case itself, even in the complaint, it clearly speaks about ಕುತಂತ್ರಿಗಳು ಯಾರು ಅಂತ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತಾನೆ ಸಹ ಅದ್ರಲ್ಲಿ ಹೇಳಿದೆ. ಮತ್ತೆ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಇನ್ ಫ್ಯಾಕ್ಟ್ there are directors has been changed. There are many number of multiple officers have come and gone. ಇವ್ರು ಬಂದೋಗಿದ್ರಲ್ಲಿ ಯಾರು ಏನ್ ಮಾಡಿದ್ರೆ ಅಂತ we never knew about it until unless an inquiry or investigation is inquiry has been done. You won't come to know a specific person who has committed this crime. Now, who has played what role, nobody knows, my lord. So that is the reason that the FIR was filed. It was under the IPC and against the unknown persons. Subsequently, after investigation into the crime, then we have come to know that what is the role and what exactly has transpired and how exactly as crime has taken place. On coming to knowledge of this, with respect to the other accused who have been arraigned subsequently, on coming to knowledge that this petitioner as well as A1 being the public servants, subsequently we have made an application or representation before the sanctioned, the competent authority and we have obtained the sanction. After obtaining the sanction, we have invoked PC Act, my lord. That's the table what I placed before this honorable court.
All right. Yes, so sanction bekagilla.
Sanction ಬೇಕಾಗಿಲ್ಲ.
Approval bekagilla
I
because there's no
filed-
PC Act offense at all. You have given your note. I
Yes,
can
I've
see.
given my note. Lord, there's one other point, Lord. If your
You said
lordship want to
Delhi High Court
look at my
judgment.
load. No, I'm not pressing that point. I'm not
Yes.
pressing that point. Lord, your lordship may just take my written synopsis. Just 1 minute, Lord.
Yes.
13-7 is when I'm arrested.
Arrested.
13-7 is when I am arrested. According to my submission, Lord, there is no 17A approval. Even if we go by their own admitted case, the 17A approval comes after the filing of the charge sheet. My arrest is on 13-7. Charge sheet is filed on 21-8. And 110 is when the 17A approval, according to their case, comes. I have also sought for a declaration that my arrest is illegal. And I also sought for necessary compensation, Lord. Your lordships is all powerful. Your lordships have, there's several judgments of your own lordships where in excess of writ powers, your lordships have granted compensation on a finding that arrest is illegal. Therefore, Lord, that will be my second prayer.
Yes. Heard the learned counsel Angat Kamath appearing for the petitioner. Learned counsel Praveen Gowda representing the first special counsel Praveen Gowda.
Out, Swami.
Public prosecutor.
Learned special public prosecutor Praveen Gowda representing the first respondent. And Muni Reddy appearing for the second respondent. Reserved.
No, there's just one additional indulgence that I need, Lord. The IO is preventing me from leaving the jurisdiction in spite of your lordship's stay. I will have to visit Delhi, Lord. Your lordship may just make some observation that nothing prevents me from traveling to Delhi.
Application. While some application was an order.
May I make one submission, my lord?
Yes.
So leaving the jurisdiction, my lord, in fact, this petitioner was granted bail on the basis of the medical health grounds on the medical ground, my lord, and due to the age factor.
Medical ground alla kottidda. No.
Or health ground mele Swami kottidda.
Lord, once bail is granted, whether it's granted on medical grounds or on merits, it makes no difference.
If you come up with an application, I'll answer. You come up with an application.
And moreover, so I don't know how far I'm fair enough to make this submission, my lord. In fact, the petitioner's son-in-law is in the highest post in the central government. So we have got an apprehension that even otherwise there was a lot of pressure on the investigation officer from XYZ. So where I don't want to mention where he works and on what rank
But I
he
can
is.
make calls to my son-in-law and get him to exert pressure.
No,
But
no,
I don't
no,
have to
no.
go to Delhi.
See, no, I'm just making a submission and bring it to notice of the court. There's
All
nothing
right,
offending,
sir.
my lord.
All right.
Yes.
And my learned friend also has passed a judgment where it has been clearly said in the initial stage of the filing of the petition, my lord, in the first day of arguments. There the CBI, they have on the preliminary inquiry, they have made known of the particular person, what offense they have been made out, and those names were mentioned there. They have not mentioned, they have not taken the sanction there. Even after sir making a name in the complaint, they have not taken the sanction against that.
Yes.
That is what the judgment which says what my learned friend has furnished before this honorable court, my lord.
All right. Yes. Reserved.
I'm obliged.
ಇನ್ನೇನಿದೆ? 230 ಮೂಡ್ ಮಾಡ್ರಿ. 230 ಮೂಡ್ ಮಾಡಿ ಕರೆದು.
Hello.
47. 47 ಇದೆಯಲ್ಲ ಒಂದು ನಿಮಿಷ.
Sorry.
47.
Passed over serial number 6. Notice has to be issued and sentence not have to.
Wait.
Sorry, please.
ಇಲ್ಲ ಸರ್ 230 ಇದು ಒಂದು ಲಿಸ್ಟ್ ಇದೆ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಧಾರವಾಡದ ಅದು ತಗೊಂಡ್ಬಿಡ್ತಾವ ತಗೊಂಡ್ಬಿಡ್ತಾವ
I think probably your lordship has a meeting and
ಟ್ರೂ ಐ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಐ ಕಮ್ ಹಾಫ್ ಅನ್ ಅವರ್ ಲೇಟ್
ಅಲ್ಲ ಇದು ಅವರೊಂದು ಇವತ್ತು
ಅದು ಬಂದು ಹೇಳ್ತು ಇದು ಧಾರವಾಡ ಲಿಸ್ಟ್ 230 ತಗೊಂಡ್ಬಿಡಿ
230 mood list serial number 1 Venkatesham Karvi.
Mother-in-law, daughter-in-law.
Initiate a proceeding under section 12 of the Domestic Violence Act against the my lords.
Mike ತೊಗೊಳ್ಳಿ. Mother-in-law, daughter-in-law ಅಂದ್ರೆ ಏನ್ ಕೇಸ್ ಏನು?
My lords, the respondent number 1 and the one Ankita Asnutkar was the husband and wife.
Ankita?
Ankita. And the respondent number 1, marriage taken place on 23/11/2019. So 19 to 22, my lords, they are stayed in Qatar.
No, why is it before me?
It is by writ petition
withdraw
ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದ್ದೀರಾ?
It's not writ ಮಾಡಿದ್ದೀನಿ. Domestic violence. There is no allegation against him.
ಸರಿ. ಹ್ಮ್.
Domestic violence, till my lord 2019 to 22, they are residing in my lord Qatar.
ಎಲ್ಲಿ?
Qatar.
लगा के लैपटॉप में ले लो
यही अब तो खुल जाएगा अच्छा लैपटॉप में
why am I logged out? See if why am I logged out. तो उनसे कनेक्ट कर
ಧಾರವಾಡ ಲಿಸ್ಟ್ ಎಲ್ಲಿವರೆಗೆ ಬಂದಿದೆ? ಇರ್ಲಿ. 1 minute. Dharwad list ಅಲ್ಲಿ anybody, any matter that can be.
94 in the Dharwad list.
1 minute. Page wise. ಕೊಡಿ madam, list ಕೊಡಿ. Dharwad list. Yes, we are 58 in the 58 to 63.
62 is already covered. Monday.
58 to
62.
62 Monday ಹೋಗಿದ್ಯಾ?
Monday.
All right. Then 63 entry order ಇದೆಯಲ್ಲ?
ಇದೆ sir.
It will go to 14th. Yes.
Please.
66.
Then 64 to 70.
66 ದಲ್ಲಿ Lordship has Lords disposed of connected matter, juvenile justice board. Lords, it may be disposed of in terms of that Lords.
Which is that?
66.
ಆಯ್ತು ನಂಬರ್ ನಾನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ
106641 of 24.
50
106641.
ಅದು
Please,
ಬರ್ಕೊಳ್ಳಿ
please.
ಮೇಡಮ್.
Same.
ಸೇಮ್ ಡಿಸ್ಪೋಸ್ ಅಂತ ಮಾಡಿ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ಆರ್ಡರ್ ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ 71 ಇಂದ 71 to 76.
In 76 matter, my lord, I have served the 2 copies up to the Standing Council of the Jilla Panchayat JDP Belagavi, my lord. CS Patil. His name may be shown to the.
ಅವ್ರು ಹಾಕ್ಲಿಬೇಕಲ್ಲ. Post immediately after service of note 76 ಅಲ್ಲಿ post immediately after service of notice upon the 4th respondent. Please, very aligned. They'll all get adjourned to beyond 3rd.
101 my lords. 101.
ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದೀನ ನಾನು? ಇಲ್ಲಲ್ಲ?
No,
Wait.
rest all.
87.
Don't create chaos. Wait. Yes.
87 further.
1 minute, sir. 79 to 83. ಯಾರಿಲ್ಲಲ್ಲ? Then 85. ಇದೆಲ್ಲ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆ.
My lords are directed to produce charge.
ಇಟ್ಕೊಂಡ್ರಿ. I'll post this on Monday. You keep it with you. Yes.
86, my lord. This is regarding kerosene theft. He is acquitted. Last occasion, government advocate stated that fresh license is issued, but fresh license is not issued, my lord. It is transferred to respondent number 4. 1436 card is running by respondent number 4.
Monday. Please.
Yes.
87, that is, this is MRP, GST and MRP. Tuesday.
MRP.
GST.
Tuesday ಆಗಲ್ಲ. Thursday. ಗೌತಮ್ ಭರದ್ವಾಜ್ ಬರ್ತಾರೆ.
Gautam, Tuesday is coming.
Tuesday I may not sit. So Thursday.
Please.
List on Thursday. Yes. Because it is further hearing, otherwise I would have posted it there. B group karibedi. B group
94, my lord.
80?
94, my lord. My request on Monday, my lord. Covered by judgment from our division bench judgment of this one will call. Assessment and the Income Tax Act initiated after the death of the SSC, not discussed, squarely covered.
Monday, yes.
Please.
Next. ಇನ್ನೆಲ್ಲ ಎಲೆಕ್ಷನ್ ದೇ ಇರೋದು ಮೇಡಮ್. 112 ಚೇತನ್
Please. Regularization, your lordship covered by judgment. Today morning you have lordship pronounced the judgment.
ಅದನ್ನ ತಗೊಳ್ಳಿ ಮಂಡೇ.
Please, Monday.
I have got it web hosted now. We'll see.
Please.
Yes. ಇದು 230 admission ಏನು? Parties to be husband and wife to be
114.
113.
13 now. Private parties. ಅದು private parties ಇದೆ. 114 ದಲ್ಲಿ my lords I moved.
113 further 14 further hearing.
Please, my lords. That I moved for being spoken to my lords that building collapse, the architecture.
Correct. 27th.
27. My lords, may I place on record my lords the charge sheet?
Here. He has moved it. He says his abundant material ಇದೆ ಅಂತ.
I understand, my lords, whatever material they feel they have, if they can share it with us, my lords, we'll be in a position to
Please.
answer it.
Put it.
Because
Please.
ultimately it's an architect, my lords.
Illa.
We'll see.
No, it's all right.
Please, I will.
You give whatever material you want to produce, please give it.
Please.
When do we take it?
Monday, my lords. Tomorrow itself I will give, my lords.
Monday?
Tuesday could it be, my lords?
Tuesday I'm not sitting.
Any other date, my lords? Monday?
Thursday, Friday? Thursday, yes. Next
Please.
Thursday.
Thursday, please.
Be on VC, my lords, but
No problem.
please,
No.
Yes.
keep your update.
Yes. ಅದು ಅಷ್ಟೇ 115 ಅಷ್ಟೇ ಅವತ್ತೇ ಹಾಕಿ. Interim orders will continue. ಮುಗಿತಲ್ಲ ಲಿಸ್ಟ್ ಇದು?
Lords, may I submit?
ಏನನ್ನು
101, my lords. Matter is covered by lordship's judgment with respect to AC's mutation entries are concerned. Muhammad Tahir sir,
Yes.
may I request
Come,
on
next,
tomorrow 2:30, my lords.
ಯಾಕೆ ಕವರ್ಡ್ ಆದ್ರೆ ಯಾರಾದ್ರೂ ಮಾಡ್ತಾರೆ
No, my lords, because last date on the occasion, my lordship was pleased to
We'll
post
see,
it on
we'll see.
2:30.
Yes. ಏನು 5 ಅಲ್ಲ 6 ಕರೆದ್ಬಿಡಿ 5 ಆಮೇಲೆ ತಗೊಂತೀನಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬೇಕು.
Principal bench matters, seal number 6, Monica Patil.
Yes, what is the urgency?
Conviction is rendered under 3 for section. Although 3 years.
ಇದು ಬೇರೆ ಇದೆಯಾ?
Notice may have to be issued, my lords.
Take notice, my lord.
Sentence has been
Monday.
suspended by the trial court for 30 days. That may be continued until lords.
Monday, may I request?
Appear online.
Let him appear online.
No,
I understand. I know the law.
3 years, law 3 years ಇದೆ. Continue ಮಾಡಿ, lords may hear it at leisure.
Conviction on?
Not conviction.
3 years. 120
years.
120 B. Lords may hear it not at leisure. All for the records.
Senior counsel Prabhuling Nawadgi appearing along with Monica Patil, the learned and the learned counsel P. Prasanna Kumar. The appeal is preferred against the conviction of the petitioner for offence punishable under section 120B in special CC 41 of 2012. The sentence that sentence that is imposed upon him is the one punishable under 3 years. In that light, appeal is admitted. The so-and-so sentence is suspended. Petitioner is directed to be enlarged on bail. Arrest ಮಾಡಿದಾರಾ?
ಇಲ್ಲ ಮಾಡಿ.
In the event of arrest. ಈಗ stay
ಆಮೇಲೆ stay
sentence is suspended. Then ಅಷ್ಟೇ ಅಲ್ವಾ?
Subject to deposit of fine amount.
ಎಷ್ಟಿದೆ ಫೈನ್?
ಇಲ್ಲ, fine amount is deposited 5,25,000 and we are seeking stay of that disbursement as a compensation anta there is a separate order. Forfeiture. That order has to be stayed.
In which case? ಕೊಡಿಯದು.
Page 385.
Page
385.
Page 385. Directive, yes.
362. Acting under 357, a suitable compensation required to be opted.
Sentence would stand suspended subject to the condition that the petitioner would deposit the fine amount. A direction to release the fine amount to the victim stands stayed as well. Yes, next. ಇನ್ಯಾವ್ದಿದೆ? ಅಲ್ಲ
40.
5.
Fifth matter.
5 credit.
Hello, may I mention, my lords?
Yes, sir.
I'm very sad to see that my lords are working so hard, my lords. And I am also. But there are 2 or 3 things which I say, my lord. If first is, my lord, there are no pleadings regarding 223.
A couple of minutes back, the additional solicitor general made a submission before a lordship in the other case. That registration of ECIR is only for the purpose of administration and not a crime that has been registered as such. But even in Vijay Madan Lal, what the Supreme Court has said in paragraph 370 and 372, which your lordship has read, it is not an FIR as registered under section 154 of the CRPC. Therefore, you are not entitled for the copies of the first information report. If that is the case, my lord, the complaint that is filed before the court can't be equated to a charge sheet under section 173(2). It would be a complaint under 2D of the old code.
I'll point out that I'm sorry, my learned friend is not correct.
Therefore, what is the procedure that needs to be followed?
Yes,
in the
sir.
question?
Yeah.
Probably, I
Age is,
think I should not request your lordship to hear me and then pass out because it is already 5:15. Your lordship, I know, my lord. Your lordship.
Paragraph number 100 of the same judgment says what we do is investigation. That's not now that your lordship.
I'll point out, Mr. Prasanna, I'll point out as far as.
Vijay Madan Lal, he has done a surgery of it.
Yeah.
Before that, we have
370 and para 370 and 372. My learned friend.
ಎಲ್ಲಿ ಅವ್ರು ಹೋಗ್ಬಿಟ್ರಾ?
ಇಲ್ಲ ಇದಾರೆ.
My lord, may I submit, my lord?
Yes,
now?
sir. Yes, sir.
What
Now,
the
number 1, my lord, on pleadings, there are no pleadings with respect to 223 subsection 2 of the BA.
Serial number 5 ಅಲ್ಲಿ let this ASG finish.
Yes, ma'am.
Yes, sir.
There is no pleadings saying that 223 subsection 2 has been infringed, not a whisper. He has not made a ground in his pleadings.
Yes.
Despite the absence of pleadings, he is making out a case without taking permission to make submission of point which is not pleaded, no ground raised. This is one. Number two, as far as the pleadings are concerned, after I complete the pleadings, I'll come to the other merits. Number two, he has also not pleaded anywhere.
Yes, sir.
He has not pleaded anywhere that the offense of money laundering alleged against him was in the discharge of his duties. He has only said that misappropriation, he was a public servant because he was a minister. He has said that the misappropriation was in the discharge of duties. Misappropriation is a predicate offense. We are not trying here the predicate offense is a PMLA case, my lords. Therefore, there are no pleadings, and the Supreme Court has said that the burden is on the accused to show that he is a public servant and that the act was done in the discharge of his duties. In the present case, there are no pleadings to the effect that the offense of money laundering alleged in the complaint was done in the discharge of his duties, not a whisper. Only whisper. May I only take my lord to the relevant pleadings, my lords, in the writ petition. But kindly come to para 23, my lords. First, my lords, may kindly have a look. Para 21 at page number 23.
Yes, sir.
Petitioner, having served as a minister during the relevant period, indisputably falls within the ambit of public servant under section 21 of the IPC. Requirement sanction in such cases operates not on merely. So he says he's a public servant. Then, my lord, he relies on Bibu Prasad Acharya's case. Bibu Prasad Acharya's case, where I appeared, there was no dispute that the act was done in the discharge of duties. The money laundering was done in the discharge of duties. Then, my lord, what does he say thereafter, my lords? After relies on the Bimbu Prasad Acharya's case, he says, allegation in the complaint pertaining to misappropriation of funds in Karnataka so-and-so Corporation Limited intrinsically relates to actions allegedly undertaken by petitioner in his official capacity as minister. We are not concerned with misappropriation. Misappropriation is a predicate offense. He does nowhere is a whisper in the entire petition does he say that the offense of money laundering, which was alleged to have been committed, was done in the discharge of his duties. So basic requirements which are required to be pleaded are missing as far as this is concerned. Now, the burden is on the accused to show that he is a public servant and that it was done in the discharge of his duties. There's one judgment, but on which I'm relying. That is the Bikamji. Suresh Bikamji Jain's matter, my lord.
Yes, sir.
My learned friend, Mr. Prasanna, will hand over the
Yes.
copies. Para 23 to 25.
Para?
23, my lords.
Yes, sir.
Now, kindly. Mr. Sibbal's contention based on the observation made by this court in Matthew's case, wherein this court of then, my lords, skip a few. If the complaint does not disclose offence, the aforesaid has been made in context of case, then, my lord, kindly slip the last four lines. The legislative mandate engrafted in 197 subsection 1, debarring a court from taking cognizance of an offence except with the previous sanction of the government concerned in a case where the act complained are of alleged to have been committed to public servant in the discharge or with official duty or purporting to be in the discharge of and such public servant is not removed from the office save or by the sanction of the public touches jurisdiction of the court itself. If the prohibition imposed, then, my lords, my lord, by an applicant, then, my lord, kindly have a look at that where it said that the accused, which is that para? Yes, my lord, kindly have a look at para 24, my lords. Further observe that necessity for sanction may reveal itself in the course of para 24 presentum D. In the course of the progress of the case, and it will open to the accused to place the material on record during the course of trial for showing what his duty was and also the acts complained of were so interrelated with his official duties so as to attract the protection afforded under 197 of the Code of Criminal Procedure. This being the position, it would be unreasonable to hold that the accused, even though might have really acted in discharge of his duty for which the complaints have been lodged, yet he will have to wait till the stage of so-and-so, or it is reached. Therefore, he has the right to apply to the court and show that it was done in the discharge of his duties.
One moment. Sir, can we do this? We'll
Yes.
take this on the 27th, next Thursday.
Yes,
Should that be fine?
yes, madam. The next
Because
Thursday.
there are some issues that are to be decided in this. Let the
Yes.
court defer its proceedings till then.
Please.
Yes.
We will not, but at least as far as he is, but with respect to other accused, the court may proceed with the proceedings.
That will, other
Kunte, as
accused,
a-
I will only say.
As
why
far
the
as the
accused.
petitioner is concerned, that's it.
Heard the learned senior
But
counsel.
we will, madam, may it be like this, but we will not proceed as far as he is concerned. Let there be no order. I'll construct
No,
my
I
contempt.
will just direct the court to defer the proceedings insofar as this petitioner is concerned.
But what happens is this, my lord. Once this order is passed, it will be continued, my lord.
No, it's only for a week, sir. 27th, I'm taking it up. Today, because of paucity of time, but for that meeting, I would have sat till 7 and finished it.
In fact, I requested your lordship to take up this matter afterwards. I know.
No, but
Your lordship has got to go for a meeting at 5 o'clock.
that's the only thing. There are all the area officers are called some problem.
If I'm not interfering, serial number 3.
You are interfering. Wait, sir. Yes. Heard the learned senior counsel, Shri C.V. Nagesh, 3 and 5 tag Malbudi. Heard the learned senior counsel, Shri C.V. Nagesh, appearing for the petitioner. The learned senior counsel has projected certain circumstances which, according to him, would not be permissible for the concerned court to proceed with the matter. The twin submissions are with regard to the taking of cognizance under the BNSS. The learned senior counsel would place reliance upon section 223 of the BNSS to contend that while taking cognizance under BNSS, the accused will have to be heard by issuance of a notice. The other circumstance is that petitioner is a public servant and the allegations are made against him have an access to the discharge of official duties and sanction is not obtained prior to the act of the concerned court taking cognizance. The learned additional Solicitor General
But
S.V.
apart from other submissions. which have-
Inter-alia, all right.
Yes.
Inter-alia.
Otherwise.
The inter-matter.
Yes, yes.
Inter-alia. Learned additional Solicitor General, the S.V. Raju would submit that section 531 of the BNSS saves the investigation that is conducted earlier and the concerned court has applied CRPC and taken cognizance of the offense, no fault can be found with the said action. And there is no pleading or there is not even a whisper in the pleading with regard to violation of section 223 in the violation of section 223. The learned
But there is, well, this is the FIR has been, the ECR is lodged prior to the.
that I'm writing.
To for the BNSS.
So the reason for invoking section 531 is that the ECIR is registered on 6/2/2024.
6 June.
6/2024 and the BNSS comes into effect from 1/7/2024. Therefore, 531 would save all the acts that have taken, all the acts that have happened earlier. In reply, the learned senior counsel would submit that the investigation or the trial is not what is questioned here. It is the act of taking of cognizance. Therefore, BNSS ought to have been followed. Ought to have been followed. Therefore, the conundrum requires a resolution. Therefore, the concerned court, qua these petitioners, shall defer its proceedings till the next date of hearing. List on 27th at list on 20. You wanted it 2:30 or
Any date, any time.
2:30 is fine.
2:30. List on
My lords,
27th.
to observe that I've only begun my submissions. I've not even
Completed it.
for the petitioner, but
Allah,
it
it's
may
the
before the
aforesaid.
proceeding
the-
for the petitioner.
Yes, yes. For the petitioners only, yes.
Yes.
So and so the learned further to hear the learned senior counsel for the petitioner and the learned additional Solicitor General further list the matter for further hearing at 2:30 p.m. Yes.
Right.
Great. I believe it's completed very well. I'll leave it.
Yes, sir.
I believe he has completed his submissions, at least as far as this interim
No,
part.
not complete.
Yes, ma'am.
Yes, sir. 47th ಒಳಗೆ.
Grateful. But all matters to be kept on 7th month because the other matters
No,
listed
this
on.
is 27th, sir.
But earlier, item number 3, my lord said
7th,
7th.
I'll keep it on 7th, then further hearing.
7th.
Heard in part 7th,
7th.
7/3/2025. Yes.
Grateful.
Yes, sir.
My lord, the interim order extends to serial number 3 as well, my lords.
ಸರಿ ಆ ಕಳ್ಸಿ ಕೊಟ್ಟಿದ್ದೀನಪ್ಪ ಎರಡು ಸೇರಿ.
ಇದು ಹೋಗ್ಬೋದು.
ಸುಮ್ನೆ ಇದ್ ಬಿಡ್ಬೇಕು. ಎಸ್.
ಕೂಗಿದ್ರೆ ಈಗ
ಅದೆರಡು ಟ್ಯಾಗ್ ಮಾಡಿ.
ಇದು ಮುಂದಕ್ಕೆ ಹೋಗ್ಬೋದು.
ಅದು ಹೋಗುತ್ತೆ ಬಟ್ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಅದೇನ್ ಕೊಡಿ.
ಏನಿಲ್ಲ.
ವೇರ್ ಇಸ್ ಯುವರ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್?
ಅಲ್ಲ ಅವತ್ತೇ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀವಿ.
ಯಾಕೆ ಇವತ್ತು ನಾವು ನೋಡಬಾರ್ದು?
ಅಲ್ಲ ಅಲ್ಲ ನಾನು ಯಾತಕ್ಕೆ ಹೇಳಿದೆ ಅಂತಂದ್ರೆ ಲೇಟ್, ಈಗಾಗಲೇ ಲೇಟ್ ಆಗಿದೆ.
2 minutes, ಎಸ್.
ಲೇಟ್ ಆಗಿದೆ, ಈಗ ಅದನ್ನೆಲ್ಲ ಕೂತ್ಕೊಂಡು ನಾವೇನ್ ಹೇಳೋದು ಅವ್ರು ಹೇಳೋದು.
ಅಲ್ಲ ಈಗ ಹೇಳೋದೇನಿಲ್ಲ, ಬರೀ ಅದು ಏನಿದೆ ಅಂತ.
ಅದು ಹುಲಿ ಅಂದ್ರು ಅದು ಬೆಕ್ಕಿದ್ದಂಗೆ ಕಾಣ್ತಾ ಇದೆ.
ಹೌದಾ? ಇನ್ ದಿ ಕೋರ್ಟ್ ಹಾಲ್ ಇಸ್ ಇಟ್? How have you read it? Oh, transcript.
He is my companion accused. ಬೋರ್ಡಿಂಗ್ ಪಾಸ್ ಹಾಕೊಂಡಿದ್ದೀರಾ?
ಎಲ್ಲ ನೀವು ಮಾತಾಡಿರೋದ?
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ,
ಅದೇ ಹೇಳಿದ್ದು ಬೇಡ.
ಅವರು ಏನ್ ಪೆನ್ ಡ್ರೈವ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿರೋ ಕೆಲವು ಕನ್ವರ್ಸೇಷನ್ ಇದರಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಇದೆ.
ಎಕ್ಸ್ಟ್ರಾ ಇದೆಯಾ?
ಹೌದು, ನಾನು ಅದನ್ನ ಏನಂತ ಮಾರ್ಕ್ ಮಾಡಿ ತೋರಿಸ್ತೀನಿ.
Who is this ಐಶ್ವರ್ಯ ಗೌಡ?
ಅದೇ ಈಗ ಅವರು ಇದ್ರ ಜೊತೆಲಿ ಒಂದು ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಅಫಿಡವಿಟ್ ತಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ?
ಐಶ್ವರ್ಯ ಗೌಡಂದು ಒಂದು ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಐಶ್ವರ್ಯ ರಯ್ಯ
ಗೌಡ
ಟೈಮ್ ಆಯ್ತು ಅಂತ ಗೊತ್ತಾಯ್ತು.
ಐಶ್ವರ್ಯ ಗೌಡಂದು ಒಂದು ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ, ಬಟ್ ಇದಕ್ಕೊಂದು ನಾನು ಕೌಂಟರ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
ಇದು ಯಾರು ಕೊಟ್ಟರು ಅಫಿಡವಿಟ್? ಹೌ ಡಿಡ್ ಐಶ್ವರ್ಯ ಗೌಡ ಫೈಲ್ ಅನ್ ಅಫಿಡವಿಟ್ ಇನ್ ದಿಸ್? ನೀವು ಕೊಟ್ಟಿರೋದಾ?
ಇವ್ರು ಕೊಟ್ಟಿದ್ರು.
ಹೆಂಗೆ?
ಏನದು?
Why affidavit of Aishwarya Gowda? Who is she?
Why the affidavit of Aishwarya Gowda has been filed is for this reason. The conversation was between the earlier, my lord, we were under the impression that some lady and this first accused.
This is the lady, is it?
This is the lady. Therefore, she would say, my lord, yes, I have recorded this in Delhi. And
Oh, it is her affidavit.
these two go together to Delhi. That also.
Accused number 1.
Yes. I have produced the boarding pass, the air ticket and all that.
ಅಲ್ಲ ಇರ್ಲಿ ನೋಡೋಣ ಅದ್ರಲ್ಲಿ ಏನಿದೆ. ಈಗ ಅವರು ಪ್ರಸನ್ನ ಹೇಳ್ದಂಗೆ ಹುಲಿ ಅಂದ್ರು
ಏನ್ ಬೇಕಾಗ್ತಾ ಇದೆ
ಅದ್ ನೋಡೋಣ. ಅದಕ್ಕೆ ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ ಇದ್ರಲ್ಲಿ ಏನಿದೆ. ನಾನು ಒಂದು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಮಾಡೀನಿ, ಅದು ಇದು ಟ್ಯಾಲಿ ಆಗ್ತಿಲ್ಲ.
ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ.
ಅದು ಯಾವ ಪೋರ್ಷನ್ ಅಂತ ನಾ ಮಾರ್ಕ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ. ಯಾಕಂದ್ರೆ ಕೋರ್ಟ್ಗೆ ಒಂದು ಪೆನ್ ಡ್ರೈವ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದೇ ಕಾಪಿ ನನ್ನ ಹತ್ರನೂ ಕೂಡ ಇರೋದು. ನಾನು ತೋರಿಸ್ತೀನಿ, ನಾನು ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟೆ ಫೈಲ್ ಬಿಡ್ತೇನೆ.
ಇವತ್ತು ಹೊತ್ತಾಗಿದೆ ಬಿಡಿ, ಇವತ್ತು ಹೊತ್ತಾಗಿದೆ, ಸುಮ್ಮನೆ.
All right, let it be in the file. Affidavit ಹಾಕಿದ್ದೀರಾ ಇದರದ್ದು?
ನಾ ಪಿಟಿಷನರ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದೆ. That lady's affidavit is also there.
ನಿಮ್ದಲ್ಲಿ?
ಅಲ್ಲಿ ನಾನು ಅದಕ್ಕೆ ಕೌಂಟರ್ ಕೊಟ್ಬಿಟ್ಟು.
ಕೌಂಟರ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್
ಅವ್ರು ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ.
ಸರಿ.
ಅಲ್ಲಿ ನನಗೆ ಐ ಡಿಂಟ್ ನೋ ದಟ್ ದಿಸ್ ಐಶ್ವರ್ಯ ಗೌಡ ವಿಲ್ ಫೈಲ್ ಅಫಿಡವಿಟ್. ಅದು ಈಗ ನಿನ್ನೆ ಕೊಟ್ಟು ಅಲ್ಲ, ಇವ್ರದೇ 6 ಇದೆ. ಐಶ್ವರ್ಯ ಗೌಡಂದು 6 ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. ಅಲಿಗೇಷನ್
ಯಾರ ಮೇಲೆ
ಹೇಳ್ತೇನೆ.
ಅಲ್ಲ,
ಐಶ್ವರ್ಯ ಗೌಡನ ಮೇಲೆ
21 ಕೇಸ್ ಇದೆ.
ಅಲ್ಲ, ನಾ ಹೇಳ್ಬಿಡ್ತೀನಿ ಸರ್.
ಮರ್ಡರ್ ಕೇಸ್
6 ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. 6ರಲ್ಲಿ ಅಲಿಗೇಷನ್ ಏನು ಅಂದ್ರೆ, ಶಿ ಅಂಡ್ ಹರ್ ಫ್ರೆಂಡ್ posing as DK Suresh cheated several people to the extent of 40 crores.
What is the
ನಾನು ಅದನ್ನೇ ಹೇಳೋದು. ವಾಯ್ಸ್ DK Suresh ವಾಯ್ಸ್ ಯೂಸ್ ಮಾಡಿ.
ಇವರು ನಿಮ್ ವಾಯ್ಸ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ
ಅಲ್ಲ, ನಾನು ಅದನ್ನ ಹೇಳಲಿಲ್ಲ. ನೋಡೋಣ ಅದೇನು ಅಂತ ನೋಡೋಣ. ನಾನು ಕೂಡ
subsequent to that only those cases are registered after this.
ನೋಡೋಣ ಅದು ನಾನು ಐ ವಿಲ್ ಆಲ್ಸೋ ಫೈಲ್ ಕೌಂಟರ್. ಅಲ್ಲ, ಸುಮ್ಮನಿರೋದಿಲ್ಲ,
ಬೇಡ ಹೇಳಿ. ಏನು
ಐ ವಿಲ್ ಫೈಲ್ ಅಫಿಡವಿಟ್
ಇರ್ಬೇಕು ಅಂತ ಯಾರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ?
ಅಷ್ಟೇ ಅಲ್ಲ, they sail together.
ಅಲ್ಲ, ಇದು ಕಂಪ್ಯಾನಿಯನ್ಶಿಪ್ ಡೇಂಜರಸ್.
The proverbial says,
ಯಾರು ಕಂಪೇನಿಯನ್ ಅಂತ ನಾವು ಹುಡುಕಬೇಕಾಗಿದೆ.
ಏನ್ರ birds of the same feather flock together ಅಂತ proverbial say. I am not saying for a moment that she is a good lady and all that. For a moment, I am not certifying.
No, we are only concerned about this, not about the character of anybody.
She has recorded it or not.
Not about the character of anybody. It's only we are concerned about this.
We are not concerned with the character or conduct of that person.
ಇದು ಯಾವತ್ತು ಹಾಕೋಣ?
ಒಂದು 3 days ಟೈಮ್ ನನಗೆ ಬೇಕು. ಅಷ್ಟೊಳಗಡೆ
27ಕ್ಕೆ ಹಾಕೋಣ.
ಕೋರ್ಟ್ಗೆ ಯಾವತ್ತು?
ಅಲ್ಲ,
7ಕ್ಕೆ ಹಾಕಲ್ಲ.
ಹೌದು,
I
am sure your lordship has posted any number of cases at the request of the lawyers, at the request of the lawyer. ನಮ್ದು 8 ಅಥವಾ 9ಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ ಪರವಾಗಿಲ್ಲ.
8, 9 ಶನಿವಾರ ಭಾನುವಾರ
10. 10ಕ್ಕೆ ಅಂದ್ರೆ 7ನೇ ತಾರೀಕು ವಿಪರೀತ. As I know, my lord, at the request of the lawyers, my lord, everyone wanted their matter to be listed. ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. ಇನ್ನೇನು 10.
Heard the learned senior counsel C.V. Nagesh, learned senior counsel Sandesh Chowda, learned senior counsel M.S. Shyam Sundar, appearing for the petitioners in all these cases. ಅದು ಯಾವುದೋ ಒಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರಲ್ಲ? Tag this petition along.
ಅಲ್ಲ ಅದ್ರದ್ದು
ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ ಆಗ್ಲೇ. And learned counsel, ನೀವಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ? ವಕಾಲತ್ ಆಗ್ತೀರಾ?
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಅವ್ರು ಕಾಪಿನೂ ಕೊಡ್ತಾ ಇಲ್ಲ. We have been requesting. I have requested him to serve copy.
ಮಲ್ಲವನ ಯಾರದು? learned counsel V.M. Shilwant ಮೆಮೋ ಯಾಕೆ ವಕಾಲತ್ ಹಾಕಿ ರಿಜಿಸ್ಟ್ರಿ ಟು ಡಿಲೀಟ್ ದಿ ನೇಮ್ ಮುಂಚೆ ಇರೋದು ನೋಡ್ಬಿಟ್ಟು ಅದನ್ನ V.M. Shilwant ಹಾಕಿ ಮತ್ತೆ ಈಗ ಬೆಂಗಳೂರಿಗೆ ಹೋದ್ಮೇಲೆ ಮತ್ತೆ ವಕಾಲತ್ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ ನೀವು? Yes, list on 10th March, heard in part, list on 10th.
Give us a copy,
ಯಾವ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ದಾ?
ಇಲ್ಲ, ಈ ಪಿಟಿಷನ್ ಕಾಪಿನೂ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು.
ಪಿಟಿಷನ್
ಅಲ್ಲ ಅದ್ರದ್ದಲ್ಲ, ಮಲ್ಲವನ್
ಕೊಡಿ. ಯಾಕೆ ದಿ ಪೆಟಿಷನರ್ ಸೋನ್ಸ್ ಅದರಲ್ಲಿ ಆ ಮ್ಯಾಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಸಿದಿರ, ಅದನ್ನ ಮಾಡಿಸಿದಿರ ಈಗ? ಕನೆಕ್ಟ್ ಮಾಡಬೇಕು. learned counsel so and so shall furnish complete set of papers upon the learned counsel for the CBI. ಅಲ್ಲಿ ಹರ್ಡ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಇವ್ರದ್ದು ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಆನ್ 10th at 2:30 PM for heard in part, list on 10th for the further hearing on 10th 2:30 PM. Interim order subsisting will continue to the next date of hearing. Yes. Sir. Yeah. It's been a very long day. Interim order ಎಲ್ಲದರಲ್ಲೂ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್, ಯಾವ್ದ್ರಲ್ಲಿದೆ ಎಲ್ಲ ಕಂಟಿನ್ಯೂ.
Kindly, my lord. Serial number 78, my lord.
ಏನ್ ಬೇಕು ಸರ್?
24th, my lord.
ಹ್ಞೂ ಸರ್.
Covered by judgment, my lord.
ಬಿಗ್ ಗ್ರೂಪಾ?
No.
ಬಿಗ್ ಗ್ರೂಪ್ ಏನದು? 78 ಎಲ್ಲ ಕವರ್ಡ್ ಬೈ.
The second round, my lord. This is a service matter covered by judgment, my lord. Second round.
Sandesh Chowda.